Afternoon, everyone, and thank you for joining us for the Medical Board of California's quarterly board meeting pursuant to the provision of Governor Gavin Newsom's Executive Order N29-20, dated March 17, 2020. This meeting is being conducted via WebEx. Public comments will be heard for each agenda item for individuals wishing to do so. In order to be ready for public comment, we ask that you please ensure your comments can be heard clearly by connecting to the audio of this meeting through the proper method. If you are having difficulty hearing the audio of this meeting, it could be because the device you are connecting with has bandwidth limitations. If you have difficulty hearing the audio of this meeting using your device's audio, please click the ellipsis button at the bottom of the WebEx application or the Communicate menu item at the top of the WebEx application, and then select Audio Connection. You will see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you are having audio problems with your device, this will still allow you to participate and hear the audio of the board meeting. Please see the instructions on how to connect link on the last page of the meeting agenda for step-by-step WebEx instructions, including screenshots. President Lawson, you can now start the meeting.
Thank you, Sean, and good afternoon, everyone. I'd like to ask us all to turn our devices to silent and also have everybody on mute so we can all hear each other. Since this meeting is being conducted via WebEx, I will ask that board members and speakers alike please announce your name when you begin speaking, just for clarity of the official record. And all board members should be able to unmute yourself automatically in order to speak during the meeting. And you can also use the, I think, the raise hand feature as well. If you'd like to get my attention, but please place yourself back on mute when you're not speaking to reduce background noise for all participants. Following this online meeting etiquette will ensure the best audio quality for everyone. During each call for comments from board members and speakers, we will ensure that all comments are and can be accommodated and are heard before we proceed with the agenda. Government Code Section 11126.5 does allow a board to remove people who willfully interrupt a meeting and to clear the room or virtual space if order cannot be restored by removing or muting the disruptive people. We do have a designated time on the agenda for public comment, and we'll ask for public comment on each agenda item. This is an official business meeting of the Medical Board of California, and as such, disruptions of the board's business will not be tolerated. The board welcomes public comments on any item on the agenda, and it's the board's intent to ask for public comment prior to taking board action on any agenda item. During each agenda item, the host moderating this WebEx event will activate the Q&A feature of the WebEx and will ask anyone wishing to make a public comment to indicate so by replying yes. The host will then call on individuals who indicated they wish to make public comment by name. When called upon, the host will unmute the microphone of the individual and they will each have 3 minutes to make their public comment. The host will audibly announce when 15 seconds remain to conclude the public comment. And after the 3 minutes have lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. And please do see page 4 of the agenda for WebEx instructions on how to connect from the link on the agenda and additional instructions that may be helpful. I also want to add that we appreciate your patience with us as we operate this WebEx board meeting. I know from managing the past meetings that sometimes the comments can be tough to get into queue, or that it can be difficult to navigate the WebEx platform. So we thank you for and appreciate your patience. With respect to public comments on items not on the agenda, which is agenda item 2, the board has limited the total public comment period for individuals to 40 minutes. Therefore, after 40 minutes, no further comments will be accepted. During public comment on any other agenda item, 20 minutes will be allowed for each public comment period. And then after 20 minutes, no further comments will be accepted. Again, each person will be limited to 3 minutes per agenda item. The board's IT staff will be assisting me with receiving these public comments via WebEx during the meeting. And I'd like to remind all speakers to please stay on topic and please do try to keep your comments to the allotted time period or less. Today's meeting will be run according to the Open Meeting Act as required by law, and we plan to end today's meeting by 5:30 p.m. I would like to now at 2:09 p.m. call the meeting to order and ask that board members unmute their computers. Ms. Caldwell, please call the roll.
Mr. Brooks,
Here.
Ms. Campoverde,
Here.
Dr. Konadev,
Here.
Dr. Hawkins,
Here.
Dr. Kraus,
Present.
Ms. Lawson,
Here.
Ms. Lubiano,
Here.
Dr. Lewis,
Present.
Dr. Mahmood,
Yes.
Mr. Ryu,
Present.
Dr. Thorpe,
Here.
Mr. Watkins,
Present.
Dr. Yip.
Present.
Thank you.
Thank you, Ms. Caldwell. A quorum is present. Board members, please mute your computers. I would like to remind the members again that we will be taking a roll call vote on all action items. Moving now to agenda item 2, public comment on items not on the agenda. And before I call for public comments, I would please ask that individuals making comments not discuss pending complaints, pending license applications, or pending disciplinary actions that may come before the board for a decision. Such discussions are considered ex parte communications, as they could provide information to members that is outside of the record in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and could lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where a decision is still pending. In addition, the board would request the public to address the board as a whole and not individual members. And again, please be aware that public comment during this agenda item should provide information to the board members and is not a discussion between the board members and the public. The only action board members can take is to listen to comments and then decide whether they'd like a future agenda item on the topic. Unfortunately, pursuant to the requirements of law, no other action can be taken on the item at this meeting. Though this may seem at times like board members are not being responsive, following these guidelines is critical to ensure the rules of the Open Meeting Act are followed to avoid compromising the speaker's goals and the board's mission. If you'd like to comment on an item that is on the agenda, please wait until we get to that agenda item. Comments at this time are only for items not on the board's agenda. And please do limit your comments to 3 minutes. I will now ask the host to call for public comments.
Thank you, Ms. Lawson. As Ms. Lawson mentioned, you can either use the Q&A window, or we are also testing out the hand raising feature today. So if you respond back in either the Q&A window or raise your hand, I will do my best to call on you in the order they come, but we will get everyone called upon here. So first up, I have Hannah Ree. Hannah, are you there?
Yes, I am. Thank you. Yes, hello, medical board members. This is Dr. Hannah Ree of Black Patients Matter. We at Black Patients Matter thank you graciously for the opportunity to speak at the inaugural quarterly public stakeholders meeting. However, we feel that it was highly inappropriate to censure the public comments by stopping board members from speaking directly back to members of the public, such as ourselves, Black Patients Matter. As usual, the hanging judge, Lawson, exerted her white privilege to prevent board members from responding directly to stakeholders using the excuse of, I promised everyone we will finish on time, which was her personal decision and not mandated by any California state statute. What we like best about Ms. Lawson is that seeing her on camera allows us to appreciate her facial expressions and disdain for our group. You can observe how when we speak, Lawson purses her lips, pupils dilate, and her voice is curt, mean, white, and privileged. Another federal civil rights lawsuit against such behavior should not be surprising, as the board member Kimberly Kirchmeier was also sued and is no longer on the medical board. So do not worry, her turn is coming soon. Thank you.
Thank you for your public comment. Next up, we have Rosie Arthur's daughter. Rosie, are you there?
Yes. Can
Go
you
ahead.
hear me?
Yes,
Okay.
we can.
Thank you. I've been working with the medical board in some aspect or another since 1994. I've worked in the field of forensic neuropsychology. I've been an expert witness. I've worked in diversion programs in county clinics. I've had cases that became gold standards, etc., and in administrative and social security law. Now, so I have a lot of experience. I've been a researcher for 50 years. And there's a real problem because things are presented on your site that are not accurate. And when you're told that they're not accurate, they are not fixed. In 2015, I informed the administration of the board about such items, and they did nothing to fix it because it apparently supported certain special interest agendas and not the consumer. At least that's all that I can ascertain from what has not happened based on the evidence. Your board, I'm sure, is acting in good faith and only on what you're given, and probably the same thing for the staff. So when you have garbage in, garbage comes out, good data comes in, you get good data that comes out. There's more than one way to look at data depending upon how you prioritize it. So you can take one set of data that says A equals B and then C, and you get other stuff that says A equals Z from the same data, depending on how you define it. So one of the biggest problems that I've encountered in advocating for different people and populations has been there are inferences drawn that certain laws or statutes have been changed when they have not. References have been deleted from your website intentionally and left off. And then these beget other problems. So deviation becomes the norm. And the special interests are supported, and the consumer is the last one and is responsible for everybody else's wrongdoing, effectively.
30 seconds.
Now, okay, BMP code 2241.5, health and safety code 124960961, and BMP 2220.05, number 3, A3, those are not referenced. They're not used. And what that causes is patients with intractable pain, the people who have the least amount,
Please conclude.
the most vulnerable, are being adversely affected. So those need to be restored. Has nothing to do with new guidelines. Those should have been there all along. Thank you.
Thank you for your public comment. Next up, we have individual identified as W. Brannon. W, are you there?
Yes, I am. Thank you. Can you hear me?
Yes, please go ahead.
I was hopeful to see new board members. I hope that this board goes through regular Brown Act training. I would encourage that all votes are done by roll call as required for remote meetings. There was a sub-panel meeting this afternoon that adjourned without a roll call vote. And for those wishing to participate or observe, it's important to know how people vote. You are dealing with an enormous backload of cases. Some people have been waiting 1,549 days. Let me say it again, 1,549 days for a resolution before this board. I don't believe that and this was around 2017, with the current backload that you have, I don't believe that you can responsibly and in a timely manner, especially with the delays of the last year, handle cases currently only meeting 4 times a year. It's rather alarming. You have had a high turnover of staff. I know that some cases have gone through 3 different investigators, and maybe 5 different case managers. And when you have that type of inconsistency with length of delay, the information that finally winds up in your lap is not always clear because the flow of information gets muddled. So I would encourage you, 1, to look at your caseload, your ability to handle all cases in a timely manner with the attention that they deserve, and somehow address this deficiency of staff and the amount of time that it takes to resolve a case. 1,549 days, to me, is not acceptable. Thank you.
Thank you for your public comment. Next up, we have Sandra Perez. Sandra, are you there?
Yeah, thank you. Good afternoon, everybody. My name is Sandra Perez, and I'm from Hesperia in San Bernardino County. I wanted to let you know, again, our daughter Jordan died at the age of 17 as a result of egregious medical negligence. I'm a victim of further trauma exacerbated by this medical board's multiple complaint closures for confirmed medical malpractice by the number of physicians and unlicensed students who I allege contributed to my daughter's death. Over a year after submission, I inquired with Ms. Jones about status, and shortly thereafter, the board closed every single one of my complaints without investigation, without contact, and then they further issued a license for a medical student deemed to have been practicing without a training license during my daughter's hospitalization in 2018. Ms. Shembra confirmed this individual did not hold a training license at that time. In 2019, I reported a lack of supervision, repeated negligence, and potential felony to this board and requested licensing information of these negligent residents. The board refused to provide their malpractice and discipline records on their initial full license application after my daughter's death. The board was dishonest and intentionally failed to disclose required information to me and further continued their support of non-compliant residents practicing without training licensing from 2017 through 2019, all without zero supervision. This is also evidenced in my daughter's medical records, where this individual indicated he called in status reports to licensed physicians, where he represented to me that he was a licensed physician in violation of BPC 2054. Unlicensed residents are not allowed to call in status reports to licensed attendings. I would also like to respond to the board's views that postgraduate training licenses that came into play in 2020, that these holders possess no risk to the public. Under supervision, that may be true. However, there is no oversight or enforcement when it comes to supervision of PTL holders. In our daughter's case, licensed physicians signed statements saying they were present with the medical student when it was absolutely untrue. To add insult to injury, the licensed physician, after never seeing our daughter, said all of our daughter's tests were normal when they weren't. And because of no oversight, an inexperienced and unlicensed medical student sent our daughter home, indicating her condition of portal vein thrombosis was not life-threatening, and of which she died of liver failure 19 days later. The board never investigated this resident and continues to let him practice now with a license that you provided him. This is my main concern for patient safety in regards to the PTL. Thank you for your time.
Thank you for your public comment. Next up, we have Susan Lauren. Susan, are you there?
Yes, hello, good morning. Can you hear me?
Yes, please go ahead.
I should say good afternoon. I'm Susan Lauren. The Hunting Ground is a 2015 documentary about sexual assault on college campuses and the failure to deal with it. It resonates with me deeply, a victim survivor of surgical assault, and I recommend that you watch it. A victim in the movie said, quote, "I told this administrator I was violently raped, and she looks at me and she says, 'Rape is like a football game, Annie. And if you look back on the game, what would you do differently in that situation?' I was expecting resources. I was expecting support. And instead, she gives me this metaphor that rape is football. And it made no sense. And I was like, no, rape is not like football at all. I was just getting blamed and blamed and blamed for this. I thought if I told them, they would take action. But the only action they took was against me. There's a lot of victim blaming with this crime, which has a silencing effect on survivors, end quote. The media reports medical harm in cheap Tijuana clinics, but there's a wall of silence around privately owned ambulatory centers in California that are prime hunting grounds for predators. When people report harm by plastic surgeons in California, they're often threatened, gaslit, and called crazy. No matter what you do, you lose. I was not given consent to make an informed decision. I was scammed and violently assaulted. The medical board and defense lawyers use experts who are corrupt and lie profusely. They claim mitigating circumstances when there are none. My complaint is a clear case of battery. No one would know the truth by reviewing Berger's misleading records and photos or listening to him or his lawyer. The board didn't talk to my doctors and witnesses. I detailed the lies and omissions and was chastised by medical board staff for sending too much information. You tell us to create laws, but there already are laws against invalid medical procedures and assaulting patients, but you ignore them. Short-sightedness, ignorance, and malice drive plastic surgery. For the most part, there are some good aspects to it, but you know what I'm talking about. Medical boards and laws regulating medicine were created long before cosmetic procedures were contemplated, when doctors used to treat illness and disease. Destructive, unethical plastic surgeons with carte blanche fill this state. When there are new accusations, thank you. When there are new accusations and you look up the doctors, you'll likely find a history of harm or lack of respect for life. And I already know about most of these people. They may risk life for no valid medical reason, and this isn't medicine. It's harming, not healing. Picking off seeds one by one does not protect the public from the orchard of harm and death. I've contributed a lot of information. I want to continue to work, but with you. I want to be respected. I want you to overhaul bad policies and procedures in order to protect Californians and therefore protect people around the world. Thank you for your time.
Thank you for your public comment. Next up, we have Kristen Ogden. Kristen, are you there?
Yes, can you hear me?
Yes, we can. Please go ahead.
Thank you. I appreciate the opportunity to comment today. I'm Kristen Ogden, speaking on behalf of Families for Intractable Pain Relief. Our topic is the urgent need to restore access to medical management for intractable pain patients. I want to also thank the acknowledgement given at the public stakeholder meeting in April by some board members to the concerns we raised at that time. We appreciated that. I want to really emphasize today the urgency of the issues we're raising and our commitment to work with the board to find solutions that can bring about the changes that these patients need. We previously have proposed the establishment of a certification and registration program that would allow medical practitioners to treat non-standard pain patients, intractable pain patients, safely and without fear of legal reprisal and with more flexibility than is generally available today. We now want to add a piece to our recommendation, and that is to consider establishing the registration and certification program as something along the lines of a demonstration project. Demonstration projects or pilot projects are common in government, and they are typically established to provide a means for experimentation and innovation to let people try new or unproven methods, and they usually include waivers of restricted policies and rules. We often hear from opioid opponents that there have not been sufficient long-term studies of opioid therapy to prove their safety and value. A demonstration could allow medical management of intractable pain to resume for patients who are suffering from loss of care, and also provide perhaps some information to contribute to filling in that gap between what we know and maybe what we don't know. I believe such a project could be set up and implemented quickly, and that it would not require much in the way of any budget from the medical board. The paramount doctor of intractable pain, Dr. Forrest Tennant, when he was in active practice, subsidized the operation of his clinic from personal funds to keep the price low for his patients. And he is again looking to subsidize clinic operations to treat intractable pain patients. I would think that it would be possible to put something in place. And I think one way that I kind of look at that is that, we have had a national emergency with regard to the COVID-19 virus, and we have emergency authority to allow the rapid establishment of vaccines and approval to deal with an emergency. I would simply stipulate that there is also an emergency with regard to the lack of effective medical pain care for these patients, and something needs to be done right away, and we would like to work with you on that. Thank you very much again for time to speak to you today. I appreciate it.
Thank you for your public comment. Excuse me. Next up, we have Eric Andrews. Eric, are you there? Eric, have unmuted your microphone. Are you there? Your computer noises, so I'll come right back to you. And next up, we have Marion Hollingsworth. Marion, are you there?
Yes, I am. Can you hear me?
Yes, please go ahead.
Thank you. Good afternoon. My name is Marion Hollingsworth, and I'm a patient safety advocate. I would like to suggest that a future meeting address the new approach to enforcement that Executive Director William Prasifka spoke about at the Sunset hearing on May 5th. He described a more effective and efficient enforcement process. There should be an explanation of what exactly this means for consumers. Advocates interpret this effective and efficient approach as a scaling back of investigations in order to save time and money. Since the board's discipline rate is only 3.5% and cases take an average of 3+ years by your own figures, it would be helpful to explain how this new plan would ensure public safety. Also, I'd like to recommend that a future meeting have an agenda item on the early termination of probation. At yesterday's panel hearing, one of the attorneys mentioned that doctors given 3 years probation can petition for early termination in as little as 1 year. Since the board is frequently making stipulated decisions that don't follow the disciplinary guidelines, more doctors are getting as few as 2 or 3 years probation for egregious cases such as childbirth death, sexual misconduct, and surgical gross negligence. You should identify the statute and explain how early termination is in the best interest of public safety. Finally, I would like to make a suggestion regarding panel hearings. At yesterday's panel A hearing, it was surprising that 2 doctors commended a doctor for being brave enough to come before the panel. This was a physician with an admitted alcohol addiction, including a DUI for having a blood alcohol level of 0.29 when he was arrested. He wanted his license back with no more than a reprimand and no biotesting. It was surprising that these 2 panel members were openly praising this doctor's courage to come before the panel. I would expect that you would save your compliments for the privacy of the closed session when you are discussing the discipline. Perhaps you would consider having some restraint at your panels to at least give the impression that you're not biased and are doing your job to protect the public. Thank you.
Thank you for your public comment. And going back to Eric Andrews. Eric, are you there?
Can you hear me?
Yes, we can. Please go ahead.
Sorry about that. I'm packing, I'm moving. It's Eric Andrews from the Patient Safety League. I have nothing to say today. Just kidding. Welcome to Ryan and David on the board. I'm sure you've been briefed that I'm the in-house troublemaker. Really quickly, so you know why I'm here at every meeting. My disabled sister died from gross medical errors, and this board closed the complaint I filed against the doctor who killed her without any investigation whatsoever. I too now suffer from ongoing stomach problems after 2 botched hernia surgeries, and this board closed my complaint against that surgeon in retaliation of me coming to every board meeting and holding them accountable. Ex-Executive Director Kimberly Kirkmeyer recently subpoenaed all of my personal Facebook records, including conversations with patients about their private medical records, without even trying to get them politely and professionally. It was a grotesque and paranoid action on her part. I want to publicly thank Christina Lawson for her awesome job on the last Interested Parties meeting. And real quick, can we consider calling it something else? It kind of sounds like a martini gathering of some college club eggheads. I'd like to suggest Advocate Roundtable, since we should all essentially be advocates for patient safety, even everyone associated with the medical board. I want to bring up yet another issue that happened with Terry Webb at the last meeting when she interrupted and scolded me for talking about a case that was currently under investigation. This goes back to the fact that this board hides consumer complaints from the public. I had no way of knowing that the case I was referring to was already under investigation because you all hide that information, unlike the Contractor State License Board, which posts all complaints. So do you all agree that Carrie was right in shutting me down as rudely as she did and stole away the rest of my time to speak? If the board wasn't hiding this kind of extremely important patient safety information from the public, this would never be an issue. You make such a big deal about not talking about pending cases, yet you all have the ability to hear about high-profile cases on the news. In court, unless a jury is sequestered, they could have heard information about a case they might end up on and are expected to act professionally and disregard any preconceived notions. To think that you ban the public from speaking about pending cases tells me that you are incapable of being open-minded enough like court jurors are. It's clearly not considered ex parte to the contractors board members. It's actually in the law that they list complaints. This policy needs to be rethought, and I am requesting that Carrie Webb be reined in over her overarching sense of authority. She's not always right and has been proven wrong many times by the public. It should be clear to you all why she won't allow the topic of the Public Record Act to be discussed at a meeting, because in the long run, it will publicly shut her down and prove she's been wrong all along. If she were truly correct, she'd allow the discussion to happen so that I would be forced to stop bringing it up. Have any of you bothered to look up the Public Record Act on your own to see which one of us is right? That information is clear and easy to find online, and you'll see that I'm right and she's wrong. Thank you.
Thank you for your public comment. I had one Q&A request, someone asking about the raising the hand feature, and I know on different platforms it's in different places, things like that. So we're going to be taking both Q&A responses and hand raises today. Queue them up in the order that they come in. So please feel free to use whichever is easier for you. Okay, thank you very much. Go ahead, Ms. Lawson.
Thank you. Just to confirm, Sean, we don't have any other public commenters in the queue?
Correct. That was the last request. Yeah.
Great. Thank you. And thank you to all the members of the public who took the time to share your comments with us this afternoon. We're going to move on to agenda item 3, which is approval of the meeting minutes from the February 5th, 2021 quarterly board meeting. Members, please do unmute your computers and let me know if there are any additions or corrections to the February 4th and 5th, 2021 board meeting.
I have an addition.
Dr. Kraus.
On page 37, future agenda items, the 4th agenda item suggested by Ms. Lubiano was also my request. So it would read Ms. Lubiano and Dr. Kraus requested an agenda item on cultural competency.
Great, thank you.
I move to approve the minutes of the February 4th, 5 quarterly board meeting.
Thanks. I have a motion. Yeah, 1 second. I have a motion from Dr. Lewis. Do I have a second for the motion? Then we can continue discussion. Sorry, who's the second from?
Mahmoud.
Okay, motion and a motion from Dr. Lewis and a second from Dr. Mahmoud. And Dr. Hawkins, you've got a comment.
Yeah, just a couple corrections. Agenda item number 6, executive management report. Substitute the word better, BETTR, for bespoke. It should be better. And agenda item 22, presentation on enforcement process. Second page, 3rd paragraph. Ms. Jones reviewed the formal investigation process, saying an investigator at HQIU will request, et cetera, It should read not just will, but will or may. And I'll send this to Ms. Caldwell.
Thank you.
You're welcome.
Any additional discussion or comments or corrections to the minutes?
Yes. On page 38, under future agenda items, should be to be for recruiting.
Sandra.
Is that my line that's having trouble, or is Alejandra's line having trouble?
That's her line. I believe we're all experiencing the same thing.
Okay.
Can you hear me?
Ms. Campaverde? Yeah, could you please repeat what you said? You broke up there a little bit.
Yes. Can you hear me now? Am I clear? I said that on future agenda items, page 38, edited to read, requested a presentation on how medical experts are recruited and trained. So we're added recruited.
Thank you. And then did you have a second part of that comment? Or was that excuse me, second part of that correction? Okay, thank you.
That was all.
Any additional comments, corrections, or additions? All right, seeing none, I'll ask the host to call for public comments again on agenda item 3.
Sorry, I just got that cleared out. Let me open that back up. Anyone wishing to make a public comment, again, you can go ahead and use the Q&A window to just type yes or anything in there, or use the hand raise function, and we'll call on you in the order received. First up here requesting, we have Hannah Ree. Hannah, are you there?
Yes, thank you. This is Hannah Ree, Dr. Ree with Black Patients Matter. I would just like to suggest that I believe that public comments made during the meeting are not entered into the record. I would state that they are probably very relevant to the meetings, and that in some way it would be a benefit to have public comments entered into the record. So perhaps I may need to work with legislators on that. I don't know, but just wanted to state that. Thank you.
Thank you for your public comment. Next up, we have Rosie Arthur. Rosie, are you there?
Hi. Yes. Thank you again. I'd just like to comment on Dr. Ree's comments there about the minutes. The minutes have been woefully lacking for a long time at the board, and one way to fix that is to take the closed captioning text from the webcasts and just simply make a transcript. Then you would have the accurate basis for minutes. So for example, the stakeholders meeting, it has nothing to do with really what happened there. And there's nothing you can go by that. But if we had that transcription, then you could have your minutes very easily. I'm still waiting for the presentation on intractable pain that was supposed to be done in November, that we'd asked for in advance. 2 board members asked for it, and we did not get it. And it's been asked for the February. It did not happen. It was asked for this. It still has not happened. I do not know what the reluctance is when even your own board members ask for presentation on intractable pain.
The comments are for this agenda item, corrections to the minutes.
Okay. All right. The other thing is, well, if you don't have these things in the minutes, then it's hard to correct something that isn't there. Proving a negative is different. So when things are missing from the minutes, that's a problem. The other thing is the right to know law. That's not functioning in bringing up the links to the cease practice orders on your website, so that when the public goes to see a doctor, they don't know that that person has a cease practice order, and these are being hidden from the public. I've notified your webmaster, but you folks need to know that the public can't access that information, that you're making enforcement actions, but the public is not being given them. Thank you.
Thank you for your public comment. At this time, Ms. Lawson, I do not see any additional requests.
Thank you, Sean. Given that we have a motion and a second on the table, members, please do unmute your unmute your computers so that we can have a vote. Are there any further comments or discussion from the board members? All right, Ms. Caldwell, please perform the roll call vote.
Mr. Brooks.
Abstain.
Ms. Campiverde.
Aye.
Dr. Gonadev.
Aye.
Dr. Hawkins.
Yes.
Dr. Kraus.
Yes.
Ms. Lawson.
Yes, excuse me.
Ms. Lubiano.
Yes.
Dr. Lewis.
Aye.
Dr. Mahmood.
Yes.
Mr. Ryu.
Yes.
Dr. Thorpe.
Yes.
Mr. Watkins,
Aye.
Dr. Yip.
Yes.
Thank you.
Thank you. The board meeting minutes from the February 4th and 5th, 2021 board meeting are approved. Members, please do remute your computers, and I will now move on to agenda item 4, the president's report. And it is my honor and privilege this afternoon to introduce our 2 newest board members that we will be swearing in here in a moment, Mr. Ryan Brooks and Mr. David Rue. Mr. Brooks was appointed on February 2nd, 2021 by Governor Newsom, and Mr. Rue was appointed on April 19th, 2021 by the Speaker of the Assembly, Anthony Rendon. Mr. Brooks is currently the Executive Vice President of Government Affairs for Outfront Media, responsible for creating and maintaining governmental and public affairs activities, compliance, community outreach, policy direction, and fundraising activities for the United States. Mr. Brooks' many appointments include an Industry Trade Advisory Committee on Services and Financial Industries under the Obama administration and reappointment under the Trump administration. In 2003, Mr. Brooks was appointed by San Francisco Mayor Willie Brown Jr. to the San Francisco Public Utilities Commission and reappointed by Mayor Gavin Newsom in 2004, serving as the Vice President in 2006 and President in 2007. Mr. Brooks served as the Director of Administrative Services for the City and County of San Francisco under appointment by Mayor Willie Brown Jr. Mr. Brooks was appointed by Governor Schwarzenegger in 2008 to the California Board of Pharmacy and reappointed in 2010 and 2016 by Governor Jerry Brown. Mr. Brooks is a former member of the New Motor Vehicle Board as well as the Little Hoover Commission, and he received his Bachelor of Arts degree in Industrial and Organizational Psychology from San Diego State University. Mr. Rue is a former Los Angeles City Council member, ethics reformer, and community mental health care advocate with decades of experience in the City and County of Los Angeles, as well as in nonprofit management and leadership. He was elected in 2015 to become the first Korean American to serve on the Los Angeles City Council and the first Asian American ever to be in City Council leadership. In 2019, the City Council passed Rue's landmark campaign finance reform bill into law, barring campaign donations from real estate developers with business before the city. And Rue also introduced legislation to expand oversight in City Hall and create stronger checks on potential pay-to-play contributions. Rue also led the city to launch Opportunity LA, Rue's children's savings account program for every child in Los Angeles. Previously, Rue served as the Director of Development and Public Affairs at one of Los Angeles' largest health and mental health care provider, Kedron Acute Psychiatric Hospital and Community Health Center. He also worked as a community activist and dispute resolution mediator in South Central and East LA, neighborhood council member and senior deputy to Los Angeles County Supervisor Yvonne Burke, working on issues of public health, mental health, housing, transportation, immigration, HIV/AIDS, senior services, and foster youth programs. With those introductions, I would like to swear both of you in today. Can you please raise your right hand and repeat after me? I, please state your name. Oops, I think I need to have you unmute yourselves.
Yeah, hi, Ryan Brooks.
Hi, David Rue.
Thank you.
Do you solemnly swear or affirm
Do
Do
solemnly
swear or affirm
that I will support and defend the Constitution of the United States
that I will
that I will support and defend the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies, foreign and domestic,
against all enemies, foreign and domestic,
that I will bear true faith and allegiance
that I will
that I
bear
will
true
faith and allegiance
to the Constitution of the United States and the Constitution of the State of California,
to the Constitution of the United States and the Constitution of the United States, or State of California, excuse me,
that I take this obligation freely
that I take this obligation freely
without any mental reservation or purpose of evasion,
without any reservation or purpose of evasion,
and that I will well and faithfully discharge the duties upon which I am about to enter.
and I will well and faithfully discharge the duties which I'm about to enter.
Well, thank you, Mr. Brooks and Mr. Rue. We are excited to have you on board. We're thrilled to have 2 additional public members. So thank you for your service, and we look forward to working with you and eventually to the opportunity to meet you both in person. Now, just for a very brief president's report from me, because we do have a number of items on our agenda where we're going to go into some detail and depth on some of the particular activities that I've participated in since our last board meeting. Of course, you already heard, and I think most of you were aware, that we did hold a public stakeholder meeting on April 12th. The webcast from that meeting is available on our website at www.mbc.ca.gov in the meeting section under the About Us tab. And we are going to have an update on this meeting later today. Later today, we'll also hear more about our sunset review hearings, which has taken up the bulk of my time as medical board president over the past several months. And so we'll hear about that in more detail later on in the meeting as well. I also participated in a number of meetings with parties. You'll hear about that in a moment from me, as well as in the recent Federation of State Medical Board meeting as the voting delegate on behalf of the California Medical Board. Are there any questions or comments by board members on the president's report or on the swearing in of our 2 new board members? All right, seeing that, I'm going to ask the host to please call for public comments.
Okay, the Q&A window is back up, and if anyone would like to make a public comment, indicate so in there, or again, use the raise your hand function. We'll call on you in the order received. First up, I have Eric Andrus. Eric, go ahead.
Can you hear me?
Yes.
Okay, I just wanted to say real quick that it should be put on the record, even though you talk about all their wonderful attributes of the new board members, that David Ryu is from the Los Angeles area and there's been a lot of scandals in Los Angeles around him, including sexual rape. It was, let me look here. I'm sorry, I just pulled it up. I'm trying to pack still. He was brought up on rape charges and they were dismissed only because the district attorney was unable to proceed within the required time. And he was also charged with taking real estate developer money when he said that he wouldn't when he was running for a city councilman. So this kind of puts him in a tentative place with advocates, because how can we trust that he's going to make the right decisions when disciplining doctors if and I'm saying if he was allegedly taking money from real estate developers, and if he truly raped somebody? How is he going to be dealing with rape charges of a doctor? I think this is very unusual, because, you know, when we put in applications to be on the medical board ourselves, one of the questions is, have you done anything in your past that would embarrass the board or the government? Did anyone not think that rape charges and giving money to real estate developers might be embarrassing to the board or the government? I think you all need to ponder that. Thanks.
Thank you for your public comment. Next up, we have Hannah Ree. Hannah, are you there?
Yes, and so as a Korean American myself from Los Angeles, what we just experienced from Eric Andrus is cultural insensitivity and a little bit of ignorance. So when you are Korean American in Los Angeles and you advocate and you mediate in places like East LA, being accused of things is part of the job. So obviously, Mr. Davis was not found guilty of anything. The charges were dropped. They were never refiled. So I just want to state and remind everyone that for myself, being a Christian, I realized a long time ago that people have faults. I personally am not embarrassed, and I don't believe our local government is embarrassed by having a mediator, advocate, Asian American, trying to mediate East and West LA, being accused of something, not found guilty, and not having charges refiled. You know, look, I'm revoked. I'm not embarrassed. I'm here. I know how the system works. And then also this question of him taking inappropriate money from real estate. who knows the details? I didn't find anything about him being found guilty. So innocent until guilty. I'm not embarrassed. I don't think our government's embarrassed. But anyway, so this is an example of what happens when you're a Korean American trying to be mediator, graduated from UCLA, going into mental health. Obviously, when you're working in mental health, you're not dealing with healthy individuals all the time. So just wanted to point that out, that when we don't work in areas of racial diversity and religious tolerance, these are the kind of comments that we hear from white privilege. Thank you.
Thank you for your public comment. At this time, those are all the requests I see in queue.
Thank you. We'll move on now to agenda item 5, board member communications with interested parties. And I'll ask if the board members have anything to report. Members, please do unmute your computers if you wish to speak.
I do. On
Dr. Kraus.
On April 27th, I received a email from Vanessa Kajina of a lobbying group representing the California Academy of Family Physicians, asking to speak with me regarding their concern on the postgraduate training license. And we subsequently had a call and discussed their concerns regarding moonlighting and leave concerns within the 36-month licensure period. That's it.
Thank you, Dr. Kraus. Any additional?
Madam Chair, Dev Ganadev, as usual, I can tell you that I am actively involved in politically with anything related to healthcare. So I do communicate, but we do not ever talk about the medical board. I keep that separate in my mind.
Thank you. Any other board member communications with interested parties? So I do just have a brief list to report. I did meet with Senator Caballero and other parties that have a particular interest in the Mexico pilot program. I did receive correspondence and communicated with patient advocates about the stakeholder meeting and other other comments, but not anything about discipline or license applications before the board. I spoke with Bridget Grammy from the Center for Public Interest Law, and I did also meet with representatives of the California Academy of Family Physicians, the California Medical Association, the California Primary Care Association, SEIU California, and the American College of Emergency Physicians California chapter regarding their comments about the PTL license, which have also been expressed during the sunset review process. So is there anyone else who has communications with interested parties to report?
Dr. Hawkins, I apologize.
Dr.
You reminded me. I did speak actually twice with Bridget Grammy of the Center for Public Interest Law about our committee, Public Outreach Education Wellness Committee, and discussing how we may work together along with other stakeholders to improve communication responsiveness to the board, to the public.
Thank you, Dr. Hawkins. Any other communications? All right, seeing none, I'll now ask the host to call for public comments.
Okay, again, the Q&A window is open and be looking for those raised hands if you'd like to make a public comment on this agenda item. First up, we have Rosie Arthur's-daughter. Rosie, are you there?
Yes, I am. I'm sorry, I actually had my hand raised for the last one, but the person I assist 24/7 needed my immediate assistance, so I had to step away. But communications with interested parties. It doesn't happen. Back in 2015, I had communications with Kimberly, and supposedly things were supposed to happen. They didn't. I've contacted the board numerous times in between. Oftentimes the communication doesn't go to whom it's directed to, it goes to somebody else, or the answer is non-responsive to the question. And I was promised back in November that I'd be able to speak with the new board president to go over some of the issues, and she's local to where I am. And instead, nothing happens. It's directed to somebody else. And, I can't write volumes and volumes and volumes only to know that nobody is reading it. If there's evidence, and things can be fixed. There's lots of problems, they can be fixed. But if you don't communicate, you know, especially people who are interested enough to keep communicating with you, it's a problem. So I would like to have an opportunity to speak with the board president like I was promised in November, and maybe be able to show how important some of these issues are. And I'm a forensic person. You know, facts are facts. And when these are ignored, like I said, deviation becomes the norm. And other groups end up taking over what is your presence of authority. And when that's capitulated, everybody loses. Anyway, thank you very much.
Any public comment? At this time, I don't see any other requests in the queue.
Thank you, Sean. We will move on now to our next agenda item, which is agenda item 6, executive management reports. Mr. Prasifka.
Madam President, thank you very much. You have the reports. I will go through first to item 6A, which is the administrative summary. Just to begin, to state that the last period since the previous board meeting has been an extremely busy time for the executive. Obviously, we have had a huge amount of work to do in terms of the sunset process, and more about that later. We've had Senate confirmation of 4 members who were successfully confirmed by the Senate Rules Committee just this week. We've had a lot of discussions, and we will speak about that separately, about the postgraduate training license, meetings with the Mexican pilot project, and then, of course, we had everything of business as usual. And so I want to thank my staff for putting in a huge effort. Many board members would have seen communications from them at all hours of the day or night, and it's been a very busy period, but we're happy that we were able to bring a number of projects to a successful conclusion. Moving on in terms of the staffing update, you'll see that we have 8 new employees since 2001. Since February 2001. Again, a very busy time for our administrative unit there. The budget update, again, we have shown some marginal improvement in the budget outlook, particularly compared to what the projections were in January of 2020. This is due because of operational efficiencies as well as increased projections in revenue. So we are trying to operate efficiently and effectively within the envelope of our resources, but this does not obviate the need for a fund for a fee increase, which we believe is long overdue. But there will be a separate presentation tomorrow in relation to the budget. In terms of waivers, you will see there that there have been a number of waivers in relation to the rollout of the coronavirus vaccine. And those are all listed there. In terms of the external communications update, again, we had mention of the public stakeholders meeting, which was held, and in fact, we have a separate item to talk about that. The board published its winter 2021 newsletter. We had lots of communications in relations to the temporary COVID-19 waivers and vaccine eligibility rollout. One item which is of great concern to the board and to the executive, and has been for a long time, is that there are some very sophisticated scams which are being perpetrated by fraudsters who are extorting members of the public purporting to be employees of the medical board. Now, we have worked with all relevant authorities. We have made all notifications, both within the DCA family, as well as internal enforcement agencies. We put a number of communications up on our website and on social media, but these scams continue, and it's a source of concern, and we will remain active in this area. We have the remote working update, and again, the board has fully complied with all state rules in terms of remote working and encouraging that wherever possible. However, at this point, we are looking forward to the time when there will be a rollback on remote working, pending, of course, direction from the governor. And we are working so that when that day comes, that we will be prepared. But we're determined to make the rollback as seamless and as less disruptive as possible to staff. We have information updates about the Information Systems branch. We're redesigning the physician survey to make it much more efficient and make it user-friendly. We're trying to operate more efficiently and effectively by printing your own pocket license cards and notice to consumer signs and QR codes. And we continue to work in terms of the rollout of the Docs portal, which is a very important initiative, which began at the start of COVID and is a drive to make our licensing process as efficient and as seamless and as online as possible. There's updates about our interagency agreement in terms of the authentication of licensees, our website refreshed in terms of ADA compliance, and that we have over 2,000 documents that have been passed for remediation to make it ADA compliant. We've redesigned our complaint form, and we've had further WebEx training for medical board experts. What I would like to do is to move on to item 6B, which relates to enforcement. Again, the expert reviewers program goes to the heart of enforcement, and we have actively been searching for additional experts, expert reviewers. That is all set out. We continue to make progress in terms of the processing of complaints. Again, efficient and effective enforcement is our goal. Well, we're asked, what exactly does that mean? What it means is that each complaint is handled appropriately. We hope that the less serious complaints can be dealt with swiftly and effectively. Where remediation is required, it is initiated at the earliest possible date, and that those cases which are more serious, which have a much greater impact on patient safety, that they are given more resources and more attention, and that we push those to achieve the type of disciplinary action ultimately which will be required. Now, if you look at some of the outturns that have happened, we have, particularly in the last quarter, been meeting and exceeding targets in the times to initiate complaints. They're now down well under 10 days. They're down now to 6 days. We have made a concerted effort to both monitor and identify our complaints, our communications with complainants. We have introduced auditing of that complaint communication. The results of that are set out in page 2 of the memorandum. And frankly, we have identified that we have to do better, that we will develop better templates, more milestones. We will continue to monitor communications with complainants. We will continue to audit that, and we will ensure that we will be meeting and exceeding targets that many of the board members, particularly recently in their confirmation hearings, have said are so important. The executive is dedicated to making the complaint process more user-friendly, more complainant-friendly, to try and be more supportive. And we have a number of initiatives which we can detail on that. They include random audits. They also include, as we have said, we're working to develop a complaint tracking system for those individuals who have filed a complaint so that they can look at online where their complaint is and be notified of various milestones. And we'll continue to undertake other kinds of activities, as we will mention in response to the stakeholders, to the interested parties meeting later on. There's information in the report about the operations of the Complaint Investigative Office, about the DCU unit, the probation unit. The probation unit is now fully staffed and has made great progress there. I would like to draw particular attention to some of the charts which follow the memorandum on enforcement. Chart 6B5 in terms of complaints received. Remember, that's only 3 quarters. There's 1 more quarter to go. So it does indicate that we will be on track to receive in excess of 10,000, perhaps close to 11,000 complaints. Just to make a note, obviously the past year, COVID has been very disruptive. It's been very disruptive to the practice of medicine. There are certain parts of the medical fraternity who have been overworked. And there have been other parts of medicine which have been very much reduced in activity levels. That has got to have that disruption, the transformation of activity levels has to at some point translate into different numbers of complaints and different types of complaints. So we'll have to monitor that very carefully. But we would hope that in the next year, we may see a different number and character of complaints than we have had as the nature of the practice of medicine returns to what it was pre-COVID, we hope. Moving on in terms of the complaint initiation time frame, that shows again that we have made great progress in terms of reducing that timeline, just as well in terms of the average days to initiate complaints in the central complaint unit, that has been reduced as well. I would now like to turn your attention to actually the last document in the enforcement package, which relates to a tracking of the total number of complaints that we have, as well as the aging of complaints. Now, just to refresh the board's recollection, we first brought this pending enforcement caseload summary at the November meeting. And then we had a February meeting, and now we have the meeting in May. So we have 3 sets of numbers. In the most recent period, we show a reduction in the total complaints in the system of pretty much close to 6%. Now, again, the goal here of the executive is not simply to reduce the number of complaints we have in the system. No. The goal is to manage them effectively and efficiently so that less serious complaints are closed efficiently, quickly. Where necessary, remediation is brought in as quickly as possible. It is by doing this that we can devote more time and more resources to the more serious complaints. Where we can reduce the number of complaints, it does show to me that we are achieving results in terms of closing the easy complaints efficiently. We're particularly working on getting the aging profile down. So those cases which have been in the system for a longer period of time. And it shows that under existing resources, we are keeping abreast of the complaint flow, at least in one important metric. Now, if you actually compare the numbers of cases in the system from May to November of last year during those 6 months, it is down approximately 13%. It is the hope that ultimately that will translate into reduced activity levels coming both from the Attorney General's office as well as the HQIU. The most recent figures indicate that the numbers in HQIU are falling. Again, with those activity levels going down, we hope to see some cost savings. I don't need to remind the board of our difficult financial position. We're doing everything that we can to operate within that. And what we're trying to do is to transfer resources from the less serious complaints to the more serious complaints I am grateful to the staff for having made significant progress. We have a lot more progress to make, but I do think that there's some indication that we are on the right track there. Moving on to item 6C, which is licensing, just very quickly there. Again, the staff has been working very hard. People remember that a year ago, with the introduction of the PTL, with the increase in the numbers of complaints with the number of application for licenses up upwards of 70%, there was a backlog that had developed. That backlog has now been dealt with, and the initial review process is back to where it was before the initial surge. A careful reading of the numbers in terms of applications received, initial reviews, and licenses issued indicate that we are maintaining, keeping pace with the number of applications in. So the backlog is not increasing. And so we are in a good place, but we know that there will be an increase in the number of applications, and we will continue to carefully monitor the situation. But just it's important to note that the licensing staff in difficult times has managed to right the ship, and we're issuing licenses at an acceptable rate. Going through the rest of the licensing update, it's been well known that the Federation of State Medical Boards and the National Board of Medical Examiners have announced the discontinuation of work to relaunch a modified Step 2 clinical skills examination, the USMLE Step 2. There have been a number of waivers which have been granted in terms of extending the deadline for the postgraduate training license. We continue to do a lot of work in terms of the rollout of the docs portal, as was mentioned earlier. This is a very important initiative and continues to be used by more and more stakeholders. And the Consumer Information Unit remains extremely active during that time. Myself and the rest of the executive would be happy to answer any questions.
Mr. Prasifka, thank you. Do any board members have questions?
Yeah, Madam Chair, Mr. Prasifka. So I have a couple questions. One is that I'm looking at 6A, page 17 and 18. Is that the amount we can recoup if we get the recoupment of monitoring from probation monitoring costs and all that? I'm just curious. I was always trying to see what is the amount we can recoup from the people we discipline if we approve that, if we go through the legislature to get that approved.
Okay, we're looking at that.
It's page 6A.
Yeah, no, sorry, we've got that.
Yeah, Doctor, I think you were referring to cost recovery. No, this is not the cost recovery. This is the actual money that was collected through the probation monitoring.
Okay. So, but do we know what the actual money we can collect it will be if we go for the recovery?
We don't know. We are going through that process of estimating that right now, but we don't have that number for you today.
Okay, can we have it for the next board meeting, please?
Well, okay, yes, of course, we will continue to work on that. But again, we're talking about projections here.
Yes.
We're talking about projections. And so the best predictor of the future is what's happened in the past. We're looking at various models in terms of how much we have been able to collect in the past when we had that. From my own experience, it's one thing to be awarded costs is entirely separate than to go and collect those costs. And I have always felt that cost recovery was extremely important. As far as I'm aware, we're the only DCA board that does not have cost recovery, but that the real benefit from us in cost recovery is not simply the amount of money that we recover in hand, but the effect that it's going to have on future litigation activities, which is something which is difficult to quantify because it really amounts to savings in terms of litigation costs that we would never incur. But we will do our best to come up with what we think is the most robust model, and then to report on that at the next board meeting.
Yeah, I mean, in the end, any budget in any company is projections. So that's what we want. Because we want to see where we are including cost savings and on your future litigation, because that is an important part. So that way we get an idea, because we approved, the legislature has to approve one of the highest license fee in the country, by the way. So we do have to look at the other areas where we can save. Our expenses are very high, whether it is the AG's office or HQIU. So we got to look at also savings along with increase in, this board approved the increase in license fee. You can't just rely on one. Thank you.
Dr. Hawkins.
Dr. Hawkins, please.
And a little bit out of order here, and I don't have a question for Bill, but he mentioned staff. I don't want to take this opportunity to really commend our staff, as well as others in the help of preparation for sunset hearings for me. And I know the other folks that came at sunset yesterday will say the same, but I did have meetings with governor staff. I had meetings with DCA staff. I had meetings with Gloria Castro. I had meetings with Kathleen Nichols. These are all to help me have a better understanding of how they can help us do a better job that we're entrusted and have to do. With regard to medical board staff, Bill Prasifka, Reggie Varghese, Carrie Webb, Charlene Smith of CCU, and extraordinary above and beyond work from Aaron Bone. Thank you all very much.
Yeah, I would simply like to echo that. It's been a very rewarding time for the staff. I know they may chuckle when I say that, but they've risen to the occasion. But I hope the board member will realize there'll be a couple of us maybe on Monday in the office. You're not going to see us.
I have
Any other
question.
I'm sorry, I didn't see who that was.
Teacher.
Oh, Mr. Watkins, please proceed.
Hi, Bill. My question has to do with enforcement, because it's something that I'm looking at real closely, and I'm concerned as usual about this is showing operational efficiency. And when you talk about being effective and being efficient, then I've got a simple question to ask to show the effectiveness, right? And you were talking about the appropriateness of resolving smaller cases. Do you have any idea how many letters of public reprimand you've written from the beginning of this year till about the end of April? And what has the average has been?
Well, of course, we can give you all that information. That's not the problem.
Well, what I was referring to is that you don't have that right now. And that is actually an enforcement statistic that pertains to the qualitative nature of the decisions that we make. And I'll give you that number. I mean, I can tell you that right now, for this year, from the 1st of this year till the middle of April, we've done 64 public reprimands as per our public records that we publish on the website. And that the average for this period for the last 10 years has been 31. So what I'm concerned is in alignment with what the public, the patient advocates are saying, is that when we hear that you are going to become efficient and effective, does that mean that we will now use a tool as a catch-all, and public reprimand becomes a catch-all tool? And what we throw in that catch-all little basket of us is all kinds of cases that is complex, that has consumer issues in it. You see, my question at the last board meeting also was related to asking questions about the enforcement outcomes, not the process. The process is one thing, and that's all good. You've got that down. But the outcomes, because the outcomes is actually the only thing that the public cares about ultimately, because that affects what happens to these cases. And so that's my concern, that we don't have, again, like real public protection data. We have efficiency data, absolutely, but we're not demonstrating how effective we are in actually adjudicating these cases. So that's my only comment. Thank you.
Okay, if I could just address that on a number of different issues. Well, first of all, it's in terms of the enforcement data and information that we present, I am happy to report that information in whichever form you like. And if we want to have an additional report about the numbers of reprimands, of revocations, of different kinds, I'll be happy to do that. I mean, that's information which we have. And it's very important that, I mean, the executive exists to inform the board, and we'll be happy to do that. Secondly, the indication that we're issuing more public letters of reprimand, I can assure you this does not mean that we are using it in circumstances where we should be using much more, stronger disciplinary tools. They could be in many cases where there would have been no enforcement before. I can assure you that in all cases where we believe a revocation is appropriate, that we are pushing those cases towards revocation. Meeting with the staff, even this week, there were a number of cases which we were discussing in conjunction with the Attorney General's office, which we were pushing to go for revocation. Every single disciplinary tool has its appropriate place. Similarly, every single disciplinary tool may be inadequate in nature of the offense for which we are confronted. For example, there may be, one would hope, a very small number of cases where revocation itself is inadequate. For example, in cases where there is a serious criminal offense and there should be a criminal sanction. So that's always going to be the case. In terms of the public letter of reprimand, you're absolutely right. There may be certain cases where it is inadequate. On the other hand, there may be certain cases which issuing a public letter of reprimand would be an abuse of our prosecutorial discretion if it is not significant enough, where it is not a matter of addressing public harm and requiring a public letter of reprimand. So it goes simply without saying that it is the job of the executive, working with the Attorney General's office, to look at all of these cases on their merits, to develop robust methodologies, to work within the parameters of our existing legal system to drive each one to have the appropriate level of sanction. If I can just give you a couple of examples to illustrate some of the challenges that we face. There was one case, I don't want to get into any details of it, but the investigation went on for page after page after page, and 10, 20 different patients had been interviewed, where to me it was quite clear that what should have happened at a very early stage in the process is that we had enough information to go in for an ISO immediately, thereby protecting the public. So there are all sorts of eventualities that we have to look at. Sometimes you have to cut investigation short, go for an ISO. Other times you reach cases where the investigation is not thorough enough to uncover what we think is the really serious point. It's simply the fact that there is no one metric that captures all of that. I am pleased that we are able to close more files than we receive. But that's not the end of it. absolutely, that is not the end of it. What we need to do is to deal with each case appropriately. And there are many kinds of cases where I can assure you where we are pushing for revocations in cases which have not been pushed that way before. And finally, can I add that the executive considers the input from the board and the board members to be absolutely invaluable. The outturns of the panel is extremely important information for us in terms of how we do our job. It is very important to have robust discussions on these cases. And finally, if I can just note, I watched with extreme interest the confirmation hearings of 4 of our members this week, of 3 new members, and we take their comments and their desire for more interaction with complainants, for greater transparency, extremely seriously. The executive has no agenda other than to follow the direction of the board and to protect the public.
Mr. Prescott, Brian Brooks. First, I want to say, thank you for all your hard work you do and the work that the team does. I think there's 2 parts. There's one part about getting the statistics, the numbers, like the numbers of reprimands, which is great. It's how you use that data that really, makes sense. So my question is, are we seeing trends? If you're issuing more letters of reprimand, is there a trend going on? And the reason I ask the question is sometimes we see trends for various reasons. We could address those before it happens to prevent the number of letters that go out or the number of stipulations that go out.
I can answer that very clearly. The trend that has been up to now for this period that I'm saying first of the year to about the tax date, the average for that has been 31 reprimands for the last, since 2008. Well, so let's say for the last decade. And in the last period, just for 2021, 2021, it rose to 64. So it broke the trend. So on a graph, it would look like this, and then suddenly it spikes. So my question was that since it spiked, I just want to know whether that spike is because unconscious policy is in a policy is in place that has an undesired effect, that suddenly we're writing these public reprimands, warranted or not. It's at twice the rate since last year. And that's my concern. I'm watching enforcement data. And if there's any break in the trend, then I point it out. This is one thing that I picked up. Nothing else. Thank you.
Thank you for the question. Yeah, because I look at statistics and numbers all the time, and the numbers on a piece of paper, they're just numbers. But if you kind of dig down to the tabs of what they actually mean, we can that's kind of the first step of preventing an incident from happening in the first place. If there is a trend because the doctors are being overworked and having good record keeping, we should identify that and figure out how to solve it before it becomes a problem, which would hopefully reduce our overall enforcement, activities within the department that would help save money and cost. So that was kind of the basis of my question.
Yeah, and I'm just going to conclude with this. My concern is the board is under pressure with money. The staff is under pressure because we are under a big caseload. And suddenly, I see the spike in public reprimands. I don't want to come across a situation where these public reprimands that are issued are on some level just becoming the catch-all basket that we throw stuff in. I don't want to, I am trying to just be very vigilant about making sure that these are not a method that we use because we don't want to address it. And I'm not saying that is happening here. I'm just saying when there is a doubling in 1 year of a trend of public reprimands, and the average has been pretty much a flat line for 10 years, then you have to ask that question. It's just a simple vigilancy that you have to maintain. And I mean, that's it.
Thank you, Mr.
Sorry,
Watkins.
Ms. Lawson, can I address Mr. Brooks' issue there?
Please.
One thing I think you've raised a very important point, which I think is sometimes missed, is that if you're looking at the success of a regulatory system, of course, the disciplinary outturns are very important. I'm not suggesting that they are not, but they tell a very incomplete story. What you have to look at what else is being done. If you had a jurisdiction in which you had, let's say, the highest rate of discipline that was going on, you'd have to ask some very serious questions. How robust are their licensing mechanisms? How much, I mean, what about even looking at the entry levels into medical school, how people are chosen to become doctors? You have to look at CME. What changes can be made to CME so that you can prevent these problems from developing? It's the entire area of upstream regulation. If you have a very successful regulatory system, you would expect there to be fewer disciplinary actions because standards were maintained and standards were being developed. The problem with this whole area is that if you just look at the numbers alone, the best medical boards and the worst medical boards could look very similar because they would have relatively few disciplinary actions. And that's because the worst boards are not effective at imposing discipline, which is a real problem. But the best boards in a robust regulatory system where you have developed a culture of open disclosure and continuous improvement will generate less need for discipline. So it's our job to do everything we can within the complete regulatory system to make it work better and to ensure that when those cases do come to us, each one achieves the appropriate amount of attention and the appropriate discipline. And that's how we can get there. But I agree wholeheartedly, the numbers alone do not tell that story.
Mr. Prasifka, I have another question. During our confirmation in the Senate and also at the BNP hearings, we heard that how are we closing the complaint? That is, if a complainant sends a letter or calls the board, how are we keeping him in the loop and informing them? I was a little concerned that they're not getting information and they're somewhat in the dark, so that was important for me. So if you can explain, if we're making some changes, what we're doing.
Yes, as we have set out in the report, there are a number of changes that we are looking to implement. The first thing is that we're looking to develop an online tracking system with our IT experts so that complainants can look at it externally and to see where various milestones have been met. Secondly, what we have done even in the past period is to begin to audit communications we have with complainants. The goal is to keep complainants informed to the extent that we are able to under the Act. Again, the Act provides that the complaint process is a confidential process. They're not entitled to, for example, expert reports and to confidential patient records that obviously have nothing to do with them. So within those parameters, we are developing protocols and procedures. We are going to continuously monitor how that is implemented, and we have acknowledged that we have some ways to go. We have to give them more communications. It has to be more meaningful communications. But at the end of the day, we operate in certain constraints because the Act provides the complaint process is a confidential process. So we're looking to continue to monitor it, develop more grounds for communications, to set out certain milestones, have more regular communications to monitor that, and we look forward to reporting to you about that at each meeting.
Any additional questions or comments from members? Mr. Rue?
No, just to finish up, thanks, but in the end, though, I think if I am the patient who sent a complaint about the doctor, I want to know that whatever you did, I don't want to be left in the dark, and that was very concerning to me when the people complained that they were in the dark. So please let us know by next meeting what are the changes and how we are doing.
That's fine, absolutely.
Mr. Rue, I saw your hand up.
Thank you, Madam Chair. Very interesting discussion. I wanted to follow up, piggyback on Mr. Brooks's question about trends. You know, on 6B, page 10, where you have the average HQIU investigation days by case type, it seems like the days all fluctuate, but for the unlicensed activity, there's been a consistent trend ever since 2016. Can you kind of comment on that?
Well, I guess for board members who have been looking at these numbers for a long time, we have seen the time frame for investigations to be going continually upward for many areas of investigations. And one thing which we have been able to do, and which we have just completed, is to put in place a new memorandum of understanding between ourselves and HQIU, which provides for much more constructive and active engagement between the executive and the HQIU. It's not simply a matter that the file goes out for investigation and then it comes back to us a year later, 18 months later. We're going to track various milestones. We are particularly concerned about the aging of cases. And we have a very important reason for that. We deal with the 3-year statute of limitations within which we have to file an accusation. And in too many cases, we've been running up to that 3-year limit. And once that limit is passed, we have to then go with whatever we have. That's why aging is particularly important. So what we are going to be doing is using the MOU to more actively monitor these cases, and particularly the ones where there's the most aging are the ones that we have to be concerned about. But that is a source of concern for us.
So there's no, because I've noticed all the categories go up and down and fluctuate, but the unlicensed activity has been a upward trend steadily. And it's not just this year, it's just, for the last 6 years. Yeah. So I was wondering, is there something in particular about unlicensed activity, or it just happens to be?
Okay, well, no, I'll tell you what, we will have to get back to you on that. Okay, I promise we'll get back to you on that.
Mr. Prasifka, just to follow up on Mr. Rue's question too, because I think, this is an area that has been of great interest to us, meaning the board and then meaning the board leadership as we prepared for the Sunset Review hearings and prepared for the conversations we had with the committees in the legislature. And one thing, as we prepared for some of those hearings that became clear to me behind the scenes is that when we look at averages, there's data in those averages that is really skewing a number. So for example, if there's a case where a district attorney in a particular jurisdiction has reached an agreement with the AG's office that we will not pursue an enforcement case while that criminal investigation and prosecution is underway, that can greatly lengthen our cases, but that doesn't show up in this data in a way that is helpful for the board members to understand, for example. And I wonder if we can just figure out, and I know that staff is working on a table that actually includes some of that information so when something gets put on hold, it doesn't continue to, for example, count against that average number, right? And really skew it so that it looks like there's a trend occurring that may or may not be. I don't know if that's the case in that unlicensed activity. category that Mr. Rue was just asking about, but I remember that coming up in our conversations about these averages and how we present this data. So I would just continue. I mean, data is great, right?
Yeah.
So long as it's providing you with meaningful information that is then actionable in a meaningful way. And so to the extent we can continue to improve these data streams we're receiving, so we know what's really going on, so that when there's a question about, well, why aren't you immediately jumping on that doctor with an enforcement process, perhaps there is that reason. Perhaps it's because there's multiple agencies involved, what have you. But so that's my comment. Are there any other comments or questions from board members about the executive management report?
I just want to comment on your last
Please.
comment, Christina. When you have outliers, you can pull it out of the data set and keep it and say this is the outliers if you want to maintain the integrity of the trend set on the data. This is all just little things that can be noted on a presentation like that, on a graph. And so the deal is, if you want to make data consistent, then you can set a standard where you say, okay, I'm going to remove the outlines and explain it in a note. That's just to help with this process.
Yeah, I agree with you completely.
Yes, Ms. Lawson.
Dr. Thorpe?
Well, Bill, I think that number one, we do have such, we really do appreciate all the work that you and Reggie and the staff are doing in all these areas. But it is one of those things where, repeatedly the delays in getting activity completed on a case is constantly brought up by our, by the legislature and by our friends in the public sector as well, and our patient advocate sectors. And I would just point out under item 6B on page 8, the days to complete investigations in the complaint investigations office, for some reason, it was actually looking pretty good in 1920, and now in 2021, quarter 1, quarter 2, quarter 3, it's progressively increased. So we were at less than 6 months in closing cases in 1920. Now we're back almost, we're approaching a year now. And so it's not that I want to necessarily hound you about that particular statistic, but it's just those kind of things that continue to concern us about making sure that we are working, that I think what TJ was saying earlier, that we just want to make sure that the letters of reprimand, okay, maybe we are seeing more, but let's at least make sure that they're appropriate and that we're not just giving letters of reprimand just to get them off the books,
Yeah, well, okay, on that point, I can assure you there. And also, I've just been given a chart with numbers about the letters of reprimand, and I will be asking someone to add these up for us, and I'll be able to have those distributed very shortly. In relation to the particular chart that you just mentioned, average days to complete investigations in Complaint Investigations Office, that's 6B8. First of all, Dr. Thorpe, I do not consider this hounding. I consider this to be a very important part of your role. Number two, the hounding is not limited to you. It's also, I am involved in a certain hounding of staff, and I asked them specifically to look into that. And what I was told, as with everything, there are a number of factors that account for the increased timeline in this area. First of all, we've had an employee who had to be reassigned to engage in tracing in terms of our obligations under DCA. Many of these pending cases date from 2018 and 2019 and involved subpoena enforcement actions, which necessarily have resulted in greater delays. Also, I think thirdly, what we're finding is that, frankly, we're taking on internally some more difficult cases than we had done before. And so this attributes partially to the reason for the increased timeframes. It is our goal to get the timelines down doing everything reasonable while still maintaining the integrity of the public enforcement function and still devoting resources. And there will be cases, frankly, which require more time and more resources for public protection. And so we are doing that, but we will be focused on this area. We've identified some reasons for it, and we hope to see some improvement by the next board meeting.
Additional, please, Dr. Yip.
Yeah, one last comment about the PLR. I actually had a conversation with Jones way back last year when we were expert training on Melinda. I think it's a good idea for Bill and Jenna to have a report on the number of PLR that was vetted by the executive alone and those that go to the board, and also the severity or the background of those cases and the criteria that would help the board members to understand, why the number increased. Is it because we try to save costs or actually because we're more efficient? And also what are the criteria that the staff can use to give out PLR with the board approval? Thank you. I think Jen has those numbers.
Yes. Okay, yes, we can do that.
Thank you, Dr. Yip. Ms. Campaverde.
Yes, while we're on the topic of useful data sets for our oversight process, I know Mr. Prasifka and I have already talked about this, but to speak about it with the full board about regular reporting on the criteria we use to close cases, including staff interactions and how and why those cases are closed.
Thank you. Additional comments, questions from the board members? Ms. Lubiano.
Yes, thank you. Just to dig into a little bit more from Dr. Dev's comment about the system that we're putting into place to inform complainants of the status of their case. I know it's top of mind for complainants as well as us board members, and also the legislature, which did ask about it, as you may saw in yesterday's hearing. And so my understanding, just for clarity, is that we're working on it. I hear that we're talking to our our tech experts to see what existing technologies perhaps we can leverage. So I just want to, one, I'd like to understand if we have a tighter timeline as to when that might be in place, and then also I'd like to understand how we're thinking about it in terms of. I see, okay, we're trying to perhaps leverage what we have, but if not, is a backup, to build a new one or, get a third party that can build one for us. And I understand, obviously, that costs money. So just wanted some answers there, please.
Well, first of all, I can assure you that this is a matter that has the highest priority. When I report in terms of the outturn from the public interest meeting, I was prepared to speak about it there, but just to say what we are attempting to do is to roll something out as quickly as possible to identify a number of milestones for which we can build into the existing system so that in a relatively user-friendly way, complainants can access where their complaint is at various parts of the process. Obviously, we need to do a legal review to ensure that the information that we are disseminating is consistent with the confidentiality provisions of the Act, and also that we're able to do it within a technical point of view. At this point, the priority is to develop whatever we can as quickly as possible and to roll it out as quickly as possible. If that is deemed to be inadequate and doesn't meet the needs or expectations, well, then at that point, we may need a more comprehensive or radical solution. So that's where we are right now.
Well, can I speak, Madam President?
I'm sorry, I didn't hear. There's two. Dr.
Mahmood. Yeah. So this concern about the timely investigation and conclusion has been, I've been on the board for 2 years, and even before that, I've been listening. And every meeting, every time, what we say is, we are going to try to improve, we're going to try to get better. Is there a possible way that we can set some standards? Okay, next 6 months, we're going to bring it down to this level. And then in a year, we're going to bring it to this level so that we follow those protocols or whatever the standard we set up, number one. Number two, there must be some cases which are very complicated and intrigued and they need a lot of, we put those cases aside and put an explanation on those cases. Okay, this is the reason these cases are taking so long. Let's not put them into the all standard cases and have like duration of investigation so long, so that we see average like 98% of the cases are timely investigated, timely prosecuted, timely whatever the conclusion come. And we put all the progress on the website, and especially board members are given the timely information like every month or every 2 months or every meeting. Okay, this case is long, that is why it's taking so long. Because when somebody come in and say, okay, this case has been going on for 3 years, we are speechless. And honestly, we should be speechless because public has concerns. Public really want, and we are working here for public. And we really want to answer them and just give them an answer. Okay, it's a complicated case. We need to know all the details, why it's taking so long, and where is the problem. Maybe we can intervene and we can cut down that time so that it doesn't affect everybody. And we should have, on a timely manner, cut down our target, where we should stand and what should be the time limit.
Okay, well, first of all, I completely agree with the need to give adequate reporting data. If I could refer you to, again, the last data in the enforcement package, item 6B13, the pending enforcement caseload summary, that tells me two important metrics. One, what are the total number of cases in the system as to how they compared before? And it also gives you the case aging, which is very important. Now, what we need to do, and this was always the intention, is that as we had more data coming in this format, then we can do a more effective trend analysis. And so we would hope that in future reports, now that we'll have a fourth one coming out, so we have 3 sets of trends, we can draw some conclusions over the aging of these cases and where they are at various portions of the project. That's one way that we can deal with this. We are always looking for newer and better ways of communicating the information to the board and to the public. And certainly we have also, I mean, the reason you have this data is that you can identify the cases, identify the outliers, and devote additional resources to dealing with those. So that's what we're doing. We'll see how that looks, if that addresses concerns, and this is something which we can report at every board meeting.
Can I just ask a quick question, Bill? You and the staff are building out a model that's effective and efficient, right? And that's going to include these timelines and everything. So before we build this, redesign a system, we do an audit of the system, and we establish, hey, what are the kinks in the system? Where does the system break down? If you could give us just a 3-point maybe, or maybe even more extensive, and give us an idea about what those things are. What have you found, and what is the solutions that we could expect? Because if you say effective and efficient, we become concerned, or I'm concerned. I'm going to speak for myself. So if you explain to me, you bring me on board and tell me kind of what your process will look like.
Okay, well, I guess I'm sorry for using the words effective, efficient. I studied economics when I was in university, and I guess I contaminated myself. But no, all kidding aside, no, it's our job, absolutely, to explain these things as simply as we possibly can. But I can assure you that the executive is not lost in the numbers. Maybe what we as the executive need to do is to better explain how in so many different ways we are pushing and a public enforcement agenda. All the numbers of cases in which we are working very strongly with the Attorney General's office, who is a very effective and dedicated partner to achieve stronger disciplinary outcomes. I mean, one area we're working very hard with is in the area of financial fraud, which I have spoken about. We're not talking about technical violations here. We're talking about physicians who unfortunately have defrauded the public health system of tens of thousands, hundreds of thousands, and in some cases millions of dollars. These are very serious matters, and to me it's not consistent with the practice of medicine. And we need to treat these things with the highest degree of seriousness and with the most serious sanctions. And we're seeing that we are making progress here, as is the case with other areas. And that's all part of the process.
Additional comments or questions from board members? All right, seeing none, I'm going to ask the host to please call for public comments on the executive management reports.
The Q&A window is open, and anyone who would like to raise their hand can make a public comment as well. First up I see here is Sandra Perez. Sandra, are you there?
Yes,
Please go ahead.
a statement made by Ms. Lawson about the outliers in the licensed, unlicensed category, that you talked about some of these maybe cases that you guys can't do anything with because there's a parallel criminal investigation. I beg to differ. In our case, when we submitted a complaint with potential felony ramifications, the board dismissed it in less than 30 days. Second to that, I would like to say that as you guys look and move towards enforcement and putting information online, one, it has to be meaningful information to the public. It can't just be information that has no bearing on what the public is asking for. Second, to Dr. Mahmood's point, it has to have measurable steps to it. You guys can't sit here and repeatedly say that you're going to take action, and here we are months later, and still no action has been taken. Measurements have to be put in place for you guys to be showing progress. And that's one of the issues that is also not happening. Thank you.
Thank you for your public comment. Next up, we have Kristen Ogden. Kristen, are you there?
Yes, I am. Thank you. I would just like to comment briefly about the expert reviewer program and concerns that I have about that program in the context specifically of my main topic, which is the need to restore access to special care for intractable pain patients. And we're talking about those patients who have severe, constant, life-altering intractable pain. That pain does really exist, but because of a number of factors happening in our country, I think there are fewer and fewer doctors practicing who understand how to treat these patients. And it would make sense to me that there are not too many, perhaps, of your pain care, pain medicine related expert reviewers that fully understand the kinds of care necessary to provide effective medical management of these patients. And we have many, many patients who have lost effective care that helped them for years or decades. So I would simply say in regard to that program, if there is a way to specifically seek out doctors, I'm not saying that your reviewers may not be perfectly well qualified to review pain care for the more common chronic pain ailments, but I find it rather unlikely that you have reviewers who, very many of them, would be expert in fair and understanding what they might be looking at in terms of a doctor trying to treat intractable pain that turns into a syndrome with measurable cardiovascular and endocrine dysfunction and leads to premature death. It's a whole different ballgame, and I would like to suggest to you that you try to find a way to be more selective, perhaps, in choosing folks to participate as expert reviewers for intractable pain, and perhaps echoing an earlier comment about the need for training on intractable pain, that it would be beneficial to board members, but also especially to expert reviewers if they're not quite up to date on that, and to the investigators who are looking into the doctors about whom you may have a concern. I think that we have lost way too many doctors who have the expertise to effectively treat people with the intractable pain type syndrome, such as my husband and a number of other patients I represent in my group. And that's an area that has led me to have great concerns. I have observed just in reading, I will not mention any specific cases. I don't know the details of cases, but there have been certain cases where it certainly, there was an appearance that doctors who were being challenged or questioned may have simply been providing what they know to be the kind of life-saving care that patients like this really require. Thank you.
Thank you for your public comment. Next up, we have Marion Hollingsworth. Marion, are you there?
Yes, I am. Can you hear me?
Yes, please go ahead.
All right, thank you. Good afternoon. My name is Marion Hollingsworth. I don't know if Mr. Prasifka can answer questions, but I was wondering about the average and median length of time for the processing of a complaint, which has been increasing over the past 5 years. I know you just addressed this somewhat, but this has been an ongoing issue. On page 6B, page 12, you have a median time of 1,209 days and an average time frame of 1,128 days. This is more than 3 years. Other states have limits for the number of days the board can investigate a case. Washington, for example, there is a 5.5-month time period, or about 180 days. How can California's time frame be lowered without having to get the legislature to impose a law? This long time frame is discouraging to consumers who have filed a complaint, and it keeps potentially dangerous doctors in practice while you determine if there should be a discipline. Also, regarding enforcement and following up on Mr. Watkins' comment on public reprimands, there has been an increase in the use of public reprimands for egregious cases such as preventable deaths. This includes childbirth deaths and overdoses. There are at least 3 such decisions recently where a baby died in childbirth years ago, and the doctor just got a reprimand. This includes a 2013 case where a young mother bled to death after a C-section and a VBAC death where the doctor failed to monitor the baby and inform the emergency surgical staff. The Death Certificate Project also had a number of reprimands. You had one overdose death case that took 4 years and 4 months to resolve. This was the Alex Smith case. By giving a reprimand, there is no summary on the doctor's profile on briefs to warn patients of a potentially dangerous doctor. And the doctor learns that even a preventable death is not a serious offense. If a doctor is found responsible for a preventable death, there should be more accountability. It's like a bank robber shooting a guard and being allowed to plead down to running a red light on his way out of town. Using reprimands in death cases should not be the norm. Right now, it is common, or at least not uncommon. How is this in the interest of public safety? Thank you.
Thank you for your public comment. Next up, we have Michelle Montserrat Ramos. Michelle, are you there?
Yes, I am. Good afternoon, board members. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. Yes, reaching out to the families is critical, and therefore you need to send letters to the families letting them know an update on their complaints. Currently, the families are not receiving letters. I have families that may get an initial letter, but that is it. They are not receiving a letter when the case is under investigation. They are not receiving a letter if an accusation is filed in relation to their complaint. They are literally hearing the accusation news from members of the public who are checking the physician profile and or are signed up for email updates. It is not acceptable that grieving families do not get notified first and have to hear from random members of the public or from me about their complaint. This internal communications audit team needs to expand beyond the central complaint unit and needs to include all areas of enforcement now. Families should have the right to hear that their complaint has reached a critical milestone directly from the board. Thank you.
Thank you for your public comment. Next up, we have Eric Andrews. Eric, are you there?
I'm here.
Please go ahead.
This is Mr. White Privilege, Eric Andrews. To be clear, I love that David is representing Koreans on the board. That was Miss Crazy Hannah talking. I hope you all tuned in to the Sunset Review and saw how Bill and Jenna both purposely misled the Sunset Committee. We have video captures of it on YouTube. Bill, what do you mean you're happy to provide those reports? Why aren't you doing it already? We've been complaining about these issues for decades. Sorry, I'm having trouble reading my notes. I'm beginning to question abilities. You're just now, it seems like you're just now towing the corporate line in the things that you say. TJ makes a great point. Dry numbers don't equate to how effective your disciplines are. We are chronicling cases over the years of you letting bad doctors off off the case easily, only for them to harm again and harming numbers of patients again. You knew about Dr. Popkin for years and did nothing until he sexual assaulted a number of more victims, and one of those victims went to the press. It wasn't until they went to the press that you actually did something about him. So we simply don't believe your rhetoric, Bill. You tried to pull the wool over the legislators' eyes, and you're trying to bamboozle your board now and the public. Remember, Ron Lewis said, you can't hang everybody, and you clearly don't. Why doesn't someone pull my 2 complaints, the 2 complaints that were closed without investigation, and use them as a case study? Find out why those 2 complaints were closed, and I think you'll see where the trend begins. It's with the board. It's with the people who are handling these complaints. If they can close them on a personal bias like you all have against me, then something is terribly, terribly wrong. And Ron Lewis proved it when he said, we can't hang everybody. Thank you.
Thank you for your public comment. Next up, we have Marissa Vismara. Marissa, are you there?
You got it. Thank you. Yes, I'm Marissa Vismara, Senior Policy Coordinator with the California Primary Care Association. First, I want to start off, thank you to the board for the opportunity to give public comment on a very important issue, the postgraduate training license. The 2020 transition to this restricted license and affiliated requirements has created significant detrimental impacts to California physicians, training and residency programs, access to care for patients, especially those in communities of color and hard to reach areas during the pandemic, and future healthcare workforce as the state has a growing provider shortage. We value the board's engagement during the last 2 years. We've met in July and December of 2020, and January, March, and May of 2021 to discuss our concerns with the PTL. One of the most significant issues, as referenced in our coalition letter, is that PTL holders are unable to enroll and bill Medi-Cal for moonlighting services. Federal regulations do not allow providers with current limitations from enrolling in Medi-Cal, and 36 months training requirement of the PTL is restriction. Medicare provisions have similar stipulations on license restrictions for providers. In these conversations, we've learned that the origin of the PTL, the board, and unfortunately prior to the PTL, there were residents or bad actors who didn't complete their training program, but went on to practice medicine with their unrestricted license. When we asked to see the data of the board was unable to provide it. I appreciate the board's comments during this meeting on the value of data, and I encourage additional data to be produced for us stakeholders to better understand the origin of the PTL, and as Ms. Lawson mentioned, make meaningful action. In the past 2 years, we've been in ongoing discussions with the board and state health agencies and are no closer to a resolution or concrete changes. Our ask of the board and its mission to promote access to quality medical care through the board's licensing and regulatory functions is to either eliminate the PTL and return to provisions and licensing statutes and requirements, or propose legislative language that will resolve the listed challenges. Thank you so much, and we look forward to further collaboration.
Thank you for your comment. Next up, we have Virginia Farr. Virginia, are you there? Virginia, I've opened your microphone. Are you there?
Hello. I'm not sure if I have an echo because I'm on my computer. Does it sound okay?
Sounds okay, yes. We can hear you fine. Please go ahead.
Okay. My question is, this computer database you're building, will it have where patients can enter the type of error and you can hold down on the type of error and then prevent that type of error? Like an example, if 50 patients had an NG tube placed in the lung and nobody did an x-ray, are you able to know that specific error is happening and prevent it from happening? Also, it'd be very helpful to have a member of the board, this patient safety expert, so they can help prevent the errors from happening in the first place, either that or hire a consultant in patient safety, because we need to prevent the errors from happening to be effective and efficient and not have all 10,000 cases because we didn't prevent them in the first place. And that's it. Thank you.
Thanks for your public comment. Next up, we have Rosie Arthstarter. Rosie, are you there?
Yes, I am. And I had to step away again to take care of some critical things. And then my computer decided to take and do an update. So I'm not sure where I am in this process, but I think I'm responding to enforcement activity. Is that correct? Or have we moved on?
We're on the executive management report for Mr. Prasifka.
Okay. All right. On part B, going back again to the right to know of 2018, there is the way that is written, it leaves everybody who's either unconscious or in a emergency room, urgent care, or has a bait and switch, a floater comes in, they don't have to inform people that they have a cease order practice against them. It seems to only help the patients, existing patients of a particular provider. And so that's a problem. On the site, as I said before, when you go to the alerts and click on the cease practice order, it goes to a 404 error. When you go to the profile, it doesn't show up at all. There was a site called forpatientsafety.org that actually had archived some of the older stuff that is not there any longer. So one cease practice order was published at one point and has now been removed. So something is going on with how that is being displayed to the public. So that's one thing I need to bring to your attention, and also to commend this group, forpatientsafety.org, because they did a wonderful job of archiving this information and presenting it in a clear, straightforward, unbiased manner. So that was good. Then the other part is under the expert reviewer program. In the examples of the materials for the expert reviewer program that are available online, it does make reference to the laws regarding intractable pain. So that would be the Pain Patients Bill of Rights, the BMPs regarding it, including 2220.05. Now, apparently it's there for the experts, but then when somebody writes up the complaint, apparently it's being eliminated and they only go down to point 1 and stop, and they don't do point 3, which says in no case if there's intractable pain shall you use it. So when the AG person comes up, maybe we can discuss what's happening with that, why the people writing the complaints are not following the law. Maybe they didn't realize that it's 1, 2, and 3, and 3 has specific qualifications for intractable pain.
Please conclude.
Anyway, thank you.
Thank you for your public comment. And at this time, Ms. Lawson, I do not see any additional requests.
Thank you, Sean. Are there any additional comments or questions from the board members before we move on to the next item? Right, seeing none, we will move on to the next item, which is item 7, update from the Attorney General's office. Is Ms. Castro with us?
Yes, can you hear me?
I sure can. Welcome.
Welcome. Thank you very much. As you know, our former Attorney General Javier Becerra has joined the Biden administration as the 25th United States Secretary of Health and Human Services. We will miss him and are very proud to have served him. Our new Attorney General, Rob Bonta, was sworn in on April 23rd, 2021. He is a champion of all that Health Quality Enforcement Section holds dear. We're very proud to serve him in executing his vision for the Department of Justice and his important mission as California's 34th Attorney General. And then finally, in my report, Supervising Deputy Attorney General E.A. Terry Jones III is retiring from state service after having been a public servant for 29 years, the bulk of which was in the Health Quality Enforcement Section, which he joined in 1992. Under his guidance, dozens of deputies have achieved great things for all of our clients. The Attorney General's office and the Health Quality Enforcement Section will truly miss his professionalism, dedication, and expertise. And that concludes my remarks. Thank you.
Thank you, Ms. Castro. Are there any questions or comments from board members? And I guess I'll start with just please pass along my congratulations on his retirement.
Thank you very much.
Questions or comments? All right, seeing none from the board members, we'll ask the host to call for public comments.
Okay, once again, the Q&A window and the raise hand feature are activated. If you'd like to make a public comment, please do one of those two options. First up, we have Rosie Arthur's-daughter. Rosie?
Hi, okay. Continuing on with section 2220.05 of the Business and Professionals Code. What I have noticed in the accusations and the other enforcement documents from the death certificate project and in other cases, what we have is a number of cases involving intractable pain for which Part 3 applies, not Part 1. But apparently when the accusations are being written, they're stopping at 1 and using that to do rather severe disciplinary actions when it might otherwise be a reprimand or, something covered in correspondence, paperwork error or whatever. But any of those then are classified as number 1. And then instead of going down to number 2, where it says, let me get it right at number 3. It says, however, in no event shall a physician and surgeon prescribing, furnishing, or administering controlled substances for intractable pain consistent with lawful prescribing, including yada, 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 of the Health and Safety Code, 124, 960, and 61, says, be prosecuted for excessive prescribing, and prompt review of applicability of these provisions shall be made in any complaint that may implicate these provisions. And so what happens is you have a number of them, it's hard to say how many, but too many for me to count, where this applies, and there's no mention of this provision whatsoever. Every time a license is revoked, the person is induced into surrendering it, changing their practice, dismissing or tapering their clients. It means that for every one of those practitioners, 250, 500, maybe 1,000 patients are adversely affected because when they can't get their medication appropriately prescribed, no other provider is going to take them because they don't have to. Nothing requires any provider to take one of these patients.
30 seconds remaining.
As a result of these types of tactics based on some cases on paperwork errors, people die because they can't get their pain relief. They suffer needless pain and psychological pain, physical pain, suffering, financial pain, and all their caretakers and families, the people they interact with, their community, all suffer when somebody forgets to go down and look at this applicable thing. So I'm hoping that the people in the AG's office will look at what they're doing when they're writing these complaints, because each one of these could be challenged. And it's caused thousands of deaths, no doubt, by now. Thank you.
Thank you for your public comment. Ms. Lawson, this time I do not see any additional requests.
Thank you, Sean. Are there any questions or comments from board members for Ms. Castro?
Ms. Lawson, this is Dr. Thorpe again. I don't want to prolong the discussion, but I would just point out again that, our budgetary allocation for the Attorney General's office, we are going to be over budget by approximately $4 million if we continue on the current course. And it is troubling that we are seeing no change in, or no decrease in timeframes for adjudication of cases, even though the board is paying more money for those results. And it's, the idea that we can just go to to the legislature and ask for a bigger budget is not really a viable option. So I would just point that out, that we're still in difficult straits financially, or will be soon. Currently, we're not, because we're not through the year, but we're only 5 months into the year. Thank you.
And Dr. Thorpe, I mean, I would just observe, and then I'll ask Ms. Castro if she has any comments, but I agree with you. But many of those items that are in the, this budget line item are outside even the control of the Attorney General's office. And frankly, to speak to some of the issues we might talk about in our next agenda item on the sunset review hearing, items like cost recovery, for example, where there's currently a disincentive, right, to resolve cases earlier on in the process. And there's every incentive for people to use the judicial process, which the AG's office is tasked with participating in on our behalf, but to use as much process as they can there to, delay. And we heard earlier before when Mr. Prasifka was talking about subpoena enforcement, right? I mean, you can drag out a case for many, many years and cause a lot of attorney's fees to be incurred by the medical board with some of those tactics that perhaps if cost recovery was still a tool in our portfolio, we might not see as much of that. So Ms. Castro, do you have any additional comments?
No, not really, Ms. Lawson. I agree with everything you just said. Mr. Chris Ryan, our budget director, is always pleased to come and address the board on those types of specific questions, Dr. Thorpe. He last appeared before your body in January of 2019, I believe, right before the pandemic, to speak specifically on the fee study. And at that time, it kind of dovetailed with the increase in the Attorney General's fees. He could speak to that much more specifically than I can. However, I can tell you that just in a quick analysis of the number of hours that we are devoting to your work, that has stayed constant. The volume of work that has come in has increased slightly, and the Office of Administrative Hearings never stopped working or hearing your cases. And so there has been no downturn in work for this DCA client whatsoever. And that's not to say that other DCA clients have not had a downturn in work due to the pandemic, but doctors continued to work, and so did we. So hopefully, if you wanted to agendize that, Ms. Lawson, our office is always available to come in and speak more to the points, and they would answer anything that you have much more accurately and fully.
Thank you. Any other questions or comments from board members? All right, seeing none, I'm going to move on to the next agenda item. Ms. Castro, thank you for joining us. The next agenda item is agenda item 8, update on the sunset review hearing process. Mr. Prasifka.
Yes, thank you, Madam President. Well, it's been a very busy time in terms of sunsets. And since the last board meeting on March 19th, the board first sunset hearing was held, and the focus was on enforcement. As a result of that hearing, we answered a number of questions and related to enforcement, and we supplemented our answers in the hearings with written responses to the Senate and Assembly Joint Committee. And we also gave them responses in terms of the issues which they raised in the background paper, and all those documentations are included in agenda item 8. There was a second hearing on the 5th of May, and that focused on licensing and administrative matters, and including the board's fund conditions. One issue of particular significance which was raised there was the issue with the postgraduate training license. As board members would be aware, there have been a number of different technical difficulties that have arisen in terms of the implementation of the PTL, which was first brought out in January of 2020. Effectively, there are a number of technical problems which arise out of a very simple situation. For many activities of doctors, it requires under legislation and regulations that the doctors are those who hold a physician and surgeon's license, full stop. these legislation and regulations were written before the introduction of the PTL. So it doesn't provide that the PTL holder can do all of these things. Effectively, what we have been doing is, and we continue to do, is to work with a variety of stakeholders, including the legislature or including the Assembly and the Senate staff members, with many public bodies who've given interpretations of how the PTL should be considered, particularly in contrast to the physician and surgeon's license. And we are doing everything we possibly can under the direction of the president, vice president, and other board members to try to resolve these matters. And we've been able to resolve some, but others appear to be more intractable. We're looking to see to what extent we can bridge the gap between what the expectations are of third parties and our own interpretation by engagement with them, by further explanation. We're looking to see where possible we can change our own regulations so that PTO holders can have all the rights and privileges of physician and surgeon's licensees. But then at the end of the day, it may be the case that what is required is changes to legislation. We are working with all stakeholders, as I said, including the Senate and the Assembly. Particularly working with the Senate and Assembly, there's a lot of goodwill there to make the PTL work. We understand that there are problems in terms of aligning policies relation to family leave, in terms of being paid Medi-Cal for moonlighting, getting X waivers for the dispensation of controlled substances. We're actively working with all bodies there. We will keep you informed, and we're looking forward to further engagement. This is very much a project in the making, and we'll certainly keep you informed of it. And just to bring it to a conclusion, we have no indication that there are going to be any further sunset hearings. The next hearing may be simply a vote on Senate Bill 806, which is our sunset bill. Currently doesn't contain anything about it. And we're awaiting word on what language may be included in that bill. And obviously, we'll be working very closely with the president and vice president on all of these issues. And I'd be happy to take any questions you would have.
I have a
Thank
question.
you, Mr. Pris. Yeah, I was going to invite Dr. Kraus if you had any, anything to add, because you were participating in these sunset review hearings, of course, as was I.
Well, I would editorialize by saying that, in my view, our staff and our executives did an incredible amount of work in a very short period of time, and I'm very proud of the work product that they produced for the sunset hearing, especially the written responses. Regarding PTL, I'm curious to know if Mr. Prasifka feels it may be helpful for the board to make a motion and establish a position that would state that the board is not looking to restrict moonlighting of those with PTL licensure. The board is not looking to extend 3-year residency training by an additional 3 months. So I don't know if those things require an expression of board sentiment, which is on the record, or if the director is comfortable in representing those concerns without a formal board action.
Well, I mean, it is a tricky question that you're asking, because we're at a very much a consultative stage of the process. We have, again, taken directions from the president and vice president, and you've made it very clear to us that you're looking for solutions, that we're not looking to restrict moonlighting or family leave. The difficulty that we have is that the reason we're having these technical problems is not because of sort of the directions that the board has given us, but interpretations that have been made by third parties over whom we have no control. Now, we've been engaging with those third parties. At the last meeting, I put it to them directly that I can tell you that the board feels that the PTL holder, in terms of moonlighting, should be on the same footing as the previous physician and surgeon holder. And then I said, is that good enough for you? And if not, do we need a change of regulations? If not that, do we need a change of legislation? I have not yet received a response there. But certainly, I mean, my view is that we should press ahead with as much engagement as possible, try to resolve everything at sort of the lowest level of intervention that is required. If it's simply a matter of convincing them that there is no difference in those circumstances between the PTL holder and the prior physician and servant, so be it. If we need a regulatory change, well, then we will put through regulations. At the end of the day, if we need legislative change, I understand that the board will fully support that. So I guess the simple answer is I think it's a little premature for us to put down that statement. What I can tell you is that in those discussions, I represent that the board is looking to solve these problems.
Thanks, Bill.
I want to comment on that PTL as well, because I read all the documents as well. And, you know, Dr. Kraus made an important point about the unintended consequences when he mentioned this. And as I'm reviewing this, it became apparent that what I was uncertain about is, are we currently working on some legislative language or other fixes to address some of these unintended consequences? Because we cannot possibly be at the consultative stage when this law went into effect in 2020, when everybody knew it was coming up. I think I feel like we're late to the game. And one of my concerns is real in light of all the other issues that happened in previous sunset, which I will discuss. This particular issue, I'm really sitting in a space where I'm asking, what problem were we trying to solve? Because that kind of got lost in this. And was this the best way for us to solve that problem? And if perhaps the way the amount of manpower and woman power and just hours it takes to come to a conclusion, was this really the intended consequence? Or was there another solution to resolve this that we may have missed? And perhaps we must have an honest conversation about that. If we did, then we can say, yes, we did make a mistake.
If I may, to Mr. Watkins' point, Ms. Webb, it might be helpful for you, and I received this feedback from stakeholders as well, that there was perhaps not an understanding of why during the last sunset review process, we moved to this PTL licensing scheme as part of that. And it did, so it was adopted as part of that last process. It went into effect earlier this year, and then last year. And then the unintended consequences came as a result of these interpretations by other third-party agencies, right? But in my stakeholder meetings with some of the groups that are interested in this issue, they were asking the same question Mr. Watkins was asking about how did this come to be? Why was this considered in the first place? And to use your language, Mr. Watkins, what problem were we trying to solve at that time? Ms. Webb, I don't know if you're the right person, or Mr. Prasifka. I know you and I've had some conversations about it in the past.
I'm happy to speak to it. First of all, the board had a process for reviewing international medical schools that it limited many medical schools that other jurisdictions recognized to allow licensure in California. And so the board went to a process where it approved medical schools listed on the World Directory of Medical Schools and other resources. And the flip side of that, the board stopped reviewing the clinical rotations and removed all of the detailed processes for a school to be approved, and also stopped going over to ensure that a certain number of weeks for each topic of clinical rotations was covered. So it streamlined that part of the application process. The other side of that is that since the board was not closely monitoring and looking at that end, the more important part was that once someone started their postgraduate training program, that's where the tests would really come. So more people have opportunity to get be able to qualify for licensure in California, but they have to complete a longer period of postgraduate training to do so. The board back in 2017, when this was being discussed, well, 2016, 2017, and even before that, felt that 1 year of postgraduate training for US and Canadian school graduates and 2 years for international medical school graduates was just not sufficient for consumer protection. The 3 years of postgraduate training is the minimum that would be required to complete like a family medicine postgraduate training program, for instance. Some programs are much, much longer, but people were able to complete 1 year and then get licensed and then go out on their own and practice medicine in an unrestricted fashion. And so the board felt that that was not consumer protection, increased the requirements, and that's what we're working through now. The interpretation about moonlighting, we think that we may be making progress on that with a different approach, but as Mr. Prasifka said, we are diligently working on this with the parties that are involved, and it may be necessary to have an interim meeting to address this more specifically, where it's agendized and more information is available.
Ms. Lawson, if I may interject, it's of interest to note that we're not the only state who's moved for more than 1 year of postgraduate requirement. And there are many other states that require 2 years at least. But these issues of moonlighting and duration of residency training don't seem to have inhibited the practice in other states. So it really may be more an issue of how other state agencies are interpreting it in California, rather than the legislation necessarily having not been drafted properly. So that's why there is the hope that these things may be fixed without more legislation.
Thank you, Ms. Webb. Thank you, Dr. Kraus. Are there additional questions or comments on any of the issues about the Sunset Review hearing?
I have a comment. I would be remiss if I obviously didn't comment, because I showed up at the first meeting and I, studied our response to the Business and Professions Committee. And how do I put this? I'm kind of in this quagmire, because the data, the information that we presented is what I would call, it's really not forthcoming. And it is at a very low integrity level. And I'm using these words very lightly and very carefully, not to offend people. But we cannot have two numbers, just for the record. We cannot have two numbers for the amount of stipulated settlements we've had for a year in question, that kind of impact how we present the information. So that's the one thing. And when information is asked and you sterilize it, it becomes immediately apparent to anybody that studies numbers that number is that number is sterilized. And I'm referring to, there was a question about how many public reprimands, and the number that was given was 80, with a note that says that some public letters of reprimand is issued prior to filing, but a number is not given. So that hides facts, right? So we're talking about transparency. So let's have a conversation about transparency. Because transparency means we present the things as is and let somebody else decide. We present the information as it is so that other people can have their own interpretation of it. At the sunset hearing, the first one that was on enforcement, I obviously, everybody by now know that's on the board, that I was not part of the board's team, so to speak, because I had a differing opinion. And I think that a lot of what I have said was misinterpreted. I found things, raised my hand and said, there's some things that don't make sense. And as a previous mentor of mine says, when it don't make sense, it's nonsense. And I was referring back in the hearing to numbers that I've created. I took all the stipulated settlements and I put it into a graph. And what I did after that, I took the criteria, the most important criteria, simply, very simply, most important criteria on the disciplinary guidelines for the public protection is the probation period, right? Now, that is not the interpretation that is in this document that we presented to the legislature, because in the legislature, which wasn't mentioned in the hearing, elements of the disciplinary guidelines are met. So now we're using cool language. If anybody comes to it and they say that it starts with the minimums or whatever, or it goes 5 years or revocation, if we fall short of that, we fall short of the probationary period. We may have mitigating circumstances. What I'm not here to do today is to kind of litigate individual cases. So what I've done is, and I will distribute this to the rest of the board, I decided that to give you a real insight on what I meant and to my fellow board members so that this can actually be an enlightening moment. And I'm really open to hearing other people's point of view. So I went for the last 13 fiscal years. All this information is available on the board side, on the annual report. And I asked public protection questions. Just public protection questions. I asked questions like, how many complaints did we have? Those numbers are all there, right? I asked, how many accusations did we file? The numbers are all there, right? And then I asked, so what was the percentage of the accusations that we filed for this period? And I came that the average for the 13-year period was that we only really filed accusations at 3.6% on average, right? And then I looked closer and I said, okay, so how many disciplinary actions did the board take in the last year and for the previous 13 years? And I discovered that last year we did 380 cases, right? And we came to a percentage of a disciplinary action rate of 3.5%. Now, why this is important? Because the numbers are really low. In fact, we are almost 1% down from the average for the 13 years, because the average that we did for the 13 years was around 4.4%. And this is important again, because now I'm breaking down the 380 cases. And that's what I spoke about at the last board meeting, that we have these 380 cases, which are the most egregious, right? They take up the most money, they take up the most time. And I asked, how many of that was public letters of reprimand? And that was 35% of that was public reprimand. Now, that's not concerning, because I have to look at what the average was for the period. It's 34%, right? So now I see that throughout the period, that was the standard, that we've been writing disciplinary and public reprimands at that rate for 13 plus years. I went further and I said, so how many times did we actually lay out probation on any of these 380 cases? And it was only 130. So let me put that in a story for you. Right now, if you ask a person that is filing a complaint against a doctor, the chances that this board will actually put probation on that doctor is around 1.2%. Now, if you think about that, 1.2% is the rate at which we hand out discipline. Now, you can go to other boards and you can find, oh, they're at 1.6 and at 1.8 or whatever, right? The point that I'm making, as someone mentioned, this is the premier board in the country and probably in the world. Why are we doing numbers like that? It is such a low rate. It begs questions of what is happening in the process. And let me just give you a number that will make you just in a very simplistic way. Let's do it in a simplistic way. We spend $60 million on enforcement. And what we get out of it is what I see on Dr. Thorpe's face every time he speaks to Ms. Castro. I see the frustration of someone that's buying something that he is not getting the value out of it. So if we want to put a value out of it, for that 380 cases to come before the board to work through the system, that comes out to about 157,574 per case for us to get to. For us to get that result, it costs us that in real money, right? Because we're sifting. The sift is accumulating costs. But here's an even crazier number. That if I say, how much did a public reprimand cost me? Out of that to produce a public letter of reprimand cost me $559,000 when I'm done sifting through all this information. So what does that tell me, someone with an operations background that builds systems? It tells me that there is an enforcement system that is absolutely not working. And how do we know this? Because the public screams at this end that it's not working. Everybody is saying it's not working, but we are tone deaf when it says that. So in the previous board meeting, I said, well, we protect the doctors, right? I said the board exists to protect the doctors. I'm going to rephrase that to be sensitive because it's not completely true, right? I'm saying that we have created a system that is so disproportionate towards the public that if this was a racial disproportionate, we would be issuing all kinds of legislation to change that because it's at that severe rate. This system that I'm looking at, this system as it stands right now, does not protect the public. The system as it is. And we really need to look at some of the more advanced ways in how we can achieve that. And this is not to raise issues with everybody or anybody. When you read the numbers, I can tell you a quick story, it takes 2 minutes, right? We get a doctor. It takes one of those 1.2%, right? And I put him through the system. Statistically, that will be a stipulated settlement. Statistically, that means we're not going to follow the probationary guidelines on number one element, which is probationary period. So he gets 3 years. The 3 years is what we kind of average out. But after we hand out this discipline, that doctor can come back to the board. And for the last 13 years, we will approve removing that discipline 76% of the time. So with numbers like that, it shows that we have there is nothing that makes it balance out. So what I am suggesting and what I've always suggested is let's find a place where we can find the balance. A balance in how we do this, and that is, there's too many things to discuss about that, from legislation from all the issues that will come through the sunset review, what the legislature decide. But I think what is more important is that we need to be proactive and have something that is measurable. These numbers are really measurable, and they give greater insight than what anyone may think about what is happening really in the process. It says, no matter how you shape this, the process is not working for the people. The process is not working for the public. But unfortunately, it's working perfectly for the doctors. For any doctor that comes before the board, this system is designed, and they can be I'm done, but I'm really curious to hear from our doctor members about what I just said. If that is alarming or if it's not alarming. Thank you.
Thank you, Mr. Watkins. And I would encourage you to please forward those written comments to all of us. I was trying to take as many notes as possible, but it's difficult to process, all of this information during a live board meeting. So if you could forward that to us in writing, I think that'd be helpful. Are there other questions or comments about this? Yeah.
Forgive me, but I do have to caution everyone that they not violate the Open Meeting Act. I did ask Mr. Watkins for that information. He initially said that he would share it and then decided not to. But I know staff would welcome the opportunity to review his data.
So, sorry, clarification on that, Ms. Webb. Can he he indicated during his comments that he had something written that he would share with us. I think that's what I was asking that he share. Is he not permitted to share that with us, or can he share it with us and we can
It would have to
disseminate it to the
be,
public?
it would have to be a public document, or he can share it with staff.
Okay.
Here's the deal. The information that I did not share with the board was the cases that I reviewed myself. And I will, why I'm separating this out is because I did not want to come into a point where I want everybody to see the big picture, right? I did this in the last 3 days. In the last 3 days, I did it to sketch a picture, because through conversations, I started realizing people do not understand what I'm trying to, the picture that I'm trying to draw. So to hear me saying we're protecting the doctors, what I'm saying is that statistically, it shows you a system that is protecting the doctors. And this information I will share. This information is actually all on the board's website. And this information should be public knowledge and public reporting every board meeting. That's what I've been trying to say. Now, instead of going through a whole hoop, I made it myself. Because from this information, you can actually measure and change things. As Dr. Mahmood mentioned earlier, you gotta have something that we can measure, goals to achieve. So I will forward you this document. I will forward the narrative to it too. I haven't written the narrative. I've got the statistics. Thank you.
All right. Thank you. Are there any
comments?
I'm sorry. Well, I'm sorry.
Dr. Mahmood.
Dr. Mahmood, please.
Yeah. So I have 2 observations. Thank you, Mr. Watkins, bringing up this discrete breakdown of. Number one is, I think we need to make this very clear, and it is in my mind very clear. I'm a practicing physician, but I don't have any sympathy for anybody. My goal, and I'm pretty sure other doctors' goal on this board, is purely and fully protection of the public. And I don't take one single case having any sympathetic feeling towards any doctor or giving any doctor a benefit of doubt in a way where public can be heard. There are cases where I go on and many other doctors go on. We go on to punish more than what has been recommended. And there are cases we kind of disagree that we need to cut down because we practice this thing, and maybe sometimes when you practice, you see the challenges and difficulties, and everybody will disagree. Everybody have a little different opinion. what we have done so far, most of those cases go through the board. Either we want to say that this board is deviated or inclined towards professionals or doctors, or this board is biased, or we want to make sure we are making the decisions the right way, because ultimately buck stops at the board members, and discussions are very open. So we can't really say that we are doctors friendly. If there is something in the system or somebody investigation and kind of stuff hang on there, I don't know about that. Number one on that thing. Number two, on early probation termination, I think Mr. Walker brings a very good point, but I think there should be one more angle needs to be looked at that. If you look at last 100 cases where probation was terminated earlier than what they were supposed to be, and out of those 100 cases, how many people went on and within 5 or 10 years committed the same thing again? Because our goal is also rehabilitation. Our goal is not only to cut heads, our goal is to hold people responsible, do rehabilitation, and bring them back to the community. So if out of those 100 cases, even if there are 10 cases who are committing the same mistakes again, that means we are doing wrongful thing to give them early probation termination. But out of those 100 cases, with only 1 or 2 cases are there who are not complying, they should be held responsible, and we should continue the process. So that number needs to be really looked into. That people who have been given early termination of probation, how did they perform in next 5 years? And that data also can be looked into that. And I think in next meeting, the data should be brought on, and we should look into that. And if the data is strongly in favor of that, those people are doing an habitual things, then we need to really work on to get on this thing that people should not get, or term limit for the early probation application should be extended. But obviously, our goal over here should be only one, and only one, that is protection of Californians and protection of public and safety and high quality of healthcare.
All right, so I appreciate the conversation and the comments on these topics. I would like to refocus us, because this item was agendized for the public as an update on the sunset review hearing. And while some of these topics came up, I do know that there are a variety of stakeholders who want to talk to us about issues that they're concerned about in the sunset review hearing that have come up, that the legislature has also expressed their interest in. So, I mean, are there other comments from board members on the sunset review hearing update?
Can I clear up this one point, and then I'm done on this point? Because this is an important point. That there's misconception that, you know, this is not against, as I proposed it, is that I say this is a systems problem. In the previous board meeting, I brought up that these DAG memos that we receive is problematic for me. And that's just my opinion. Everybody is entitled to their own opinion, but they produce these kinds of numbers. So Dr. Mahmood, just to address something you said, that, you know, we push back, but that does not show up. In last year, for example, of all the stipulated settlements that the board, that we were presented with DAG memos, out of the 303, 299 was signed off by the board, a literal rubber stamp. 299 out of 303 is 99%. That we didn't make one change. We had a say in it. We spoke about it, but when it went to a vote, it went one direction. And when you see those trends, then it points to, hey, what can we do different? This is not for me attacking the board. This is just me asking that we need to look at these things with a point to identify exactly what it is that we need to do in order to resolve it. Thank you.
Thank you. Are there any questions, comments from board members before I invite the public to comment? All right, seeing none, Sean, would you open the line for public comment, please?
Yes, we've got the Q&A window open, and also able to click the raise hand thing if you'd like to make a public comment about this agenda item. First up, we have Sandra Perez. Sandra, are you there?
Yeah, I'm here. Sandra Perez again from Hesperia. I want to speak specifically to a question that Mr. Watkins asked regarding the PTLs. And that question was, how did we get here? My understanding on the BPC 2052, and let me preface this by saying I am no way a lawyer. I don't practice law. I do not have a law degree. But over the last couple of years, after the egregious medical negligence that my daughter faced, resulting in her death, I've learned that BPC 2052 indicates you cannot practice medicine without a valid license. And prior to 2020, the postgraduate training authorization letter was only issued to international graduates and not US graduates of medical schools. And I have two statements here from the medical board, signed by chiefs of licensing of the medical board. One dated February 24th, 2020, signed by a Marina O'Connor. The other one, June 8th, 2018, signed by April Alameda, and both of them, I quote, "The issuance of a PTL will allow residents to train without violating the law," end quote. This means that the medical board and the state legislature knew that residents that graduated from US medical schools were violating the law, and thus they instituted a PTL license for them, so they would no longer violate that law. I think Ms. Webb was a little bit dishonest or less than forthcoming when she was answering Mr. Watkins' question regarding how did we get here with regards to the PTL. Thank you.
Ms. Webb, I just wanted to ask you for a clarification because my understanding is that in the past they were being granted the unrestricted licenses as opposed to these PTLs, but maybe you could clarify.
Yeah, prior to January 1st, 2020, those individuals in approved postgraduate training programs were authorized by the law to practice while they were in those programs. They did not require a license if they or a postgraduate training authorization letter if they were graduates of US or Canadian schools. The law specifically allowed it. What the PTL did was, because they were going to be practicing for a longer period of time without a license, and because we wanted them to be able to moonlight with approval of their program directors and bill and sign death certificates and birth certificates, the postgraduate training license was instituted. That requires them to get that license within 180 days after enrollment in a postgraduate training program. So the law allows for a specific exemption period, and even now, what they have 180 days to get that postgraduate training license. So between day one and the time they get that license, they are practicing within their programs legally because they fall within that exemption period.
And that exemption period is built into the law, correct?
Yes.
Yeah. Okay. Thank you for that clarification.
Ms. Lawson, can I give a little more clarification on that too? So one of the issues that our board faced was that some of these people were not given a second year training. So they were actually did internship and they could get full license. So that was very concerning to the medical board. So that the Cleanup Act, which was done, and same for the international graduates, if they did 2 years of training, could be both internships. Then they were given full license. So to correct that came in the PTL, where they are under the institution supervision because they're actually residents to be able to do it. And I can see the problems because of 3-year requirement, but not all the reason was just only whether they went to school somewhere and whether they went to school somewhere else. It's one of the bigger reasons was that we thought it was not safe to give somebody full license to practice medicine with 1 year of training after medical school.
All right, I'm going to ask that we go back to the public comment queue, and then we can have this discussion once we bring it back to the board after hearing public comments.
Okay, next up we have Eric Andrus. Eric, are you there?
Yes, I'm here.
Please go ahead.
Okay, my blood's boiling, you guys. Dr. Mahmood, it is not a goal of the medical board to rehabilitate doctors. Go back and read the mission statement. The word rehabilitate is not in there. In the law, it says that you can strive to rehabilitate doctors, but only if it's in the best interest of patient safety. It's not a given. You can't go into a disciplinary action and say, we're going to try to rehabilitate this doctor without knowing that it's 100% compliant with patient safety. TJ, it is more important to reveal the truth and the problematic people than to worry about hurting someone's feelings. Because of your bravery, you are substantiating advocates' cries that have been thwarted by this board for decades. Howard, were you proud of Jenna Jones when she flat out lied to Senator Roth? He asked several times if the board interviewed complainants upon filing a complaint. She hemmed and hawed, and he finally asked her again. He said, is a body an agent of the board asking some preliminary questions of the complainant or complainants at this point in the process to determine whether there is additional information that should have been provided or questions that should have been answered, even though not asked, as part of the initial process? And Jenna Jones said, yes. That's a bald-faced lie. I have an email. Let me pull it up here real quick. Oh my gosh, I'm so nervous. This is just making me so angry. I have an email here from Amandeep Kaur, K-A-U-R, on September 24th, 2018, in answer to why I was not ever interviewed on my complaint that was closed without investigation. He says, and I quote, "The Medical Board of California does not conduct interviews during this stage of the review process." Close quote. Jenna Jones bald-faced lied to the legislature. You guys should be ashamed protecting this staff. Bill Prasifka for lying to the legislature. TJ, you're absolutely right that everything that's said to that legislature is to sugarcoat what this board does and does not do in order to try to get 4 more years out of that legislature. Shame on you.
30 seconds.
Shame. I'm done.
Thank you for your public comment. Next up, we have Dennis Cuevas Romero. Dennis, are you there?
Yes, I am. Thank you very much. Good afternoon, members of the board. Dennis Cuevas Romero, legislative advocate with the California Medical Association. I want to thank the board and staff for continuing to engage on this critical PTL issue, which is causing various challenges, as has been outlined by our joint coalition letter since its implementation. I'd like to focus my comments on the PTL's access to care, as other colleagues will comment on other issues. Many facilities rely on additional support from residents to provide care. This limits the amount of patient access provided to needy communities, especially in rural and underserved communities. At a time when the state is struggling to meet demand for care, policymakers must quickly and swiftly address issues limiting access to care. Additionally, CMA is concerned with the added administrative burdens of attendings to fill the void caused by the PTL implementation issues. While the death certificate issue has been resolved, there are still outstanding issues which are preventing residents from signing disability and employment forms. As board members, you have a keen awareness and understanding of how vital these issues are and the challenges facing residents. We ask the medical board to urge the legislature to resolve these critical issues in statute through the sunset review process so we can eliminate these challenges to access to care while maintaining patient protection. Thank you.
Thank you for your public comment. Next up, we have Katrina Reyes. Katrina, are you there?
Yes, I am. Thank you. Good afternoon, board members. Katrina Reyes with the California Academy of Family Physicians. We, along with our coalition partners, sent a letter to the board outlining our concerns with the postgraduate training license. We'd like to highlight one of the issues we outlined in the letter, which is that the new licensing timeframe has a disproportionate impact on residents who take medical or family leave, particularly on female residents who choose to start families during this time in their lives. California's strict requirement that medical school graduates complete a minimum of 36 months of postgraduate training with 24 months of continuous training in a single program does not allow for the licensure of residents who have taken leave for family or medical purposes without extending their training. Extending training, even though the program director and clinical competency committee has signed off on the resident's ability to practice autonomously, has a domino effect of consequences. We, along with the American Board of Medical Specialties and the American Board of Family Medicine, met with medical board staff in December of last year to raise these consequences. However, I am assuming because of the precise requirements in statute, the medical board does not have any leeway in interpreting the statute in a way that allows for leave without the need to extend training. As a result, we have heard from program directors that residents had to change career paths because of their inability to get licensed in California. For example, a program in an underserved community was expecting to hire a fellow from out of state who has been in excellent standing throughout her training. But because she did not meet California's strict time requirement for licensure due to her partner's serious health condition, and because she is unable to extend her training due to the fact that the program does not have the funding for the additional time, she is unable to be licensed in California and is now seeking employment in other states rather than coming to serve in one of our underserved communities. We understand the medical board's desire to ensure the competency of physicians. Nobody is more committed to this goal than residency training programs and the directors of these programs. It is important to note that clinical competency committees and directors of residency training programs conduct ongoing evaluations of resident progress and ultimately a final determination of resident preparedness for autonomous practice. To Mr. Watkins' point, it is important to consider whether the new licensing timeframe really addressed the issue the medical board was trying to solve. As such, we ask the medical board to work with the legislature to fix the licensing timeframe provided for in statute through the sunset review process, and to resolve it quickly to ensure that we do not exacerbate the primary care workforce shortage in California and access to care. Thank you.
Thank you for your public comment. Next up, we have Marion Hollingsworth. Marion, are you there?
Yes, I am. Thank you. I would like to again thank Mr. Watkins for asking questions based on the statistics. This is what we advocates have been trying to do for years, which is using the voice documents to show that the public is not being protected. This is an issue that time and time again, dangerous doctors get the chance to harm again. Take the case of Dr. Arjang Naeem, an obstetrician. He was found responsible for the bleeding death of a woman following a C-section, and he had two other near-miss cases a month before this case and a month later, in which women coded in the operating room while undergoing C-sections. Two near misses, as well as the death of Kara Johnson. Naeem had a total of 6 harmed women, yet he was just given 4 years probation for all 6 cases. The disciplinary guidelines say the minimum should be 5 years probation for gross negligence. How are cases like this protecting the public? These are cases that haunt us and should haunt the board. You just can't paper shuffle with that kind of harm. I agree with TJ that the board must reevaluate how it is disciplining dangerous doctors. And regarding how you communicate with complainants and the sunset review, you don't, and you often lie to us about our complaints. I was lied to by my investigator who promised me an accusation but quietly brokered a PLR without telling me. She then told me that the DA's office was short-staffed and it would take a while before the PLR would be posted. I contacted the DA's office and was told that not only does the DA not write the PLRs, but the DA's office was not understaffed. This board is not honest with complainants and was not honest with the sunset review hearing. You are failing the people of California by continuing to give more concern to doctors and their practices than you are to the consumers of California. Thank you.
Thank you for your public comment. Next up, we have Tim Madden. Tim, are you there?
Yes, I am. Thank you. This is Tim Madden, and I'm representing the California chapter of the American College of Emergency Physicians. We are also one of the coalition partners that sent in the letter outlining our concerns with the PTL. I'll focus my comments on the PTL issue with the X waiver. For emergency physicians, the X waiver has become a common and important tool, allowing them to start patients on buprenorphine for the patient's addiction challenges. When applying with the Federal Substance Abuse and Mental Health Services Administration, or SAMHSA, residents are told the following from SAMHSA. This is a direct quote. To apply for the buprenorphine waiver, you need to have a full medical license that states you are a medical doctor. We will need to withdraw your waiver as you do not meet all the requirements. California emergency medicine residency programs have tried speaking with SAMHSA to explore different approaches to allow for the X waiver, but they have been consistently sent the same message. Unless the physician has a full medical license, they will not get an X waiver. We are also beginning to hear this as an issue in other states. Specifically, the Massachusetts chapter for the emergency physicians just this week told us they are experiencing the same problem and are considering running legislation to fix the problem. We appreciate the comments by the medical board members and staff during the sunset hearing about their willingness to fix this issue. We also appreciate in the background materials the medical board reaching out to SAMHSA, but would note the lack of response and follow-up from SAMHSA. Given the stance of SAMHSA, it is unclear to understand how to fix this problem without going back to the structure before the PTL was put in place. We appreciate your time and consideration of our comments.
Thank you for your public comment. Next up, we have Michelle Montserrat Ramos. Michelle, are you there?
Yes, I am. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. Regarding board composition, staff has recommended to add 2 additional members of the public, and you have not considered a possible change to its composition. Please change the composition of the board to ensure some form of consumer protection. Current composition of physician majority is not working. Give the public members the vote they need to protect the public. Consumers are not being protected. Cost recovery. Yes, consumers agree with the board. Please seek the authority to seek cost recovery. You will regain some funding. It will decrease enforcement timelines and will lead to more accountability for patients and consumers. Complaints. No, families are not being advised of their complaints and are not receiving letters of their complaint status and where they are at in the enforcement process. They are not being notified that their case is formally under investigation with no investigation numbers. Families are hearing of the outcome of their cases by members of the public and not from you. An investigator has told one of my families that you are no longer providing letters to families. That is not what you are telling the legislature. It is unacceptable to mislead grieving families. Enforcement options. You should not be looking to cut enforcement costs on the backs of Californians. A letter of advice is not a cost saver. It will lead to more deaths. Consumers are completely against a non-adversarial manner of resolving disciplinary actions. Consumers are completely against a letter of advice. You may issue a letter of advice to a communications tech who does not repair your Wi-Fi or cable issues, but there is no room for a letter of advice for a doctor when it comes to a life lost or a Californian who now has to endure life in a wheelchair for the rest of their life due to negligence. There is no place for a letter of advice when it comes to a doctor and the fragile life of a patient. This does not protect the public. It protects the doctor and leads to more lives lost. Thank you.
Thank you for your public comment. Next up, we have Hannah. Hannah, are you there?
Yes, I'm here. Yes, can you hear me?
Yes, please go ahead.
Okay, I apologize. It's interesting. I'm working with the Hawaii Medical Board, and they meet at the exact same time as you all do. So I apologize for that confusion. So yes, I just wanted to state that Dr. Mahmood, I agree with you. So doctors are rehabilitatable. I've seen it. I've experienced it. So no one is perfect, of course, and there is evil out there, but we at Black Patients Matter are very grateful for the strides that have been made with the Medical Board of California. And I know that everything takes time and it's a process. So I commend you and I encourage you to keep pushing forward because we are going to change the country. We here at California. So thank you very much for your efforts. That's all. Thank you.
Thank you for your public comment. Next up, we have Helena Papa. Helena, are you there?
Can you hear me?
Yes, you can. Go ahead.
Okay, thank you. This is the first board meeting that I've actually spoken at, but I have been following these board meetings. I am one of the cases that the Center for Public Interest Law featured in their sunset review letter. So I'm very frustrated, I have to say, with what I've been hearing over the last year and a half of listening to board meetings. First of all, I do not think that the board members really understand what is going on in the enforcement process. I appreciate that there are some really good probing questions being asked. I think Mr. Watkins is asking excellent questions. Thank you very, very much. In order to, and I'm mindful that I cannot talk about my individual case because it's active. You must audit individual cases in order to find out where the process is breaking down. And that doesn't seem to me to be happening. There were breakdowns in my process because my complaint was actually reopened. So it was significant enough for it to be reopened. So there was an initial failure with the initial medical expert review. I have not been getting communications that are being represented by the board members that you're giving out to the public. I call very frequently to find out, and it's very frustrating that I have to keep on it in such an aggressive manner when my case was important enough to be reopened. So the letters are not going out at every stage as you are representing on these meetings. The complainants are not being kept in the loop. Right now it's an investigation. I cannot get any information about what's happening in the investigation process. I still have not been interviewed. I have given so much. I am a trained lawyer, so I have given the information in such a detailed fashion to them, almost spoon feeding them the case. I cannot understand why I have not been interviewed or the doctor hasn't been interviewed, and her interviews have been postponed twice already with no explanation to me. And now I'm in the situation of wondering if my statute of limitations is going to run. So I think these are things that I just want to raise. I do think you need to audit individual cases such as mine to find out what's really going on. Thank you.
Thank you for your public comment. At this point, Ms. Lawson, I do not see any additional questions queued.
Thank you, Sean. I will bring it back to the board. Are there any additional comments or questions on this agenda item, which again is the Sunset Review hearing update? Dr. Lewis.
Yeah, I just want to remind some of the members of the public, one in particular made a comment about doctors not being, our mission does not deal with rehabilitating doctors, but the ALJ's comments at every one of the meetings I've attended in panel A do refer to the fact that protection of the public is paramount, but also we do not punish. We try to rehabilitate when possible. And if that individual in the public would look up in Google about the medical board and about the laws dealing with discipline of doctors, that person will find those comments in there. Thank you.
Any additional comments from board members? All right, seeing none, we will move on to agenda item 9. And just for an update, I'm planning to take a brief 10 or 15 minute break before we go into the item 10, which is going to be a lengthy discussion of legislation. So I was planning on doing this item 9, and then we'll take a 10 or 15 minute recess before we sit down again for a lengthy discussion of all the legislation. Can I just see some heads shaking if that sounds good? Great. All right, so we'll move on to item 9, an update on the public stakeholder meeting. And Mr. Prasifka, this is yours again.
Okay, thank you very much. I hope this will be relatively brief since I think a lot of the material here we have already covered. As was stated, There was a public stakeholders meeting on the 21st of April, 2021. It's the intention to hold these on a quarterly basis, effectively between board meetings. We had over 80 individuals participate, or close to 80 individuals participate. On the board, president and vice president, along with 5 other additional board members, were present, as well as lots of staff of the board executive. We invited Bridget Grammy of the Center of Public Interest Law to speak. The Center for Public Interest Law has a long history of interest in the medical board. They have published a number of reports going back a number of years, and so we thought that she was a very good speaker to bring with us. One of the major themes that has developed, and we've already spoken about here, is the issue of transparency. But for me, the most important result of the board is that the executive, along with the president and vice president, have developed an action plan that is going to arise out of the public stakeholders meeting. We are currently working to develop a video to explain the complaints process. We want to refresh the website to give more information about the complaints process. As we have said today, we are looking to enhance direct communications and contacts with complainants. We have been actively measuring that. We've been monitoring it. We will be looking for more milestones in which there will be communications. As was already stated, we're looking at an ICT project so that we can create an online tracking mechanism that complainants can use. We've begun the process of looking at other jurisdictions, which we have stated the Ohio Medical Board, the Maine Medical Board have respectively victim coordinators and consumer advocates. We would welcome our stakeholders to do a similar trawl of other types of organizations that have this sort of liaison between the board and the complainant that is a useful model, whereby we can make it more user-friendly and communicate more directly with complainants. We're going to be reestablishing the Public Outreach, Education, and Wellness Committee, and the goal is to engage further with the stakeholders at subsequent meetings to brief them on the progress that has been made to date and to get further suggestions, particularly on how we can work on this transparency issue. And just in conclusion, I note that transparency and communications was a major theme raised by 4 of our board members at the recent Senate Rules confirmation hearings. We look forward to working with you in particular to make our communication, outreach, and complaint interface more effective. So we'll be happy to answer any questions on that area.
Thank you, Mr. Prasifka. And one thing I will just add is that I really appreciated about the public stakeholder meeting was the opportunity to have a conversation with our patient advocates, with the other stakeholders who were present at that meeting. And when I say a conversation, I mean a real back and forth where we could speak to each other, because the process that we have for our board meetings, because of the Open Meeting Act, because of the agenda restrictions we have in terms of accepting public comments and really not having a conversation during these more formal meetings, really limits our ability to just have a human-centered experience, really, and communicate on a human level with those who are so interested in the work that we're all doing. So I hope we can continue these meetings. I hope perhaps that maybe even the next one or the quarter thereafter, we can do it in person. I envision the type of thing where you all sit around a table. If we have 80 of us, it's going to be difficult to have it in that format, but the type where really we can interact with each other and work collaboratively to come up with solutions to the to the problems we have. And I see them as opportunities to improve the work we're doing. And like I said, I thank all of the public participants in that stakeholder meeting. I thought it was very valuable. Dr. Yip, I see your hand up.
Yeah, I would like to request possible we can fix a day way ahead so that more people can attend. Particularly now for myself, after the pandemic recovery, we're short of staff in the hospital. more patient needs service. Nursing staff is short. We really pretty hard to provide service to the public. So I'd love to really have a meeting with the stakeholders. So we can even do it evenings, like 5 p.m. After hour, we can schedule a lot better and more board members can attend. That'd be great. And also fix the date way ahead of time. That'd be wonderful. Thank you.
Yeah, thanks, Dr. Yip. And the comment about timing, in fact, the executive leadership and I had a conversation about even rotating the time, right? Because the time isn't going to always work for everybody. So just like we rotate our meetings sort of around the state again to, typically we travel around the state much in the same way, rotating the times of these meetings so we capture as many people as possible, recognizing that not everyone is going to be able to make every particular time we set for various reasons. Any other comments from board members?
Yes, Randy, may I speak?
Dr. Hawkins?
Yeah, hands up didn't seem to be working. So it's clear from that stakeholder meeting as well as today, we have a lot of work to do with our public outreach, education, and wellness committee. As sooner we can get some dates for when we might meet, the better, so folks can plan, as was just mentioned. The advocates have told us they don't want to be involved in meeting planning, and they've made some other suggestions like advisory committees. We want to work, and we will work with the public to make this work. I'm not sure it's going to be easily. We have things that get in the way, like Open Meeting Act, that we can't control. But there's a commitment from me as the chair of that committee and two other members, Ms. Campoverde and Ms. Lubiani, and I really know the board as well, because it is not working the way it needs to. Although they don't know about this, I don't wonder if, because they haven't had a chance to talk, Ms. Lubiani and Ms. Campoverde, would you mind speaking anything you thought about regarding this committee? I realize we're behind, but perhaps you can say something if you're inclined. If you're not, then I apologize. Two other members of the committee.
Sure, thank you. Lori here, if I may.
Please.
Thank you. I think overall, I'm excited about the progress we've made. And now that our committee is, we're planning to convene and just, roll up our sleeves and get to it. But also, prioritize the work we have to do and think realistically, what can be done in what period of time. So we're going to take a look at that. We'll look at the ideas that have come in, bring some of our own, and looking forward to it overall. Thank you.
We have a lot of tools at our disposal, thankfully, because of every kind of platform, from podcasts to social media to our website to our handouts, and brochures that haven't been updated in a while. So there's a lot of things that we can do to improve our communication. I know that all three of us are really excited to roll up our sleeves and look at how to do that in a way that's culturally competent, inclusive, and is able to explore new ways to pull back the curtain on the process so it feels less esoteric and be able to all feel like we understand what's going on. So feedback and forth is going to be really important in this, but we all are really excited to dive in. That was, as was mentioned, something that we talked about in our confirmation hearing, and we all want to prioritize.
I have a comment. This is TJ Watkins.
Please.
So we are on a great first step, and I feel the energy and the new excitement of the new committee, and that just makes me feel like we're going in the right direction. Here's my suggestion. We are taking people on a journey, so the expectations have risen because we've created space for them. So I would like us, and I think Ms. Lubiana pointed to this, of prioritizing what are the things that are the most difficult, what are the things that is in the medium term, and what is the low-hanging fruit that we can immediately start giving back to the people that have approached us. Because how this relationship is going to work is like every other relationship. Someone asks for something and they expect something in return. They either expect an action or they expect that you need to communicate with them. So we are really going to be called to order right now, because some of it is going to be difficult. I mean, some of it is going to affect the laws that we have to abide by. What we better have a game plan to make sure that when we communicate with them, we say we've reached that point here that it's going to affect a certain law or whatever, so we can't really touch that at this stage. But we are doing X, Y, and Z at the bottom, at the lower hanging. Simple stuff like including things on this agenda, for example. Someone mentioned that. If it doesn't take much, let's do it on a shorter time frame. Because now that we have a little good start, we gotta feed momentum into the system. And that's just my suggestion, but this is encouraging.
Thank you, Steve.
Points made, and there's two different kinds of communication and outreach. There's responsive and there's strategic. And so we have to do both sides, right? There's the kind of communication that we strategically push out as a board, again, that we have control over those platforms and the new platforms that we're creating, like the web tracking system, which obviously a lot of people are very interested in how that rolls out. And then there's a responsive communication, obviously these letters that people don't feel like they're getting, and that kind of communication. And so both sides are very important and have to work in tandem with each other.
Additional comments or? All right, seeing none, we'll open this for public comment, please, on the public stakeholder meeting.
Okay, the Q&A window and the raise hand function have been activated. If you'd like to make a public comment. First up here, we have Eric Andrus. Eric, are you there?
I'm here.
Please go ahead.
Okay, please consider this an official complaint that I feel that Ron Lewis is now incompetent to be serving on this board. Is anyone else concerned about his current state of inebriation? He can barely speak. Why is this being tolerated? Two, three. Okay, this person, Eric, knows fully well what the law says about rehabilitation. It's too bad that more board members couldn't be bothered to attend the interested parties meeting. That was my only concern about it, was that there was only, I think, what, 5 there? You all at least get per diem to attend. We all give freely of our time to help you. We set aside our day to attend this meeting. We don't get paid to be there. We are there free for you, just like these meetings. I've spent here now since 2 o'clock this afternoon, giving my time to you and to listen to this board so that we can help make the public safety. I think the least you can do is attend the interested parties meeting. My only concern is still being, and then finally, my only other concern about the meeting, which I thought was great. Thank you, Christina. I thought you did a fantastic job. My only other concern was that the interested parties meeting is about us. It's about the public and our point of view to you guys. And yet we were still being limited in the amount of time we were given to talk, and many people were cut off. That's not good, because the board members are never cut off. So that's an inequality in this meeting that's supposed to be about the public advocates. Thanks.
Thank you for your public comment. Next up, we have Kristen Ogden. Kristen, are you there?
Yes, I am. Thank you. I would like to also say that I found the public stakeholder meeting to be exceptionally remarkable as far as this kind of a board meeting is concerned. The fact that there was indeed conversation around the issues was very refreshing. And as a public commenter, I felt that I had been heard. In that respect, I would like to encourage that, although I am definitely looking forward to in-person meetings, because some of the people I represent who suffer from intractable pain and have less than optimal care at this point find it difficult to travel, to drive, I would like to suggest that you retain the option of attending virtually if that's possible. I think that would be helpful to a lot of the public stakeholders. I thought that Mr. Prasifka's report was comprehensive here, except in one regard, and again, this was your first meeting, it's your first staff report, but I did feel that my comments about the urgent need to restore access to medically managed care for intractable pain patients, because it did generate some, what was surprising to me, some additional comment and discussion. I've gone back and listened to the recording and saw that it was like 20 minutes in its entirety. I very much appreciated that both Dr. Krause and Dr. Thorpe had some substantive comments, and that Ms. Lawson, you indicated, you informed me of some of the board's plans for the future, which was very helpful. I would have thought that perhaps that would have risen to a level that it would warrant a mention in this report, and that was a little bit disappointing to me. Finally, I would indeed agree with Mr. Watkins that people who have urgent issues of great consequence, access to appropriate care for people suffering from the worst kinds of pain illnesses, we do feel a sense of urgency, and we do hope to get some answers and action. And I believe there may be a way that the program I have outlined for this small, very small group of tragically ill patients might be looked at as low-hanging fruit, and maybe there's a way to get there. Thank you to all of you. I do encourage and hope that these public stakeholder meetings continue. I thought it was very valuable, and I appreciate the opportunity to comment. Thank you.
Thank you for your public comment. Next up, we have Michelle Montserrat Ramos. Michelle, are you there?
Yes, I am. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. I am pleased that you're willing to implement my recommendation that I've been asking you to consider for years, and that is to create a video on how to file a consumer complaint. Consumer Watchdog is very interested in seeing this action through to completion. Please utilize the medical expert training materials that is already in your possession. These materials will give consumers the specific information they need to file their complaints that will address exactly what you're looking for in a complaint. In the past, board members have stated that they had to dismiss viable complaints because they did not have the information they needed. Giving consumers information you need will help you and your enforcement staff, and that information is in the medical experts training material. We're also pleased to see that you're willing to create a complaint tracking system. The complaint tracking system is really simple. Dr. Yip came up with the idea first. Model it similar to Amazon's or the post office's package tracking system. The family has a tracking number included in their initial correspondence with the board. The tracking system will tell them that their complaint is with a CCU analyst or it's with a medical consultant. A medical consultant has closed the case or has been referred to a field office. It is with the investigator, it's with a medical expert, etc. Please make sure that it includes tracking through the entire enforcement process and not just the initial stages of enforcement. Thank you.
Thank you for your public comment. Next up, we have Helena Popovic. Helena, are you there?
Hello, yes, thank you. I think the video would be a great tool. I would have appreciated something like that. I did give very comprehensive information when I filed my complaint, the one that I was referring to earlier that had to be reopened, was closed prematurely and was reopened. In my case, my understanding was the information I provided was actually not looked at. So it was there, but not looked at by the expert. That's my understanding. But I do think that a video is required. I have a background in law, so I know the kind of information someone would be looking for, but another person who doesn't have that background wouldn't know what to provide. The other thing I want to bring up is there's I don't understand how the public letter of reprimand system is actually serving the public. There was one doctor that I was trying to look up. This was all in connection with my case because there were some interrelated cases. And I called the medical board and asked specifically why a doctor had been reprimanded. And I was told by the enforcement analyst that he could not tell me. And I said, well, I don't see how that's protecting the public if the doctor has actually had some kind of discipline and you're not telling me any information. And he, just was very dismissive of my concern. I ultimately did find out because I went to the courthouse and looked up the case that led to the public reprimand, the malpractice case. And there were some very concerning information within that court file. So I don't really understand that was a negotiated settlement, and the doctor pushed to have that information taken off his public reprimand file. So I just want to bring that up because I don't think that the public should have to go to the courthouse to try to dig up a malpractice lawsuit to find out exactly what happened in a case. That's all I have to say.
Thank you for your public comment. Next up, we have Hannah Reed. Hannah, are you there?
Yes, I'm here. Yes, I just wanted to state that I think we're making progress here at the California Medical Board. I just got off the call with the Hawaii Medical Board, and my hope is that whatever progress we make here, that it would be picked up by the other medical boards in the country and utilized, because we have to, as Mr. Prasifka had stated, we have to rebuild the relationship between physician and patient, and that many times the patient just wants to know what happened and wants a line of communication. So thank you so much. That's all.
Thank you for your public comment. At this time, Ms. Lawson, I do not see any additional requests.
All right, thank you. Sean, are there any additional comments or questions from the members of the board? All right, seeing none, I have 5:49 as the time. Could we plan to return at 5 after 6 o'clock for agenda item 10, which is the legislation agenda item? All right, we'll see everybody back in 15 minutes. Thanks very much.
I'm back, Christina.
Hi, Dick. Nice to see you. All right, we will try to get started in about 1 minute.
Taking a break was a great idea, Christina. Oh, I feel like a new person now.
I was looking for an opportunity to do it earlier, but
Wow, it's the
got-
final stretch.
got delayed.
We're gonna finish strong.
Yeah,
That's-
it's one of the problems, honestly. I mean, there's lots of problems with Zoom meetings, but one of the problems is that you don't have the normalcy of a meeting where, if you needed to get up and, go use the restroom or what have you, you just would, right? And so you just sit in front of the screen, and it's an odd phenomenon of Zoom meetings that people feel like they can't leave.
The
beauty of a Zoom meeting is you could be sitting on a commode.
You could, Dr. Krause, you could.
Well, I think that's a good idea.
It's nice to meet you too.
Hey Ryan, welcome to the club.
Thank you. I'm not quite sure what club I was getting into, but I think I'm glad to be here.
It's gonna be fun.
Working on some great things, which is great.
Ryan, I have to have my vision checked. Every time I look at you, everything in the background looks blurry.
We don't judge afternoon drink. Everyone else sees it's clear.
I believe that.
We have Sean and 4 staff. Are we on our way to a quorum?
I think we are getting there. We're just working on some staff's computer issues.
No problem.
So
We're
bear with
just
us.
going to do the legislative stuff, and that's the end of today.
I thought we tried to get through the whole agenda. Maybe.
And which one will we start tomorrow?
Power through, like when I was on the city council, we'd go to 2 o'clock in the morning or what have you. So we're just going to keep going. We start at 9 tomorrow, Ryan.
So I'll be late. I'll be at 9:20 tomorrow.
No problem.
Okay, great.
We talked a lot about PTL, so you wonder how much time has to be spent on that today. But
Yeah, tomorrow there's a fair number of, updates, that type of thing. And then some strategic plan.
Does the public get bumped off during this time, and then Sean invites them back?
I think no, I believe they can probably hear us speaking to each other right now.
I just don't see anybody on the side, so, okay.
I can see there are 52 current participants.
Oh, got it.
Yes, yes. So this is a live meeting,
Yeah.
but tomorrow's invite is completely separate, just so you know.
The world is listening.
Yeah.
I had a power outage, and it was 101 today.
Relocated.
Palm Springs. So
yes.
you can't have enough water or Gatorade. It's 85 degrees inside.
I don't know, Ron. I haven't even gone out. This meeting is getting to me.
It will be the same temperature for you, 101.
Stuck in this room, at least no mask on. So
yeah.
We do have a pretty impressive geographic representation at this point across California, although I guess we don't have San Diego anymore. We used to.
So when means when they were in person, Did you do a Northern California, Southern California rotation?
Yes. So, I mean, often, sometimes San Diego, sometimes, somewhere in the Los Angeles, Orange County region, Sacramento from time to time, and then sometimes somewhere in the Bay Area.
Ms. Lawson, I've been advised that we're ready to start when you are.
Great. We are ready to call the meeting back to order. And Sean, just to confirm the public, I'm assuming they were on the line just as our connections remained on the line over the break, but I want to make sure that nothing happened to their
the whole time. Yeah.
Great. Terrific. So we're going to start with, moving on to agenda item 10, which is discussion and possible action on legislation and regulations. And just for the new members of the board in particular, we will discuss each bill individually, and each bill discussed will need its own motion and then a vote. And we'll take public comment on each bill as well. And so we're going to go through them one by one. And Mr. Bowman, I'll turn it over to you then.
Thank you, Madam President. Good evening, members. Today we will be looking at a much heavier volume of bills compared to our prior meetings. The first item in your legislative packet is the tracker list, and you see some items in green and blue. The bills in green are those that we will be discussing today, and the bills in blue are being deferred. Just very briefly on the deferred items, the first AB 443, I was informed just very recently by the author and sponsor that they plan to substantially amend the bill to the point that it will be quite different from the one before us today. Therefore, we will update the board at a future meeting on that. AB 852 is a cleanup bill to last year's AB 890, which dealt with nurse practitioners. The bill this year addresses some details that were overlooked in the bill last year, but does not change the overall direction of that policy change that was signed into law by the governor last fall. AB 1273 is a bill that's still being further studied by the staff, as the impact to the board, if any, is unclear, and we will again update the board at a future meeting. Finally, Senate Bill 806, which was referenced earlier, will be the board's sunset bill. It is in green in the tracker chart, but only just in case it was amended at the last moment, but that has not occurred. So therefore, we're going to defer action on that bill, Madam President, as the language in there currently only pertains to physician assistants. So unless there's any questions, Madam President, I'm happy to move to the first bill for our discussion, which is AB 356.
That sounds great. Okay. Thanks.
Thank you. This bill authorizes but does not require the California Department of Public Health to issue to a physician or doctor of podiatric medicine a one-time temporary permit authorizing them to operate or supervise the operation of fluoroscopic X-ray equipment if they meet certain requirements. The author and sponsor note certain delays with the CDPH permit process and request this option to pursue a temporary permit while awaiting approval of their regular permit. The bill is sponsored by the California Podiatric Medical Association and the California Orthopedic Association. And I will turn it back to the board for any discussion or comments.
Move no position.
Thanks, Howard. Question, Mr. Bone. According to the report, that was our position. We had a neutral position in 2019 when a similar bill was proposed.
The policy topic was similar, but I think the direction of that was quite different. The Radiological Association, or Society rather, was opposed to that bill last year. I do believe there is an advocate on behalf of the sponsors who will be happy to provide some comments and may be able to kind of help round out our understanding of this bill before us.
Okay, so Dr. Kraus made a motion that the board take no position on this bill.
I'll second that, Dr. Lewis.
I have Dr. Lewis second that, and then let's move to public comment unless there are board members who'd like to speak on this.
Yeah,
public comment.
I do, Madam Chair. So, Aaron, what's the difference with this bill versus, I'm trying to read that stuff, what is currently a law for the fluoro license for DMDs and DOs?
Well, so as I understand it, they have to go and obtain a permit from the Department of Public Health in order to perform this type of procedure. And so because there are delays the details of which are not clear to me, but because there are certain delays at the department, that's why the sponsors are seeking a one-time temporary permit, would not be renewable, and they would have to meet the other requirements, which would include that they hold a valid license to practice medicine here in California, that they've already submitted an application to the Department of Public Health for their fluoroscopy certificate, that they've used that procedure in another state, and that they disclose to the department the facilities where they plan to practice fluoroscopy. I apologize if I'm butchering the pronunciation. So those are the requirements that seem pretty good. But this is a topic that goes a little bit beyond what we do here at the medical board, because we don't license this particular type of activity. That goes through the Department of Public Health.
Okay.
Question. Dr. Yip, question. For the temporary, do they require the exam to be taken?
They would have to apply. They would have to have a current application on file with the department. But I'm not clear on all the eligibility requirements that go along with that application.
So the reason I'm asking is there are very few painful exams for doctors to take. One of them is this fluoroscopic examination, which is nothing but physics. We all did. Anybody who does, I'm a vascular surgeon, so I do have fluoro license. And when we hire new people from other states, if I recall, no other state has this. This is a California special. And it takes so long to get this thing. And so why were they only doing the podiatry rather than, because of this emergency situation, why couldn't they do it to everybody in the end? Next time they do have to take that exam, they do have to have enough CMEs. That's a requirement for this license.
Those are good questions, Doctor. I wish I had the answer to them.
Yeah, I'm fine with no question, but I think we need to, if we're going to do this, I mean, my two endovascular surgeons, one came from Harvard, one came from Cleveland Clinic. They couldn't do anything for three months or 4 months in the radiology suite, even though they were doing nonstop at their places because of this exam you need to take, and they had tough time getting a date and whatnot. So, I mean, if there is a way they can give a break to everyone during this emergency, and then if we can eliminate it, that's I'll be the happiest guy. But it is you can't just give a break to only one segment of providers.
No, I think it would cover not only doctors of podiatry, but also physicians and surgeons.
Yeah. Okay.
Yeah. So I think it covers everybody, to my understanding.
All right. Additional comments before we move on to public comment? All right, Sean, let's please open up that line.
Okay, we have the Q&A window and the hand raising functionality opened up. Anyone like to make a public comment? First up, we have Kim Stone. Kim, are you there?
Yes, thank you so much. Can you hear me?
Yes, we can.
Oh, great. Thank you. Kim Stone of Stone Advocacy on behalf of the California Orthopedic Association. This bill would apply to all physicians who have used fluoroscopy in another state. California is one of only 2 states that require physicians to have additional certification beyond going to medical school to use fluoroscopy. And so what happens is, just as Dr. Ganadev described, when doctors come to practice in California who have practiced in other states, they don't know that they have to receive this additional certification, and that there can be a delay of several to many months to receive the permission to use fluoroscopy in surgery. And so what this bill would do is allow a one-time only temporary permit to use fluoroscopy in surgery while you go through the process of taking that complicated long test about the physics and patient safety behind fluoroscopy. And that way, when the physician who has already been using fluoroscopy in many cases for a number of years in their other state, they can continue to do so just this one time while they go through the California process to receive the permit. happy to, if there's any other questions, I'm happy to address those.
Question: Is any movement to actually do away that examination?
I mean, not in this legislation. This particular bill is only to provide that one-time only temporary permit while you go through the process, you know, to take that test and get the ongoing certification. And then as you know, there's also ongoing medical education required to continue to use it. So that's what this bill is about. I that, you know, I haven't heard other doctors complain about about the test as well, but right now this bill is only limited to just this one-time temporary certification.
Dr. Hawkins, how long does the temporary certification last? The duration?
So may I answer that? Right now there is no temporary certification. This temporary certification would only last until you had taken the test once, and if you pass the test, then you get the then you get the regular one that lasts for 2 years before you have to re-up.
And I'm sorry, I mean, it could last for 2-3 months until you get the official one, you're saying.
Okay. Yeah, it could last up to 12 months, but you have to be going through the process. So if the process takes less than that, it would only last as long as going through the process took.
So the limit is 12 months, right?
Right,
That's
let's,
the
yeah,
that's the upper
just,
limit.
Yeah, let me just stop the back and forth from the group, and let's see if there's another public commenter, and then we can go back to asking questions.
Okay, next up we have Bridget Grammy. Bridget, are you there?
Yes, but sorry, that's meant for a different time. Sorry about that.
Oh, okay. Thank you. This time that is all I see in queue for this item.
All right, let's now bring it back to the board for additional questions or comments.
So
Ms. Lawson, well, I think this is a good thing. And even in my own group, we had a interventional neuroradiologist who was unable to practice for a couple of months waiting for his fluoroscopy permit. I don't think it's important for the medical board to take a position on this bill.
All right, so your motion still stands.
Yes.
Howard, I was hoping that you change your mind and come up with a support. So, I mean, there is nothing in this bill which has any issues with the patient protection, and this bill streamlines the process. These are the people who are already doing fluoroscopy in the other states, and what we are doing is we are actually curtailing their training because they have to do this specifically for California. So I would support, actually, I would recommend support rather than no opposition.
So if we come back to our duty to serve the public interest, you would say that we serve the public interest to improve their access to these services. So in that case, I'm happy to either withdraw or modify my motion to request support.
I second.
Thank you, Howard.
So are you modifying or?
It's unclear what, yeah, I don't know what got seconded because he said he would either withdraw it or modify it. So let's withdraw the motion first.
I think that's the simpler thing for me to withdraw my motion.
So make a motion, we'll make a motion to support the bill.
Yeah, let's back up. Ron, do you agree to the withdrawal of the motion? You're the seconder.
Yes, I agree with the withdrawal, the second.
All right, so the neutral motion, the motion to remain neutral on the bill is withdrawn. Do we have a motion?
I move to support the bill.
Thank you, Mr. Watkins.
I second.
Dr. Lewis, the second. Is there additional comment?
Lawson.
Yes, Dr. Thorpe.
I mean, I guess we have to make sure that we're not wasting our powder, so to speak. And I think Dr. Krause's initial instinct was appropriate. I totally support this. I had the same issues that you've all had. I had my own license or my own certificate for a number of years when I was putting in pacemakers. But this is not I don't think it makes any sense for the medical board to support this legislation. It's a good piece of legislation. It should be supported. I hope it passes, but I don't think it needs our support to do that. And unless they come back to us asking for our support, I would recommend that we have no position. Mainly because it doesn't further our agenda. It doesn't help the medical board in any way. And it does help doctors, and that's important. But I think what we're trying to do is support legislation that is actually going to be something that the medical board needs to do in order to actually see our mission statement accomplished.
I disagree
with Dr. Thorpe. Let me tell you why. So you hire a person in California. It could be any institution, including all the university hospitals. So is ours now. So that person, the reason you hired that person is actually he or she can perform procedures which they've been performed on the consumers in other states with well-qualified people. In California, it takes 3 months is the lowest, shortest time it takes. It takes up to 6 months for them to do. So you are actually not able to provide necessary care by a qualified person because of this requirement. So that's why I think it is important to support.
I'd just like to just say, I won't say anything more, but I agree with you, Dev. I totally agree. I think it's a great bill that should be passed, and I think it will be passed. I think we have to consider, why are we supporting pieces of legislation or opposing pieces of legislation as a medical board? There's a reason that we do that. We put our weight behind a bill because it advances either our mission statement or our vision. It advances our perspective on the medical care in California. This is an important thing. It's good for doctors, and I totally support it. But I don't think the medical board has, I would just oppose the medical board having a position of support for it. I don't think it's necessary.
Can I ask for Mr. Bones' recommendation?
Add something?
Yeah, go. Yeah, if anybody else has, go ahead. I do have an answer.
Time out. No, we can't all talk at the same time. Dr. Mahmood.
Yes.
What happened?
He lost his fluoroscopy permit.
Dr. Mahmood, we can't hear you. Dr. Mahmood, something's happened, so.
Aaron?
Okay, I think I'm back on. The reason I think we need to support this bill is there are certain places who have only 1 or 2 providers who can do certain procedures which require fluoroscopy. And if there are only 2 people and 1 person is hired and another one has to wait for the thing, the delivery of care would be hindered and people in California will be affected by that. And we are making sure that that person who is doing it has already applied, fulfilled the requirements, has been performing other places. And if we can be a tool to be more supportive of the bill to get this bill approved, it would be a good service for the state of California. And people don't have to wait for so long. And there are so many small places. There is only 1 vascular surgeon or 2 vascular surgeon. One goes on a vacation, it won't happen. Or some radiology procedures, the pulmonologists and cardiologists, they won't be able to do it if they have to wait that long. So I think the need and reason is very obvious that we should support this bill.
And I want to add to that, the access component at no downtime, the access component is part of what the board's mission is in terms of public protection, because we would put Californians at risk if they do not get it in a timely manner. And so since I made the motion, I fully support it, and I think we have, if there was nothing in it for us, the citizens of California, then go on a neutral position. But there's actually something for the the public in this.
Agreed.
All right, we already took public comment. We've got a motion on the table. Is there any further discussion? All right, let's move to a roll call. I'm sorry, what? I'm sorry, who was that?
Lori, quick comment.
Please.
I think along the lines of Dr. Thorpe too, just from a strategic perspective, it would be helpful to know, how do we think about when we yield our power, our support. That's helpful. But with this legislation specifically, I do agree with the access component that it does promote that side of, our mission. So, thank you.
May I ask
Additional
Mr. Bohm to comment if we weaken ourselves by supporting something that doesn't need our support?
Generally, I would say no. I don't think that weakens the weight of the board. I think a bill like this is related to our mission because it deals with the practice of medicine, albeit in a very specific way. So if the board, if the consensus of the board is this is a way that's going to help patients get access to folks who are otherwise qualified to provide this care, and that any risk of patient harm is modest and appropriate, then I think a support position is perfectly acceptable.
Thank you. Thank you.
Right.
Ms. Lawson, I just want to make one other comment, and that is the last time this came through, the Radiology Society opposed it. I'm sure it was a turf issue, but that may come up again, and that's my only point is I don't think there's a reason for us to really weigh on this. I think it's a good bill, and it'll get support, and it should pass on its own. I'm not sure that we need that to give it support unless they ask us for that. And if they ask us for it, then I think it's a great bill, and I would be willing to give it. But I feel like I'm a voice crying in the wilderness, so I will.
All right.
Thank you.
Additional comment? Let's move to a roll call vote on this one.
Mr. Brooks?
Aye.
Ms. Campoverde?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Ms. Lubiano?
Yes.
Dr. Lewis?
Aye.
Dr. Mahmood?
Yes.
Mr. Ryu?
Yes.
Dr. Thorpe?
I'm going to just register my abstention.
Mr. Watkins?
Aye.
Dr. Yip?
Aye.
Thank you.
Thank you. So we'll move on, Mr. Bone, to the next one. I would just ask the board if we want to get through all of these, we need to expedite our process, and I don't want to limit people's time to comment, but if you agree with what somebody else said, I would urge you to just agree with what they said, because at the current rate, we're going to be here for 4.5 more hours, and that's a long time for this evening. All right, Mr. Bone.
Thank you, Madam President. AB 359 authorizes applicants who took more than 4 tries to pass step 3 of the US MLE to qualify for licensure in this state, provided they hold an unrestricted license in another state and meet additional qualifications. This bill also adds specified subjects to the list of courses that a licensee may take to meet their continuing medical education requirements, also referred to as CME. As discussed in the analysis, there are multiple pathways to obtain a physician license in California, including for those who have a license in another state. For many first-time licensees, they are generally required to pass the USMLE Step 3 after no more than 4 tries. For those who required more than 4 tries, they would be able to apply those test results if they meet the following other requirements as described in this bill. 1, they hold an unrestricted license as a physician and surgeon in another state. 2, the board determines that no disciplinary action has been taken against the applicant by any medical licensing authority. And 3rd, the applicant has not been subject to adverse judgments or settlements resulting from the practice of medicine that the board determines constitutes evidence of a pattern of negligence or incompetence. The second portion of the bill relates to CME, which significantly expands the types of courses that a physician may take to meet their CME requirements. Current law limits allowable CME to courses related to direct patient care or those that improve the quality of care provided to patients. This bill would expand allowable CME courses to include new topics, including practice management content to improve services to patients, management content related to billing, and educational methodologies used when teaching in a medical school. Under the bill, it appears a physician could continue to renew their license without taking any coursework related to direct patient care. The bill is sponsored by the California Medical Association and Choice Medical Group. I will turn it back to the board for consideration.
Questions or comments from the board?
Because it deals with licensure, I think we should have a position on it. But I see some good in it and some questions in it. So.
And to clarify, Doctor, if I may, when the analysis says that the recommendation is none, that's indicative of the staff not having a recommendation rather than the position should be none.
I see.
I wanted to clarify that.
So it's nice to improve access by allowing a pathway for more physicians to practice here. On the other hand, you might say there's something questionable about the qualifications of somebody who can't pass the USMLE after 4 tries. And I'm a little bit uncomfortable about the ability for somebody to meet CME requirements without having to do any CME that actually involves patient care. So
one thing on the USMLE aspect, Doctor, I just wanted to include is that USMLE is implementing a new attempt limit policy, and that beginning July 1 of this year, the limitation will be no more than 4 attempts, which would match what we have in current law. So at that point, you would, I guess you would be out of luck and you would not be able to continue to take it after that many times.
So I agree with Howard on this. The only thing I would suggest is I do agree with the issue about CME, and I think we should support if amended, meaning that we should ask for a certain amount of CME to be related to direct patient care. And I would say, I don't know, my thought would be 50% of the CME should be directly related to patient care.
Minimum.
No, Howard's position sounded to me like an oppose unless amended position.
Madam Chair, I will I abstain on this one because I think someone called me on this one. So I will not participate in the discussion or in the vote.
Okay.
My concern with this bill is that do we actually reduce the integrity of the licensure process by allowing this? Because the point that Dr. Kraus made is that if you can't pass it within the certain time frame, then we're getting a subpart out of the system, and that's why I would oppose this.
Aaron, do we know why this bill came into being? What the unmet need was that the author saw?
Some of that is a bit unclear to me. I think a big question that I don't know the answer to is how many people might qualify to be newly eligible for licensure under this bill. I have to imagine that's a very small number. As we noted in the analysis, there's actually a fairly high passage rate for step 3. I think the first time test takers, they tend to have a 97% passage rate. it drops for repeat examinations. So I think we're talking about a pretty discrete group of folks here. With regard to the second portion of the bill on CME, I think the sponsors, they noted, and I hope they'll be able to, speak when we get to public comment. They noted some elements pertaining to, COVID pandemic and how that has kind of exacerbated certain needs. And I think probably the policy choice before the board might be, do you take a more expansive look at the way CME may benefit a provider as they are providing their, going about their work? And if you believe that these types of broader CME courses will, although they won't provide necessarily support in the direct patient of care, but there may be indirect benefits to patients through the improvement of their practice, for example, or through the supporting of medical education. So I think that's probably the policy question before the board is, do they feel that that's an appropriate and suitable place for CME to live?
Aaron, Dr.
Yes.
Lewis, what are the, when you had a discussion, I think with the COS of Cooper, who's the author, right? Or is the author Smith?
The author is Cooper.
Cooper. So you had a conversation with the COS of Cooper for the reason behind all this? I'm not clear.
No, I had some interactions with the sponsors, just a couple of interactions with the sponsors with the California Medical Association.
Oh, not with the assembly person.
That's correct.
Ms. Lawson, may I speak?
Please.
There is already a pathway, as Mr. Bones said, that would allow someone who did not pass the USMLE within 4 attempts to be licensed in California. And so what this does is allows someone who did not pass within that specified period of time and who has not met the other requirements that currently exist to get licensed in California. And so the other pathways require them, for instance, to practice in another state for at least 4 years. What this legislation would do is allow them to get licensed in California immediately if they have a license in another state. And so these protections on paper that says that they couldn't have board discipline in the other state, it's not going to be tested in every case because they can get licensed immediately in California once they're licensed in the other state. Provided they meet the other licensing requirements.
Okay, thank you.
The other item that I wanted to add with regard to, I think, Dr. Lewis's question has to do with the CME portion. And so I'm refreshing my memory on the fact sheet on the bill, and it speaks to the Accreditation Council for Continuing Medical Education, that there are some, that they and other states allow a similar definition of CME activities, and allows those activities to be broad and include practice management content, as those topics, they say, can serve to assist physicians in carrying out their responsibilities. So again, I think the question is a direct patient care or a more broader, expansive view of CME, and I think that's the policy question.
Dr. Mahmood, can I speak?
Please.
So this bill has 2 different parts. One is to be eligible to get licensed in the state of California. And the second part is to maintain the license, totally 2 different scenarios. I think most of the people are agreeable what the requirements to get licensed, but to maintain license, not to have direct patient care, direct patient care CME is a very strange thing. I don't know why they combined both the requirements into one bill. I will oppose if this is combined, taking CME without direct patient care, because medical board's prime job is to keep the quality of healthcare, and quality of healthcare cannot be kept at the level until you make your physicians to take continued medical education so they know what is going on latest, or you make them, force them to take those courses and be up to the level and up to the par. So I think either they should divide the bill into two or we should oppose it.
Are you willing to make a motion?
So
I'm willing to make a motion on this to oppose if it stays the way it is.
And I second.
Got a motion by Dr. Mahmood, second by Mr. Watkins. Is there any further discussion, or can we go to public comment?
Can you read the motion again? Some of it fell off.
The motion to oppose unless amended, Dr. Lewis.
Okay, now clear. Thank you.
To clarify, the unless amended would be to divide the bill in two. Is that what was stated?
Our continued medical education should be with the direct patient care.
All of it or 50%?
The concern is that unless it's amended to address the board's comments, that the CME requirement should have a strong focus on patient care.
Direct patient care.
Well, so that is the thrust of the bill with regard to CME, which is to, again, have this more expansive view of CME and no longer be limited only to direct patient care. So that's why I wanted to clarify, because if we're asking them to amend the bill to do something that the bill would no longer do in any way related to what they are proposing to do, then an opposed position may be more appropriate.
Okay, then I'm not sure we all have an understanding of what the CME piece part of the legislation is doing. So perhaps you can go over that with us again.
Sure. Happy to.
Would it be appropriate to take public comment? Because I suspect there's someone in the public queue that has a vested interest in this bill. Maybe they could answer some of those questions that we're asking before we actually make a motion. And I've had that happen before. I've made motions and then somebody in public comment actually made a very cogent remark, and I've had to withdraw my motion on
good idea
one occasion.
And just to be clear, what I'm reading in the report is that they can maintain their license to practice exclusively through coursework unrelated to direct patient care. So perhaps I just left one word out of what I said, right? Which I think that what Dr. Mahmood and Dr. Hawkins were saying was that they wanted a CME requirement that included direct patient care in all circumstances. So there wouldn't be a circumstance where you could keep your license without having done the CME with direct patient care, which is apparently what this provides for.
I agree with your read, Ms. Lawson. And so the idea that was one of the ideas mentioned of having a certain limitation, 50%, 25%, that sort of thing, that might be a way to go.
I believe that's what Dr. Hawkins was recommending.
Exactly.
So I perhaps inarticulately tried to wrap the motion up in a bow. All right, let's do the public comment.
The other concern I had regarding immediate licensure in California upon licensure in another state is, could that be used as a way of getting around our 3 years of required postgraduate education?
It does not waive that requirement.
Okay. To the public.
Sean, let's open it up for public comment, please.
Sorry about that. I had too many windows in the way. I do have the public comment windows open here and the hand raising. Anyone would like to make a public comment, please do so. Give it a few more seconds here. Okay, this time I don't see any requests.
All right, we'll bring it back to the board. We don't have any public commenters in the queue.
The other peculiarity is the bill has an urgency clause. And I'm not sure of the necessity of the bill, much less its urgency. So I'm really left at a loss to explain the birth and the conception of this bill. You know, what great unmet need is being satisfied by it.
That's where the discussions with the author would come in of why they propose this bill.
So in looking at the fact sheet, they speak to the pandemic as a reason why we need to facilitate bringing in additional physicians to qualify for licensure here. Cited the shortage of licensed physicians in California as evidenced by the passage of AB 890, and talk about, anyway, I'm skimming, but those are the types of hurdles that they.
So that seems to me, I'm sorry, I thought you were finished it, but I think it was
I'm wrapped
choppy.
up. Yeah, go ahead.
I mean, this seems to me to be a bill to modify CME requirements wrapped up in a COVID, some reason why we should, you know, have more doctors in the state because of COVID. I mean, it's just the connectivity between these two issues in the legislation doesn't seem to make a lot of sense to me.
Yeah, this doesn't make sense, and so we should oppose this.
Exactly. This doesn't make sense at all. And I think there's some, I don't want to say that, but there's some vested interest or whatever, but they are kind of embedding something in broader thing, and which should be opposed. And I'll still stand with my thing that we should oppose this bill. Nothing else.
So we did have a motion on the table to oppose unless amended.
Who made that original motion?
Dr. Mahmood.
Oh, I thought his motion was to oppose.
Oppose.
Okay.
So just straight oppose.
I'll take it.
It's been made to us in the past, Aaron, that when we take an opposed position, we're kind of removing ourselves from the opportunity to discuss how the bill goes forward. So what do you advise us, Aaron?
Well, the short answer is, I guess it depends, but the board seems to be unclear as to where, you know, where the bill is trying to go and the problem that the bill is trying to solve. And so if the board doesn't have an idea to, not an idea, if the board doesn't have a position that would include a pathway for them to earn the board's neutrality, so to speak, then oppose makes sense in those conditions.
But the author can still approach you to discuss it.
Oh, absolutely, absolutely. And then, you know, they'd be free to, you know, we could bring it back to the board at the next meeting, and then would be able to, you know, discuss it, and the board could consider revising its position.
Hey, Aaron, I got a quick question for you. So how structured does that work with the board? Because say we oppose it today, or whatever, take whatever position today, author comes over, new information, everyone's happy, but the deadline to move it through committee is coming up in the next 3 weeks, right? And so
That's true.
So we're not going to have a board meeting, you know, prior to, you know, this bill being heard, because they'll be on recess. They'll be gone. This year's over.
We would come back. Our next meeting would be, I think, just before the summer recess ends. So there would be a few weeks left of session. But your point is a good one, Mr. Brooks, in that there's not much time, wouldn't be much time left in the legislative session.
Yeah.
Ms. Lawson, this is Dr. Thorpe again, and I agree with Mr. Brooks, and I think there is a reason to either, I mean, I think the best position would be opposed unless amended, because it would allow Aaron the flexibility to negotiate on the bill, and it would allow us to get some of these changes we want if we wanted to have, a percentage of CME be related to direct patient care. I think that's a very good idea. If we had some other stipulation that we want in the licensing part, I would say oppose unless amended, and then we can negotiate on it.
Well, so it's one, you can always negotiate. Just because you oppose with amendment doesn't mean, negotiations off the table. The biggest challenge that I see with this bill is, I'm not quite sure what problem it's trying to solve when we have a 97% success rate on the tests. Right? It sounds like someone's cousin missed out to get this bill, through. I mean, I'm trying to see what the, public of this is. I understand it. It's not with an analysis.
Well, that part actually makes sense. Sorry.
If we're talking about saying oppose unless amended, are we really clear how we would amend a bill that we're not completely sure what the purpose is and so on? And I think it's also telling that there's no one here speaking on behalf of the bill.
Well said.
So we do have a motion to oppose on the table, correct? Dr.
Yes.
Mahmood
Yes.
as the maker of the motion, and Mr. Watkins is the seconder, I believe.
Yes.
Are we ready for a roll call vote, or is there further discussion? All right, let's move to the roll call vote, please.
Mr. Brooks,
Yes.
Ms. Campoverde,
Yes.
Dr. Gonadev,
Abstain.
Dr. Hawkins,
Yes.
Dr. Kraus,
Yes.
Ms. Lawson,
Yes.
Ms. Lubiano,
Yes.
Dr. Lewis,
Aye.
Dr. Mahmood.
Yes.
I believe Mr. Ryu left.
Yes.
Okay. Dr. Thorpe,
Yes.
Mr. Watkins,
Aye.
Dr. Yip.
Yes.
Thank you.
Yeah, just for clarification of the record, Mr. Ryu did indicate to me that he needed to leave in order to make it to a 7 p.m. meeting. So he left just a few moments ago.
Christina, can I make a comment? It
Please.
is so difficult to stay off the discussion when you know the person why they're asking for and you know the reason. So it's the first time I felt that, boy, I can't participate. So I just had to tell you that.
All right. So if you want the backstory, talk to Dev.
Shall we move to the next bill, Mr. President? The next bill is AB 562, which requires the Department of Consumer Affairs to establish a mental health resiliency program for licensees of certain healing arts boards that have or are currently providing care to patients with COVID-19. The medical board, the osteopathic medical board, along with the Board of Registered Nursing, physician assistant, and respiratory care board would be included in the program, DCA would, in consultation with those boards, contract with vendors to provide mental health services to eligible licensees. Each board would receive applications for this program, and it is expected that through pro rata, each board would reimburse DCA for the related costs. I've had a very positive and productive dialogue with the author's office, who is well aware of the board's financial position. They indicate that they are pursuing funding through the state budget or other possible sources to cover the costs of this program. One area that I wanted to draw the members' attention to is a suggestion that the bill be amended so that the applications are taken directly by the contracted vendors. Staff feel that that may boost participation and may ease concerns that a licensee may feel with requesting mental health services through the regulatory board. Staff recommend a support if amended position to request that applications be received and eligibility determined by program vendors, and that funds outside the board be secured to pay all program costs. I'm happy to answer any questions, Madam President.
I would so move to support if amended as you just described.
I will second it, Dr. Lewis. Agree.
We got a motion by Dr. Kraus and a second by Dr. Lewis for the staff recommendation. Are there any comments or questions before I take public comment?
I don't know what exactly it means. I thought we have residency programs in the MD and DO. So what is this all about, and tell me why this came up? I'm just curious.
Yeah, so it came about, I believe it's sponsored by the California Medical Association, and the bill is intended to be a response to the toll that the pandemic has taken upon the profession and other professions as well. It's supported by some nursing associations, the Society of Anesthesiologists as well. And so I think in recognition of just the difficulty that the pandemic has had on healthcare professionals in general, the desire was to pull together and fund a program that would be able to provide care to those professionals if they sought to seek that out. It would be funded by either the board's fees, or they are pursuing an appropriation through the Budget Act. So in that case, if that's successful, it would be, funded by, by the taxpayers. But again, as I've dialogued with the, with the author's office, this is the chair of the Assembly Business and Professions Committee, Mr. Lowe. So he's very well aware of our financial position and our role. And so we think the supportive amended position helps to sidestep some challenges that the board may face.
So does the fund come from the tobacco tax proposition, which funds new residency programs in primary care?
Well, so right now the bill is silent on the funding mechanism. And so typically when, since the program will be put together by DCA, that means then the boards fund it through pro rata payments. So that would be the norm with how a program of DCA would typically be covered. But again, the author is very aware of the costs, potential costs that are associated with that. And they're eager to try to reduce the cost of the program whenever they can. And again, since they know our fund condition quite well, that's why they are, pursuing sources of funding outside of the board's control.
So I'm pretty sure they're aware of the tobacco tax proposition funding, because many hospitals in California received that for primary care, residency, ER, and one other women's health. These are the ones which are being funded for the new programs or expansion of the program. So maybe that's a venue it will be another competing program going into that, but it did help in creating new programs. So that might be, rather than this board is totally broke, there is no money here. So that's what worries me.
Yeah, no, they know that, Doctor, and so that's why I was encouraged when they shared that they are looking at at other sources of funding as well. I don't believe whatever program that ends up going forward, I don't believe it's going to be paid for by our board. I think that they're going to be able to find other sources of funding.
Okay.
But again, the supportive amended position would support that, which would be to in part find other sources of funding to cover the costs.
Okay.
All right, are we ready for public comment? All right, Sean.
The Q&A window is open. If anyone would like to make a public comment, please indicate so or raise your hand. At this time, I'm not seeing any requests.
All right, we'll bring it back to the board. We have a motion. And now I'm forgetting who made it. Dr. Kraus.
Yes.
A second by Dr. Lewis on the table. Is there any further discussion? All right, seeing none, let's have a roll call vote, please.
Mr. Brooks?
Yes.
Ms. Camporoni?
Yes.
Dr. Bonadette?
Yes.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Yes.
Ms. Lubiano?
Yes.
Dr. Lewis?
Aye.
Dr. Mahmood,
Yes.
Dr. Thorpe,
Aye.
Mr. Watkins,
Aye.
Dr. Yip.
Aye.
Thank you.
The next bill, Madam President, is Assembly Bill 1102, which would clarify that a telephone medical advice company must comply with directions and requests for information from not just DCA, but also any licensing board that has jurisdiction over the type of advice being provided. When the Telephone Medical Advice Services Bureau was abolished in 2017, enforcement responsibility was transferred to the various boards that regulate the individual licensees who may be involved with an entity that provides medical advice services through the telephone. However, the requirement for those entities to comply with DCA directions was never updated to include complying with directions of the various boards. This minor bill corrects that oversight and also clarifies that out-of-state licensees must also comply with the requirements of their respective license. Staff have a support recommendation, Madam President. I'm happy to answer any questions.
Thank you. Well, this sounds like a good idea. Do any other members of the board have any
Yeah,
comments?
I do have a couple questions. So I do have a couple of questions. I mean, how do you enforce this? How do you enforce across state lines? How do you enforce from Canada? How do you enforce from any other place that is providing this type of service? And I just say this from my experience back on the Board of Pharmacy, where we were trying to, regulate mail-in prescription drugs. And then, we had everywhere, and we had no way of enforcing it. How is this different, Aaron?
I'll let my colleagues correct me if I misspeak, but I believe in general, if we receive a complaint about an out-of-state licensee, then that would often include a referral to the appropriate licensing board from that state for them to take appropriate action.
So the challenge, though, Aaron, with that is that becomes a reactive phase, not a proactive phase, because there's so many different companies and so many different shell names, and if we feel comfortable enough, we can regulate this. I think it's a great idea, 100%.
Well, so we're already so maybe back up and I'll provide a little bit of context. So this bureau that doesn't exist anymore regulated at the time when it went away 68 service providers of these telephone medical services. when the legislature just allowed that to sunset, and then turned over to the individual boards the responsibility to essentially regulate the individual providers that may be practicing within those different service providers. So there is no coordinated regulation over the business entities themselves. Rather, if we got a complaint about a physician who was engaged in this activity in San Francisco, not to pick on your home city, then we would conduct an appropriate investigation if they were violating the law as it pertains to the telephone medical services. So that's the way the law works, as well as for nurses or osteopaths, or you pick the type of licensee. Does that help as well, Mr. Brooks?
Yeah, I understand. Thank you.
Aaron, I would move to support, and I want to say that this is not really changing or modifying the law. Existing law requires that if a patient is in California, that the service provider must be licensed in California. Yes. This just replaces the loss of the telephone medical service agency and restates existing law.
A very minor clarification.
The big jeopardy is not the individual practitioner who is taking a phone call in South Dakota, but that telehealth has become a large for-profit corporate entity, and if we don't assert our right to oversee the practice of medicine in California, it'll be viewed as a weakness by the telehealth corporate structure that they will rush to take advantage of. So I think this bill is important to clarify that we still observe existing law.
And I'll second Dr. Krause's motion. I think, Howard, you made a motion, right?
Move support.
Yeah.
Thank you. Yeah, I mean, to me, this is closing a loophole. The loophole that currently exists is that they don't have to respond to our requests for one reason or another. It's not that they're not already regulated, it's just that they don't need to comply with our directions or our requests, which seems to me to be Aaron, I think if you described it, an oversight when they disbanded the previous board.
That's great.
Other
The
questions?
No, thanks
Other
for the
questions or
clarification. Yeah, I'm in support.
Thank you. Let's go to the public, please.
Okay. Let me mute this microphone. The Q&A box and the raise your hand function is enabled for anyone wishing to make a public comment. A few more seconds here. Okay, we have Hannah Ree. Hannah, are you there?
Yes, hello, Hannah Ree of Black Patients Matter. I just wanted to make a general comment about, again, the progress that the Medical Board of California has been making with Mr. Prasifka on board and the other new board members present is so exciting for our group, Black Patients Matter. I just got off a meeting with the Hawaii Medical Board, and I was the only participant, and I was told to not be so political as I attempted to advocate for Black health. So I just want to thank you again, Medical Board California, for being so progressive. Thank you.
Thank you for your public comment. At this time, I don't see any other requests in queue.
All right, we'll bring it back to the board, and we've got motion by Dr. Kraus, a second by Dr. Lewis to support. Any further discussion? All right, seeing none, we'll move to a roll call vote.
Mr. Brooks.
Aye.
Ms. Campoverde.
Aye.
Dr. Gonadev.
Yes.
Dr. Hawkins.
Yes.
Dr. Kraus.
Yes.
Ms. Lawson.
Yes.
Ms. Lubiano.
Yes.
Dr. Lewis.
Aye.
Dr. Mahmood. Dr. Mahmood. Dr.
It
Thorpe.
appears to be off screen.
Dr. Thorpe.
Aye.
Mr. Watkins.
Aye.
Dr. Yip.
Aye.
Thank you.
Next, moving to Assembly Bill 1278. This requires a physician who receives a payment or transfer of value from a drug or device company on or after January 1, 2014 to disclose that amount in writing to their patient or the patient's representative prior to the intended use or prescription of that drug or device. The bill also requires physicians and surgeons to post a notice in an area likely to be seen by all patients who come to their office that informs them of the Federal Centers for Medicare and Medicaid Services Open Payment Database. This database discloses payments made to physicians from medical product manufacturers. Failure to comply with the requirements of the bill would constitute unprofessional conduct. The bill is sponsored by the Center for Public Interest Law and has opposition from certain physician organizations. I expect the board may hear from both sides today during public comment. Staff recommend a support position on the bill, Madam President, and I'm happy to answer any questions.
Aaron, I'm concerned that there should be a bar above which the reporting should occur. I looked up my own name in the Sunshine Act, and in 2019, I received a little over $4,000 from pharmaceutical companies. Interestingly, about 3,700 of it was for some consulting work I did for a pharmaceutical company that was looking at ophthalmic side effects for a cancer drug that I don't prescribe. But I would look at the other ones, they range in value from $21.51 to $45, which relates to receptions I went to at national meetings that were sponsored by drug manufacturers. And I don't even remember what drugs these companies have. So for $21.51, I shouldn't have to have my patient sign a release recognizing that I received something of value from that particular company. So I would be in favor of introducing a dollar amount above which the reporting is required.
Additional comments?
So, Aaron, Dr. Ganadev, I tell all my house staff and my attendings, be very careful when there is a dinner or some reception, because they add all that stuff. And $40, there were so many people's name on for $40 for dinner. So nobody even knew that it was a educational session sponsored by the pharmaceutical company. I think I do agree on putting dollar amount, because I don't think a lot of people, because of my experience, I'm very careful in not going to any one of them and avoiding them, like residents' grand rounds. Many times the food is provided by them. And the house staff are happy because they're doing their presentation, but they get free food. So that's why this becomes a really big issue to put everything to be documented that way. It's an excellent intent, but practicality wise, there has to be some limit. Pick it up and let the author pick up whatever limit he or she thinks is the right amount, because otherwise young people or people who don't know what to do for educational session, they went to one of these meetings, their name goes on and they have unprofessional conduct, because that's what happened. So that's what my problem is. The intent, I totally agree. I think it's important not to get these guys bias out. It's extremely important. So that's why, and the biggest problems in the country with these things are people getting paid hundreds of thousands of dollars by pharmaceutical companies, and they're going around and recommending the products. That's where the problem is.
Deb, I just figured out why you're skinny and I'm fat.
We support if amended, and Aaron, you will then work with the author and we'll come up with a cap dollar amount.
Well,
that way.
It would sure be helpful if there was a dollar amount that the board, if that was the direction the board wanted to go in, it would sure be helpful to have a dollar amount that I should be aiming for.
For each payment or for in total your year?
No, from the pharmaceutical company in question.
Oh, one company. Okay. Well, you could put like $1,000. I don't know.
So if I'm prescribing a drug that's produced by Bausch & Lomb, and I went to dinner at Bausch & Lomb's expense, I shouldn't have to explain that to my patient. But Aaron, I would suggest $500, but I don't know how the rest of the board feels. Maybe it should be $200.
May I speak? Dr. Cross, if you're going on a dinner with one company, can I talk? If you're going on a dinner with one company and there's a different company every week,
that's why I weigh so much.
So dollar amount should be a number of amount of money you can get for the whole year. So it's not like people, I mean, I'm just putting you at just a little sarcastic, but there are people who literally go to these dinners every week or every month. And there are people who are enticed to do this thing. They invite their friends because they are a speaker and they get free good dinner and wine. And then that person gets some stipend on top of that. And he's the main beneficiary. But I think there should be a total dollar amount for you to be able to be compensated for the whole year. So not from just one company, everything.
I think we're part of this, which I don't think is necessarily the one we should be focusing on. I agree that we should have a dollar amount. I think it should be very low, but when we're talking about patient protection, this bill is at the very center of it. This is when we were saying earlier, we weren't sure if we were going to support a bill because it didn't necessarily rise to the occasion. This one's smack in the middle. If you think about the women who have breast cancer, who are sold breast implants, like there's so many physical implants that you want to make sure that people aren't being sold because of a prior relationship. So I don't know. I mean, you guys tell me, in my experience, doctors aren't going to these dinners every day. So, and probably should be a little busy with their patients to not be going to fancy dinners every night. So I think that we should look realistically at a low number that accounts for the fact that there is relationship building, but also is realistic about the fact that we're not also trying to make accommodations for people's social schedules.
Yeah, sorry, just on a follow-up comment. You're right. People are not going on dinners every night, and people who are going on dinners and kind of stuff, there's a very small minority, and this bill is basically for that minority. So you just try to control people who don't follow the law, who just are a little greedy. They are very small amount. Those are the people you make the law for, and without putting in a justified restriction, it is going to be abused.
The Form 700 has a dollar amount, and perhaps that's a government form for when you have to report. So
that's a government form, and $50 if it's a reportable source. $50 is the threshold.
That it?
50, yeah.
Oh,
Yep.
well, we can't do that.
I heard Dr. Kraus propose 500. Is there anybody that objects to the 500 number or thinks it should be lower or higher?
500 is good.
You know, I think back to I think back to a scandal that occurred at UCLA Orthopedics, where several of their surgeons were receiving hundreds of thousands of dollars from implant companies and using their implants. And I think that the intent of this bill is to prevent corruption and to prevent a perversion of medical practice where a physician is motivated to prescribe something because of financial gain. Receiving up to $500 of value from a pharmaceutical company is not likely to be a factor in what drug a physician chooses to prescribe. Receiving $10,000 certainly could be a factor.
Yes.
So you
Are we proposing $500 per company or $500 total for pharmaceutical companies?
I was thinking of it as being like an event. Now, I guess you could try to get around it. I mean, they could get sort of cute, but you know, for a particular reason. So for a dinner, it could be that, or they give you a plane ticket to go somewhere, or they, you know, provide you just with straight compensation via stipend, anything over $500, but it would be per company, right? Or really per event.
Well, and to clarify, the bill speaks to the specific pharmaceutical company related to the device or drug that you're planning to prescribe to that individual patient. So I think tailoring it to a single manufacturer, and then if it's over, in this case, $500, then that triggers the reporting requirement, if you will, to the patient prior to you prescribing or intending for them to make use of that drug or device from that particular manufacturer.
I would agree with that. Otherwise, a circumstance where I did consulting work for a drug that I never prescribed would knock me out of the box and make me have to get a informed consent signed from every patient, even though it doesn't relate to the drug that I was doing research on.
And I don't believe that's the intent of the author or the sponsor, rather.
So the motion, I think I made a partial motion. So we support if amended, and we give Aaron instruction that the amendment would be $500 per event.
No, not per event, per company.
Company event. Well, company event.
Not event, per company.
Company.
Bids by one company, right?
Company.
Yeah.
If a physician has received more than $500 in value from a company,
one company, yes,
then the physician must divulge that to any patient that he is prescribing a device or pharmaceutical of that company.
This is one I would love to hear public comment. Official position.
I agree.
Agree.
Can I make a comment? Dr. Yip?
Please.
I have no problem either way. No problem notify the patient. I think it's fair and good. Just for the member and public who are not physician, In reality, actually, this relation is tricky. In my practice as a urology, the certain cancer drugs actually pretty quite expensive. And the drug company is willing to give us like 2 weeks supply for patients to try, while willing to get authorization. So in a way that we're no problem by the patient, but I think sometimes idealistically, we should separate ourselves from the pharmaceutical company, but sometimes we do need the help to serve our patient to get certain drugs, which are increasingly expensive. Thank you.
Yes, but if you're not selling those drugs to the patient, then you're not deriving any monetary value of it. The monetary value is really going to the patient, not to the doctor.
No, thank you.
And also, it's just saying you have to disclose. So you can still disclose and explain why it is you've chosen to use that drug, but it's saying that the patient has a right to know that there was that relationship. So it isn't prohibiting it.
That's correct.
All right, let's move on to public comment, please.
Okay, the public comment window. The public comment window is.
Comment before going to comment. If I can make a quick comment.
Please.
Instead of company, I was wondering if we might want to think about amending that to the word source, if that makes any kind of difference. That's all. Thank you.
All right, public comment, please.
Okay, the public comment Q&A window is open for anyone who'd like to make a public comment. Please indicate in there or raise your hand. First up, we have Bridget Crammy. Bridget, please go ahead.
Hi, thank you so much. So I just wanted to start by addressing some of the concerns that you've all raised about the dollar amount. And this is something that we've talked about quite a lot. And the problem, I mean, just to take a step back, as I really appreciated Ms. Campoverde's comments, because really the whole point of this bill is to empower patients with information that they need. And this information that's already publicly available, Dr. Krause just looked himself up. I mean, it's already available. And what we're trying to do is kind of find a balance, I guess, between making this overly burdensome for doctors. This is really not meant to be like a punishment or a shaming exercise at all. It's just to give patients and empower them with the information that they need to make their own healthcare choices. So if you look at the database, you can tell it's broken down by meals. It'll tell you Dr. Krause received $500 in meals from this company. I mean, it is broken down very specifically. And so at the end of the day, we ended up not putting an amount on just because it's hard to make, and it's hard to identify at what point does somebody become influenced, and we're not trying to make a judgment that doctors necessarily have a conflict of interest anyway. We're just trying to give patients information that they need, and they can look it up and find out that information. I'm afraid that if you say, okay, well, now you have to look at look at the database and now decide for yourself which ones you have to disclose and which ones you don't have to disclose. You're going to hear from our opponents, I'm sure you already will tonight, that this is going to be an administrative burden for people. It's going to be too difficult for them to figure out what they have to disclose and what they don't. And it's taking time away from patient care, which we don't want to do. So this way, we were just thinking you could print out, we received money from these particular companies. Here's a printout of the database from last year, and here's a reference to go check out the database, and that would do it. And then your patients can ask you questions if they want to know about it. But we're trying to minimize the administrative burden, give patients the information they need, and really trust them to make their own decisions about, I personally couldn't care less if my doctor went out to dinner with somebody. I'm able to make that decision for myself as a patient, whether I think that might have an influence over my treatment or not. So anyway, I had remarks prepared. I think it's probably better to just explain to you kind of our rationale about that particular thing and just emphasize that it really is about empowering patients and not about, trying to shame doctors for taking money. It's just something that's happening, and we think patients need to know this information. And so for the board, Ms. Campoverde is exactly right. This is exactly the kind of position you should be taking, a support position on something like this for patient transparency and protection.
Thank you for your public comment. Next up, we have Marion Hollingsworth. Marion, are you there?
Hello, I am.
Please go ahead.
Thank you. My name is Marion Hollingsworth. I'm a patient safety advocate. Part of this process, it all should be part of the informed consent process to know the risks and benefits of any treatment or procedure, and also to know any influences that could affect the care. It's my understanding that 1278 would cover both drugs and devices. It came out of a case where a patient was not told that a medical device that the doctor was going to insert into her was actually experimental and not FDA approved, and that he had a financial interest in it. So this covers any kind of financial link to a company, the way I understand it. Going back to what Ms. Campoverdi said, I totally agree. The patient does have a right to know, especially if something's going to be taken into their body in the terms of a device or medication. And how can we empower patients to make their own medical decisions if they're not given all the information? So not to shame doctors, but just to give the patients a chance to know what's going on, to know if there are any links. And some doctors may be influenced by a high dollar amount. Some could be, influenced over a turkey sandwich at lunch. So if there's some type of link to that drug or procedure, it would be in the patient's best interest to be notified. So thank you for your consideration, and I hope you approve 1278.
Thank you for your public comment. Up next, we have Hannah Ree. Hannah, are you there?
Yes, hello, Hannah Ree of Black Patients Matter. Look, we don't care about that kind of stuff. That's the waste of time and resources. Besides, most of us have either Medicare, Medicaid, a healthcare plan which dictates what medicines we can get, we can purchase. So, we have plans that have formularies and tiers. So, it's a waste of time asking doctors who's feeding you, why are you so fat? If you all pass this, you might as well call it the medical board diet. Because it's a waste of time. Look, we've got some serious cases and issues with the medical board, and this is not one of them. It's a waste of time. Thank you.
Thank you for your public comment. Up next, we have Virginia Parr. Virginia, are you there?
Hi. Actually, I think this bill is related to a woman that was hurt by a surgeon that received $500,000 from the company. And the device was not recommended by the FDA, and he failed to let her know that. So this bill is actually very important, and it'd be really nice if the backgrounds of the bills were known before they're debated. I'm not sure if this one is that one, but it's cases like this that make it very important to pass, unlike the previous caller's note. So anyway, thank you.
Thank you for your public comment. Up next, we have Emily Hughes. Emily, are you there?
I am here. Can you hear me?
Yes, we can. Go ahead.
Okay. Thank you so much. Emily Hughes with California Medical Association. I just want to say I appreciate all of your perspectives. We absolutely, wholly agree that the patient should be informed of this. And we are absolutely on board with posting about the open payments database. We think that that should be information that every patient should have access to, and they should be able to access that information if they are wanting to. Unfortunately, and like Bridget, I apologize if I'm saying the wrong name, said we are worried about the implementation. We are worried about when a physician is going to have the time to create this personalized document. So in the middle of a care visit, after I've decided what I'm going to prescribe for my patient, I'm going to need to leave the room, if there are multiple prescriptions, leave the room and create a document that has the information that I've received from company A, B, and C since 2014 before I return to the room, ask the patient to look over this information and consent to the prescription I am then giving them. We understand that that doesn't sound, when I say it, it might sound very simple, but as physicians, I know that some of you probably understand you're already under an immense amount of administrative burdens, and paperwork takes up a lot of your week. So we are concerned about the time that it will take, the time between patients, as well as the potential threat to that physician-patient relationship. Some people aren't going to be interested in this information. However, like I want to reiterate how supportive we are that those patients who are interested have access to the website, to the database, are informed. We would like to post it in the offices, but for those who are not, we believe that it may disparage doctors unnecessarily, because we know that you guys receive education from these things. This is not just money thrown at you. If there's a printout in front of a patient that just has a dollar amount, Dr. Hughes received X amount, and that's all that they see, that we don't believe that their care visit should be spent you explaining why you received that money. If that is something they would like to ask about, absolutely supportive of that. They have the right, you are the doctor, that relationship should be nurtured in that way, and they should be made to feel comfortable with whatever information they need. However, when there is no context to that payment, we are worried that a setting that should be focused solely on health, solely on health, would be reconfigured in a way that we are not comfortable with, and that we don't think that would help the patient ultimately.
Thank you for your public comment. Next up, we have Susan Lauren. Susan, are you there?
Yes, hi, thank you. I support this bill, and I hope that everyone knows the reason that it was created. Transparency is one of the most important things, and I can understand what the doctors are saying their concern is, but we're just looking at doing medicine in a new way now, because it's not working the way it's going. Too many people are being harmed and not having choice in the matter. So maybe I don't understand how this would work, but I was a professional organizer, and I really don't, I would just say post it in the office and explain on there, and you can say, look at that. If that's not possible, we can come up, or people can come up with other creative ways, because the idea here is to protect patients, which is not happening now. And also what I wish, it's not part of this bill, but a lot of doctors do question and answers online on websites like Real Self, and they get patients and money, and there's financial conflict of interest. And most of the women I know didn't know this, and we actually just trusted that they were, it sounds really bad, but my father was a doctor, and I'm sorry, I'm in a lot of pain, which is when I start not being able to, you guys know me well enough now to know that when I'm in a lot of physical pain, it's hard for me to talk, so it's embarrassing for me. But anyway, the meeting's going long. I support this, and I think that if we have human relationships with each other, that people wouldn't judge you for, in fact, I think they would think better of you that you did consult, I think it was Dr. Krause, that you consulted with them. If I trusted you and had a good relationship with you as a doctor, it wouldn't bother me at all. And anyway, thank you for your time. Bye.
Thank you for your public comment. Next up, we have Wendy Necht. Wendy, are you there? Wendy, are you there? Wendy Necht. Next. Wendy Knecht. Okay, we're going to move on. Eric Andrus, are you available?
I'm here. Can you hear me?
Yes, please go ahead.
First of all, I have to give my disclaimer that less than 1/3 of California's doctors are members of the CMA. and that a good portion of those are forced to be members of the CMA due to their local medical society, so they don't speak for all the doctors in the state of California. Perhaps Henry has never had to explain to a harmed patient that they had a financial interest in the harm that was caused to that patient. I don't think it's a waste of time at all that we have to explain these things. When we think about Wendy Connect, who is actually trying to call in right now, she is the harmed patient who received an implant in her body due to a doctor who had a financial interest in that part. Let's think about all that slew of doctors in Long Beach who were putting deformed screws in people's spines, and they all had a financial interest in the harm that was created. Let's all think about that. Let's cue the violins for them. You know, if doctors think it's such a burden to create a document to keep patients safe, perhaps they shouldn't be taking money from the pharmaceutical and medical device industry in the first place. Just don't take the money if you find it such a burden to have to create a document to keep patients safe. I'm so sick of the CMA talking about these burdens that these doctors have to go through. We're talking about people's lives, health, and the death of patients over these things, people. Let's stop feeling sorry for the doctors having to create a document and do things that takes time for them. Thank you.
Thank you for your public comment. Wendy Connect, I saw you put your hand down. If you're able, let me see if I can. Wendy, are you there? Wendy, I believe we can hear you. Would you like to make a public comment? Wendy, I just heard you say something. There? Okay, I'm going to go ahead and put the line back on mute. Okay, this time, Ms. Lawson, I don't see anyone else in the queue.
All right, let's bring it back to the board, please, for some further.
Oh, I'm sorry, Ms. Lawson had a last second hand go up here.
Okay.
Dan Savage, Dan, are you there?
Yes, I am. Can you hear me?
Yes.
Hi, my name is Dan Savage. I'm the Chief of Staff to Assembly Member Adrien Nazarian, who is the author of the bill. So I just want to add a couple of comments. I think Bridget actually covered the relevant issues in her earlier comments, but I did just want to read one section of the bill to make sure that everybody understands what the written disclosure that a doctor would be asked to provide a patient. It could be provided in the waiting room while they're waiting. It could be given by the nurse. It could be given by the doctor, but it would read, quote, "If you would like further details on the information provided above, you may discuss with Dr. Blank and or visit the open payments data at cms.gov, a federal tool used to search payments made by drug and device companies to physicians in teaching hospitals. So a physician and surgeon shall include in the written or electronic records for the patient a record of this disclosure, and the physician and surgeon shall give the patient or patient representative a copy of the signed and dated disclosure." Now, we thought that the doctor keeping the record, a signed record, would provide some protection, I guess, if you will, if a patient were to come back and say, "You never gave me this information." But the goal, the bottom line goal, the very fundamental goal of this bill is just to allow patients to know that the federal open records data system is available to them. As one of the doctors on the panel just looked himself up, I've looked up any number of the doctors that I visited. I never knew this database existed. So this is just an education tool that we're trying to provide. Now, we've talked to the CMA, we've talked to many of the other medical organizations, because we are trying to work with them to strike a balance between the administrative burden. And one of the things, and I don't want to put words in their mouth because they were just on the phone, but my understanding in the discussions with them is they didn't want a requirement, a minimum threshold, because that would create more burden. So what we're trying to do is just provide educational opportunities for all patients. We would require it to be posted in the lobby, and we would require a disclosure form, just like any of the number of forms that I fill out and all of you fill out when you go to your doctor. And do you have this ailment? Do you have that ailment? Check, check, check. So that's the goal of the bill, is just to allow patients to know that this database exists.
Thank you.
For your public comment, that was the last one in queue.
All right, thanks, Sean. I do have one question, and I don't know if we need to bring back Bridget potentially to answer it, but there was this comment, I think it was from CMA, and now I'm not recalling, but this comment that the doctor would have to leave the room, go fill out some type of individualized form, and then come back and provide that form to the patient, presumably based on whichever drug or intervention they were proposing. But what I'm hearing and what I think that the bill says is that this disclosure could be provided with the packet of other disclosures when somebody checks into the office, for example, and that it would disclose potentially, you know, all the companies or what have you, but that it would be done at one time, and it wouldn't be done once the doctor has had the visit with the patient and figures out what the treatment's supposed to be. She or he wouldn't have to run out of the office and get a new form and have it reprinted. Am I correct about that? And Aaron, perhaps you can answer because we've closed the public comment period.
So, not knowing exactly all, it's difficult to envision all the different ways that it that this might work, but in reading the bill language, it states that the physician who receives, you know, this payment shall disclose the source of the remuneration orally and in writing to each patient or patient representative prior to the intended use or prescription of a device or drug manufactured or distributed by the company. So I suppose if that were going to occur before the patient visits, you would need to have a pretty comprehensive document, potentially, depending upon all the different payments that the provider had received, and that somebody would have to tell them orally as well. So maybe that's the MA who's taking your blood pressure or whatnot, and that's a part of that. You know, that might be a way to be in compliance with the bill.
You know, this is Howard. I guess the devil is in the details. If indeed it's, as was expressed by the last caller, that it's simply a matter of informing the individual of the data being available on the web for their particular doctor, and that if they have questions, they may approach their doctor and inquire, you know, that's not burdensome. But if I'm going to prescribe an eye drop and I have to look up to see which manufacturer it is and whether or not they bought me dinner last year and have them sign a specific waiver for that specific medication for that specific company, that becomes burdensome.
Ms. Lawson, Bridget Grammy is saying she's willing to comment. If you'd like me to unmute her.
If Carrie nods and says that's okay, that I bring Bridget back. Yes.
Okay. Bridget, your line is open again.
Thank you. I do think it's, as Dan referenced from the author's office, that we are suggesting, you know, something that would administratively burdensome, but would still provide the patients with the information that they need. So it is more, as you described, it's how we're envisioning it. And I do think it is still in the details as far as how the language of the bill will end up. But I guess I can't speak for the author, but I can speak for myself as the sponsor. The intent is not to have it be as burdensome as Dr. Kraus described for each and every prescription, and then you have to look up in the database. It's, you know, it's really meant to just be informative for the patient so that they can look up that information for themselves.
Thanks, Bridget.
Ms. Lawson, this is Dr. Thorpe.
Please.
So under the analysis part of the document that we've been given on page 1 of AB 1278, it says, according to the Center for Public Interest Law, disclosure of financial conflicts of interest by doctors is a moral obligation not enforced by law, and I totally agree with that. AB 1270 would remedy this problem by mandating physician disclosure of any financial conflicts of interest, empowering patients to make better and more informed choices about their treatment. And I totally think that's a great, that's important, especially when you're talking about, you know, implants, major surgical procedures, those kind of things. But it says preceding any treatment, physicians would be required to explain their healthcare recommendation, the clinical evidence supporting it, as well as disclosing any financial ties they have to the drug or device manufacturer. And I personally, I'm thinking as a primary care doc, the most I have ever, I mean, we have the drug reps come by and they bring us lunch for the office once a week. And that doesn't necessarily influence me. I normally don't even remember who they are, what product they're bringing. I'm interested in the lunch. But the point is that if I have to go back and outline to every patient why I'm giving them lisinopril for their blood pressure, and that I talked to AstraZeneca about that medication or during a time when they gave me lunch, I mean, I think that is actually quite disruptive. It's a different story when you're doing a major surgical procedure or a major medical treatment, like a major hematology oncology medication that's extremely expensive. It's going to cost you $10,000 a month. That's a very different kind of conflict than the day-to-day use of medication, explaining why you're giving a cardiac medication for a patient, or an antihypertensive medication for a patient, or a diabetic medication for a patient, when it's really, yes, you need to explain it to them and go through that process, but to explain I mean, I think it could be onerous, yes.
Thanks, Dr. Thorpe. I think I'd like to articulate my position, which is I believe that the patients should have the choice to decide whether or not they believe something could or did influence their physician in making that recommendation. I am concerned about the idea that a physician in the midst of an appointment, and I am thinking about it from, you know, the perspective of my own interactions with physicians, I wouldn't want the physician to be prescribing me medication for migraines, for example, and have to run out and think through and search their database and then come back and interrupt the patient physician relationship in that way to go figure it out and come back with an individualized disclosure form. To the extent there's something that can be provided, which I heard the chief of staff for the author indicate that was their intent, that it's provided at the outset of the visit, and perhaps it has a list of the companies, or perhaps it's just providing a real easy way for a patient to understand how to get the data for themselves so they can make an informed choice. They can decide whether they believe the turkey sandwich influenced their physician or not. That seems to me to make sense. But the idea, you know, the example Dr. Krause articulated about eye drops and having to even make the connection between, was I at the lunch for this one or for that one, and then leave and come back with a form, just doesn't seem to me to make a lot of sense.
Dr. Hawkins, may I speak?
Please.
Go ahead.
So Hawkins, I'm sorry. So I imagine I would query myself. I'd have my own printout. I'd be able to review that and see what it is that I'm prescribing and what appears on that form. I want to make a motion to support.
I'd like to second that. If I may comment as well, I don't know if I agree with the characterization that the intent was for doctors to be in the moment in real time, going in and figuring out how to fill out a form. When I went through my confirmation hearing yesterday, things that I said that I was going to bring to the table in my experience on the board was my experience as a patient. And I have 2 metal rods on either side of my spine because of an advanced surgery for scoliosis. I have implants because of breast cancer. Like, there's a lot of us that have to really rely on the impartial judgment of doctors and how it is that they treat our bodies when we are completely vulnerable in their hands. And if my doctor told me, hey, I have a relationship with Mentor implants, that would not make me not trust my doctor. I'd say, okay, well, why? Because I trust my doctor. And if they say those are the best implants, then I would say, okay, that makes sense. So I actually think, again, this is about transparency. It's about trust, and that this bill that I agree we should approve wholeheartedly is at the center of the reason we're here, which is patient protection and transparency and patient empowerment, frankly.
Okay, that's
So Christina, so I have absolutely no problem with the intent of the bill. I think it's a great intent. What worries me is the way what the Chief of Staff explained is absolutely okay with me, but what Aaron is reading is not okay with me, because it does create a lot of problems for simple things. I use this word not just once, multiple times, because I do train residents. They do get lunches sometimes. And so what happens if they are the ones in the resident clinic, they're seeing, how are we going to implement? So that's why I would rather have this bill cleaned up. And I have no problem if what he's asking is, if we just have to stick a notice that this is where the website is, you can see, well, if this doctor got any money from them, or for any drugs or any devices he or she is putting in. And I have absolutely no problem completely prohibiting doctors if they privately own a company and they want to use that equipment. So this is, I'm still confused what I heard from the author's chief of staff to what I'm hearing from my own people, and the description is, there's a lot of discrepancy.
All right, thanks, Steph, for those comments. I think I'm going to call the question. We have a motion by Dr. Hawkins and a second by Ms. Campaverde on the table.
so you're going to call the question to limit the discussion.
Oh, is there any further discussion?
That would be it.
What I would like to comment is I do support disclosure of the variety that was offered by the Chief of Staff. And if we could have this a support, if amended, to allow a front office signed disclosure that wouldn't interfere with the direct patient-physician relationship, I'd be much more comfortable with that.
So it's for you. So I understand the intent. I'm in support of this bill, but so is it everything a particular drug maker makes or pharmaceutical company makes? So most of them making multiple products, from eye drops to ear drops to lip balm. And so would you have to disclose the intent of the bill for disclose every particular drug? I'm unclear.
So to respond to Mr. Brooks' question, is that the disclosure requirement is triggered when the physician receives a payment or remuneration from the company. So that's when the requirement occurs.
So, but when you say look at payment, some people are incentivized, some wristbands or whatever it may be. If I'm getting paid to, push those, I have to disclose it. When you were saying if I went out to dinner, is that considered a payment for a particular company's products?
I'm sorry, could you repeat the question, sir?
So if I'm getting paid direct to push whatever product, that's definitely disclosure, right? I have a final interest in that. But if I'm a doctor and I meet with, say, Pfizer or any other, Merck, and they have multiple drugs, do I have to disclose every single drug under their
Yeah.
verbally in the office?
The disclosure requirement occurs if you are going to issue a prescription, or you intend for your patient to use any drug or device manufactured or distributed by the company.
May I help, Ms. Lawson?
Yeah.
Please.
I think there's two ways of doing this. One is particular to each patient based on what you're going to recommend as far as a drug or a device. I think the other option is that you prepare ahead of time a disclosure list that covers all of the compensation that you've received from the pharmaceutical and device manufacturers or distributors, and that you do ahead of time. So I think that would be less burdensome, but you have the option for this particular patient, you're making this disclosure. If you're using a drug or device from a company from which you've received compensation for.
I'm so confused about this. Something is not right.
Well, this is TJ. I think what we are going on about one very important thing. Well, let's separate it out. We are talking about patient protection via disclosure. That's one, that's the big piece. And then we're talking about doctor administration function, right? Now, if, like Carrie just mentioned, if the doctors, they'll figure it out. They'll figure it out. The bigger thing that we are here for is for that patient protection component. And I think that once they realize that the front staff can put a generic document together to raise a conversation, then we end this. And then this is not a big deal. Otherwise, we're going to go through this another 100 times trying to figure out scenarios after scenario after scenario. We agree in principle that this is the right thing to do.
And I would agree with that. And I already figured I'd adopt the approach that Carrie mentioned. Go in there, print the paper out, and we'll deal with it. I think you should call the vote.
So to clarify, the motion is just support. Is that what I understand, Madam President?
That's my understanding of Dr. Hawkins' motion, and my understanding from him requesting we call the vote is that he doesn't wish to amend his motion based on the comments he's heard. Is that correct, Dr. Hawkins?
Correct.
Can you phrase your motion again, Dr. Hawkins?
Just support.
The motion on the table is a support position for the bill as drafted.
Ms. Lawson, this is Dick Thorpe again. I would just say that this bill is very prescriptive. Very prescriptive.
Dr. Thorpe, I mean, I appreciate your comments, but I think we're now at the point where we're going around and around and around, right? We're making the same comments over and over again. Are we okay with calling the question? All right, let's proceed.
Vote.
Call the roll.
Mr. Brooks.
Yes.
Ms. Kilpavarty.
Aye.
Dr. Bonadev.
Abstain.
Dr. Hawkins.
Yes.
Dr. Kraus.
No.
Ms. Lawson.
Yes.
Ms. Ljubljana.
Yes.
Dr. Lewis.
Aye.
Dr. Mahmood.
Yes.
Dr. Thorpe.
No.
Mr. Watkins.
Aye.
Dr. Yep.
Yes.
Thank you.
By my count, I think that motion carried, but I don't know for sure.
I counted 9 ayes.
Yes, it did.
Yes.
The motion carried. Thank you. All right, moving on to the next bill.
We're halfway there, Madam President. All right, the next one is Senate Bill, sorry, Senate Bill 48. Would require all general internists and family physicians to complete at least 4 hours of continuing medical education, or CME, during each 2-year renewal cycle. This bill is sponsored by the Alzheimer's Association. Current board regulations require physicians to complete at least 50 hours of CME every 2 years. In addition, under current law, general internists and family physicians for whom more than 25% of their practice includes patients 65 years of age or older
they are required to complete 20% of their CME in the fields of geriatric medicine or the care of older patients. The author and sponsor believe that the current requirements are insufficient to prepare primary care physicians for the current and future expected needs for those at risk for dementia. At the board's prior meeting, you did not take a position, but instead directed staff to send a letter of concern, and that letter is outlined in the analysis. I've engaged in numerous conversations with the sponsors on the bill who are sympathetic to the concerns of the board and other organizations. However, to date, the bill has not yet been amended to address those concerns. Accordingly, staff recommend an oppose unless amended position, requesting the bill be amended to encourage but not require those physicians who are general internists and family physicians and have a significant population of patients 65 or older to take CME in the special needs of patients with dementia care. I will turn it back to the board for discussion and a possible motion.
Aaron, I would support if amended, but I have a greater general concern about CME in general. And this derives from what I experienced personally when I did my 12 hours of mandated CME on pain relief, and later discovered that most of the experts who were giving us our CME courses were paid consultants by Purdue Pharma and telling us things that were not accurate. And similarly, I have a concern here that Alzheimer's drugs and products are a multi-billion-dollar business. And as soon as we have mandated CME, those companies will hire consulting physicians to subliminally peddle their products. So I would want to see an amendment that would indicate that the CME meeting organizer and presenters should not be in receipt of funding directly from corporations deriving revenue from the sale of products or services to dementia or Alzheimer's patients or their families or caretakers. And I think that that would be good law in general for CME that's approved in this state to assure that doctors are not being lied to or given subliminal messages to promote the sale of products of dubious value.
Got a motion, Howard?
Yeah, support if amended, and if the group likes the amendment, I'm happy to read the language again and slower.
Second.
Can we have a discussion? I know I'm glad that we already have a motion. And why are you bringing this up again when it was not amended? Our position was opposed unless amended.
Oh, no. My support if amended is with the original amendments and this in addition.
What?
Got it.
I agree with you, Dev. We can't support it because it's not been amended. But in addition to the original amendments we requested, I would request an amendment that gave us some security that there was no conflict of interest in the purveyors of the CME.
So the board did not request amendments at the prior meeting. The board did not take a position, and the board directed staff to write a letter of concern. That letters delivered some weeks, long time ago, and had numerous conversations with the sponsors of the bill. Does that help, Dr. Garnadev?
Yeah, it does, and it doesn't take my second concern away. That is that till now, mandated CME, only thing it did is harm patients. One big example is pain management. Opioid crisis started after mandated CME was put on, and like Dr. Cross mentioned, a lot of stuff they made the pain as the sixth vital signs and pushed on the opioids, including saying that they're not addictive drugs. So it just worries me whenever we mandate something what the private industry does.
So
let me say I misspoke at first when I said support if amended. I had forgotten that we were opposed unless amended. So yes, it would still be opposed unless amended, but I would want to add the origin of the CME to our requested amendment.
So, okay. So just to clarify,
what the amendment that I'm suggesting in the analysis is that it would not make it mandatory. Rather, it would allow the physicians who are already subject to the CME requirement for geriatric medicine and the care of older patients to add as a third option for them to satisfy their 10-hour requirement. The third option would be on dementia care. So that would not be prescriptive. It would instead be optional for them to satisfy this 10-hour requirement, moving from two options, geriatric medicine or the care of older patients, and I'm reading on page 5 of the analysis, and they would add a third option to be dementia care.
I think the one other issue is that, which is very concerning to me, is that the money flowing from these companies who make these drugs to the people who put the CME on. So I think it's also very important for public protection and everybody's protection that those CME programs should not be funded by the companies which make the drugs for treatment of dementia.
So one item, and maybe Ms. Webb may be able to help me out with this, but one item that just occurred to me is that if we put the prohibition, and I apologize, Dr. Cross, couldn't write it down quickly enough, but if we do put in this prohibition about payments to the source of the CME providers, that might create a requirement for board staff when they're reviewing and whether or not CME is going to be acceptable. They would have to potentially review and get access to the kind of information about the CME provider, and that might put staff in a challenging spot to verify that type of information.
Agreed.
That is true. That is a concern, but I think it's still a very important point, and something that if this is going to go forward, this has to be a safeguard, because for all the reasons already stated, that it can harm patients when the providers of CME have a financial interest.
We could ask for an attestation from the CME provider and the presenters that they have no financial interest.
Yeah, Howard, that only works if the CME provider is in California. We have no authority over out of state.
Oh, no, I understand.
Should we open up for public comment? All right, let's do that.
Hey everybody, I'm opening up the public comment window and the raise hand functionality. If you'd like to make a public comment on this agenda item, please do either of those and we'll call on you in the order received. First up, we have Hannah Ree. Hannah, go ahead.
Yes, hello, Hannah Ree of Black Patients Matter. So I guess I would have to conclude that I wouldn't be doing my job if I didn't have the Patient Safety League attacking me. So it's kind of ironic that we're advocating for patients and we get attacked by the Patient Safety League, but who knows what's behind that. But that's okay. Here at Black Patients Matter, we are used
Ms. Reed, do you have a comment on point on SB 48?
Oh, SB 48 is acceptable. Thank you.
Thank you for your public comment. Next up, we have Katrina Reyes. Can you go ahead?
Thank you. Good evening, board members. Katrina Reyes with the California Academy of Family Physicians. CFP has an opposed unless amended position on SB 48. Continuing medical education curriculum should be developed by demonstrated clinical need and research, not dictated by statute. The CAFP shares the author's goal of ensuring that patients suffering from Alzheimer's and dementia receive appropriate and timely care. SB 48 will not achieve this goal as currently drafted. We appreciate the analysis done by the medical board staff and the alternative options presented. We are working closely with CMA, medical board staff, the sponsors, and the author's office to amend the bill so that it better achieves the intended goals. Thank you.
Thank you for your public comment. Next up, we have Virginia Farr. Virginia, are you there?
I agree with the bill. I believe that when the CME people apply, they should disclose what disclose where their sources come from. I also am really concerned about not hearing Dr. Thorpe out, because with workflow, you're adding stress to a stress system and going to risk patient safety by this Disclosure Act. I agree with the Disclosure Act, but I think it needs to be amended. And I really wish Dr. Thorpe was heard out. So thank you.
Thank you for your public comment. At this time, I do not see any additional requests in queue. Oh, sorry, one more just came in. Susan Lauren, go ahead.
Yeah, I agree with what Dr. Kraus said. Thank you.
Okay. Thank you very much. That's all I see in the queue now.
All right, we'll bring it back to the board. I'm not sure, do we have a motion from Dr. Kraus on the table?
My motion should have been stated as an oppose unless amended. And the amendment would include those things that we had previously discussed, with it being a option but not a requirement. And I added the amendment that a CMA purveyor and the presenters should not receive funding from corporations deriving revenue from the sale of products or services to dementia or Alzheimer's patients or their families or caretakers.
I'm sorry, Doctor, I'm trying to write as quickly as I can. Could you one more time, please?
I'm happy to text it to you, but basically the CME meeting purveyors nor presenters should not receive funding from corporations deriving revenue from sale of products or services to dementia or Alzheimer's patients or their families or caretakers.
Thank you.
Question, Howard. Does that mean that the person who's conducting that lecture can't be on a speaker program?
That if it's a funded speaker program, I would be against that, because that's what happened to us with Purdue Pharma.
Second.
All right, we have a motion and a second. Is there any further discussion? All right, seeing none, let's move to call the roll.
Mr. Brooks.
Abstain.
Ms. Campoferti.
Aye.
Dr. Bonadev.
Yes.
Dr. Hawkins.
Yes.
Dr. Kraus.
Yes.
Ms. Lawson.
Aye.
Ms. Lubiano.
Yes.
Dr. Lewis.
Aye.
Dr. Mahmood.
Yes.
Dr. Thorpe.
Aye.
Mr. Watkins.
Aye.
Dr. Yip.
Aye.
I'm still on meeting. I'll find out.
I'd like to just pause before we move on to the next and ask Carrie, from a legal perspective with respect to our agenda. I mean, we represented, I guess, on our agenda that we were going to end at 5:30. It's now almost 8:30, 3 hours later. I've been watching the participant list just drop from about 70 participants to less than 40, which means most of the members of the public have fallen off. And I'm extremely concerned about that, with us going over what our published agenda said. And so I guess my question is, can we table the remainder of the items until tomorrow? Then I'm concerned also about what happens with our agenda for tomorrow, which itself says it will end at 2 p.m. and what we can do, or what flexibility we have in these published agendas to either make revisions so that we can address the items we need to address, but also be respectful of the public and our board members' schedules.
It is okay that you end the meeting if you so desire at this time and take the rest of the items tomorrow, if that's the will of the board. At least people will be aware and they can come back and tomorrow and make comments. It is easier too, since people aren't having to travel and so they can still participate. With regard to tomorrow, and I'm sorry I'm talking funny, I hear an echo. But anyway, you on the items that don't require a vote, so just the update items, you can not take those for discussion tomorrow if that's what you want in order to control the time.
Okay. I guess one question is, if we have attendees that have been waiting until 8 p.m. tonight to comment, and there's a particular bill, we should probably take them tonight because they've been on the line this long. I don't know. Is there a way, Sean, for you to have them put in the Q&A what item they're here for? We have 3 more bills and then 4 regulatory actions on the agenda. So 7 items total.
I could open the Q&A and let people respond in there, you know, if they're planning on speaking on any of the topics.
Is there a way for them to put it in a chat, or no, we'd have to activate their lines?
Well, no, in the Q&A, if the remaining public individuals are interested in speaking in a particular item this evening, go ahead and send me that item number in the Q&A. So yeah, we got one here saying that they've been waiting for 6 hours to talk about SB 310. One saying SB 528.
All right, let's keep going with these bills.
Oh, I have one question, Carrie. Could you ever start earlier on Friday, like a half hour, or is that not permitted?
Well, I won't be here.
Oh, you won't be here anyway, so forget.
No, I won't be here 30 minutes early, but I'll be here at the prescribed time.
Okay, got it. Sorry. Yeah, just asked.
Let's go ahead and proceed with these. There are people who've been waiting for 6 hours, so we should
Can we take
allow them.
those 2 rather than the rest? Otherwise, your board members will be dropping off too. So there are 2 items he mentioned. I don't have any problem. 310 and what is the other one you mentioned? We can take, but the regulatory items, can we take them tomorrow?
Deb, you can't hear you. You need to speak close to the microphone. Thank you.
Sure. I think the day is getting to me. So what I'm asking is that can we take the 2 items people are waiting for hours, and the rest we can take them tomorrow?
Perhaps, but let's make sure in the chat that there's no one that's been here for those items.
The only 2 items that have been brought up in the Q&A are SB 310 and SB 528.
Okay, let's start with those.
So there's one additional bill that we would then take tomorrow. Senate Bill 57 would happen tomorrow. Is that the direction?
I guess.
Okay, great. Senate Bill 310 requires the board to administer a program that allows for the donation and redistribution of cancer medication between patients of a participating physician who is registered with the board. The author and sponsor note the great challenges that patients may face as they seek appropriate medications to treat their cancer. As some medications are not well tolerated by all patients, there may exist an excess of unused medications that they believe are safe and certain conditions to redistribute to other patients. This may lead to great financial difficulties for those patients involved as they continually look for appropriate medications for them. The analysis notes consumer concerns relating to medication integrity pertaining to the safety of redistributed medications and liability risks that may be shifted to recipient patients. Further, it is unclear why the board is the appropriate entity to carry forth this program, given that this is not a licensing or a disciplinary process. Finally, the bill is likely to exacerbate the board's current financial challenges. In light of these concerns, Madam President, staff recommend an opposed position. I'm happy to bring it back to the board for discussion.
So Aaron, does federal law allow it? Number one. Number two is, does pharmacy board allow it?
Pharmacy board does not allow it. The pharmacy board opposed a similar bill in a previous year, I believe 2 years ago. And under federal law, I'm not well versed on federal law. I do understand that there is an advocate on behalf of the sponsor who will be speaking. And I understand that this is allowable. This does happen in certain other states. There is an underutilized cancer medication, an underutilized program that counties are able to opt into, but I understand that has a very low adoption rate. But in terms of this type of a program being run by a state licensing board here in California, that would be a first to my understanding here in California. And I would just note as well, in the states, in my research, in the states that do administer this, I haven't yet found a medical board that runs this program. Sometimes that state's equivalent of the Department of Public Health, sometimes a pharmacy board, sometimes there's public-private partnerships. So different states, handle it in different ways.
Yeah, I agree that this program is of value, but should not be done via the medical board or at medical board expense. So therefore, I would oppose.
I'll second the oppose.
And I would just.
I'd love to hear from the advocate, because I think this program sounds incredible, well needed, and a huge public good. And so I'd like to hear more about how this would necessarily be administered, because I guess I'm confused why that would be the medical board.
I agree.
Ms. Lawson, we can't quite hear you.
Oh, she's probably
sorry. I just said let's go to the public. I'm sorry.
Okay, we have the Q&A window and the hand raising function activated. First up, I have Autumn Ogden Smith. Autumn, are you there?
Yes. Hello. Can you hear me?
Yes.
Okay, great. Thank you so much. And thank you all for taking the extra few minutes to hear this tonight. I know it's been a long night, and I'm Autumn Ogden Smith. I'm with the American Cancer Society Cancer Action Network. And we are a co-sponsor of this bill. We've been working closely with Aaron to try to figure out what would be amenable and to lower costs. We do understand your cost concerns. And as Aaron mentioned, so out of 38 states that have some sort of drug recycling program, 12 of them focus on cancer medications. And as Aaron noted, it is different in every state. There's not one entity that consistently oversees. We thought the medical board would be the appropriate place because it is with the oncologists. And so we thought that the medical board would, overseeing doctors would be an appropriate place here. We are open to the discussion and how that can work. And also we have talked about capping the number of participants to reduce cost. Again, we do know that that is a concern. And I believe there was something else you brought up, and I think I'm a little lost in my notes at this time, at this late hour, but I'm open to answering questions directly.
Is there additional public comment?
Yes, up next we have Hannah Ree. Hannah Ree, go ahead.
Yes, Hannah Ree, Black Patients Matter. This sounds like a possibly a great idea, but as a patient advocate, I would wonder whether or not there would be disclosure to the patient that they're receiving a medication that was, from a bottle of some sort that was previously opened or partially used. So I just wonder if that would be disclosed to the patient. Thank you.
Okay, thank you for the public comment. At this time, I don't see any additional requests.
Thank you. We'll bring it back to the board.
Just want to add that in my,
I'm sorry. Go ahead, Ellen.
I was just going to add that in my reading of the bill that all the vials or bottles would be unopened and unused. So just adding that context. I understand the concern about the cost and the administration by the board. Again, I think this is an incredible program, and for this drugs, these like very valuable cancer drugs that are out of reach for a lot of patients to be wasted, it would be such a loss. I'm curious, it sounds like the caller would be open to a conversation about how this might work. So I'd be interested in seeing if there was a way to amend this.
And I'm just curious on how the actually program itself works. And say if I have, 5 doses of unused cancer medicine that's extremely expensive, because the medication typically is, they find a patient who needs, say, 10 doses, but there's not 10 doses. Then, like, what happens? Does the patient then have to go to a different drug, or this goes without, or do they just there's more medicine? How does that work? I'm curious.
So I think some of the answers to your questions, Mr. Brooks, would probably have to be resolved through a rulemaking that the board would most likely have to do in order to set up all the different structures and answer some of those questions that you've raised. To Ms. Campoverde's comment a moment ago, she's correct that medicine would have to be unused. It would have to be inspected by the physician and determine that the drugs are unaltered, safe, and suitable for distribution, and meet certain requirements. Tamper-resistant packaging has to be unopened and intact. They'd have to do some inspections of the medicine itself. So it does include those kinds of requirements, but I believe additional requirements would be up to the board to pursue through a rulemaking.
This is a worthy endeavor, but I have to protest. It's not a physician practice. It's a pharmaceutical practice. It's a Department of Public Health practice. And to land this on the medical board because the pharmacy department had nothing to do with it or would have nothing to do with it, I think it's still inappropriate. The medical board is not the correct venue, and physicians are not the correct professionals to be verifying the purity and quality of returned medication. It should be pharmaceutical board or Department of Public Health.
Can I make a comment?
Please.
So the other important factor on this is those unused medication, how they would pick the patients, and would they use this for their financial benefit? Like they are like double billing patient who was supposed to be used and cannot be used, and now next patient there will be double billing. And are they going to be moving from that clinic to different area? Can you hear me?
Yes.
Yeah.
The bill speaks to a requirement that the physician must already have a relationship with the patient. And I believe the explicit purpose is to help patients who are unable to afford, some of these, very expensive medications. Double billing, I couldn't speak to that, Doctor.
Yeah, but these are the rare medicines, and what is the guarantee that there'll be another patient there? And we might be very few cases when there will be another candidate for the drug is going to be available in a certain amount of time, because once this drug is dispensed, it has to be used in very certain specific time. So I think this is more in the scope of pharmacy than medical board, but still there are a lot of caveats on this thing that they just open it and use another person and kind of stuff, and then people be using, I think this drug might be abused, or there might be some financial benefit or somebody must be behind it. But I think this is more in the scope of pharmacy board than medical board, because the drug is not like kind of treatment, it's already tendered that this drug is going to be treated. So I will oppose it.
If the board believes and agrees that the medical board is not the right entity for this to live under, I think there's two different issues, which is this something we want to support as a board if it lives somewhere else, you know? And I think that there is a conversation introduced that, you know, if the sponsors of this bill decide to amend this so that it doesn't necessarily live under the medical board, say it does go to the pharmaceutical board, say it goes somewhere else, but I'd argue that maybe we could support if amended to not be within the jurisdiction of the medical board, if that's how people feel that it shouldn't be here. But I do think that this is potentially life-saving and very positive bill that we should support.
Yeah, I think that language.
Yeah, and I'm with you. I think this is an incredible program. There's so many people out there who can't afford these types of drugs and medicines, and they shouldn't have to go to waste. But this is a distribution issue and not a medical board issue. And so if you were to make that motion, I would.
So Dev. Okay.
So I'll withdraw my oppose if Ms. Campoverde would like to rephrase a support if amended position.
Yes, I'd like to move to support if amended. I don't know what the right language is here, Aaron, but to consider another.
So to clarify, is it that does the board support every aspect of the bill with the exception of who administers the program? Because that would be in essence what we would be saying if it was support if amended, except, you know, go find somebody else to run the program. So I wanted to clarify, was that your intent, Ms. Campoverde?
Yes, not in the go find someone else to run the program language, but yes.
Right, yeah. Yeah,
The question is about whether the medical board is the appropriate entity to administer this program. And so does the board support this bill? And what I'm saying is I suggest that we do support this bill. If the medical board is not the appropriate place, then, you know, that we leave it to the sponsors to address, but I do move that we support something like that. I personally donated medication myself and had donated medication offered to me. People who especially are in the cancer space, this is something that is actively needed and utilized, and especially in communities of color. So I think this would be something that would be a great public good.
One comment I wanted to add is that if that was the adopted position, support if amended, in case if the author and sponsor did not amend the bill and simply left it as the board, that the board would have no position on the bill other than support if amended. And so if it got to the point where they continued to move the bill through and down to the governor's office, the board would not have directed staff to then seek a veto or do anything else to stop the bill based upon a support if amended position.
So Aaron, you're suggesting we're better off accomplishing this by an oppose unless amended.
That does preserve more opportunity for the board if it becomes clear at some point that they're not able to find another home for the program. That would then give us the opportunity to pursue every option to then at that point stop the bill.
So can you support that, Ms. Campoverde, oppose unless amended to find another home other than the medical board?
I will not make that motion, so I will withdraw my motion. That's what
So
people.
then I will move to oppose unless amended to find a board or state organization other than the medical board to supervise the program.
Okay, I'll second that, Howard. I agree. Second it.
All right, we have a motion by Dr. Kraus, a second by Dr. Lewis. Is there any further discussion on this bill? I think we also need to reflect on the record that I think we lost Dr. Gananadev due to some connectivity issues.
Yes, he messaged me that he was having some difficulty.
Where he lives, they pull the sidewalks in after 8:30.
Is there, so there's no further discussion, so let's move on to a roll call vote.
Mr. Brooks,
Yes.
Ms. Campoverde,
No.
Dr. Gonadev. Oh, sorry, Dr. Hawkins,
Yes.
Dr. Kraus,
Yes.
Ms. Lawson,
Yes.
Ms. Lubiano,
Yes.
Dr. Lewis,
Aye.
Dr. Mahmood,
Yes.
Dr. Thorpe,
Yes.
Mr. Watkins,
Aye.
Dr. Yip.
Aye.
Thank you.
Thank you. So I think we had one more
Yes, Madam President.
SB 528.
I think this will be briefer. This bill requires the Department of Social Services to create an electronic healthcare portal through which care providers will be able to access health information included in a foster child's health and education summary as provided in law. The portal must also include completed and approved forms developed by the Judicial Council relating to the administration of psychotropic medication for specified dependent children in wards of the juvenile court. This program is expected to support continuity of care for this vulnerable patient population, and it may ease the board's access to medical records necessary to investigate possible violations of the Medical Practice Act with regard to children in foster care. For these reasons, staff recommend a support position. I'm happy to answer any questions.
Okay, I move to support this bill.
Second.
I second.
Sorry, who was the seconder? Dr. Lewis with the motion.
Alejandra.
Yeah.
Thank you. All right, is there any discussion? All right, I think we have a public commenter though who's hoping to speak on this.
Yes, the public comment window is open for anyone wishing to do so or raise your hand. But first up, we have Brixton Lane. Oh, who just disappeared? Okay, there we go.
Brixton Lane, your mic is open. Hi, thank you for allowing me to speak and for taking this item up tonight. I know you've all had a long day. This is Brixton Lane from the office of Senator Brian Jones, the author of this bill. I wanted to make myself available for questions and request your support for SB 528. Thank you.
Okay, thank you for your public comment. Next up, we have Hannah Ree. Hannah, go ahead.
Yes, hello, Hannah Ree of Black Patients Matter. It sounds like it's a good idea, but the devil's in the details. So I probably want to hear more about what's included. But overall, it sounds like a good idea. Thank you.
Thank you for your public comment. At this time, I don't see any additional requests.
We'll bring it back to the board. We do have a motion by Dr. Lewis, a second by Ms. Campoverde. Is there any further discussion? All right, seeing none, we'll go to the roll call vote.
Mr. Brooks,
Yes.
Ms. Campoverde,
Aye.
Dr. Hawkins,
Yes.
Dr. Kraus,
Yes.
Ms. Lawson,
Yes.
Ms. Lubiano,
Yes.
Dr. Lewis,
Aye.
Dr. Mahmood,
Yes.
Dr. Thorpe,
Yes.
Mr. Watkins,
Aye.
Dr. Yip.
Aye.
All right, the motion carries. So I think we're going to recess for the evening. Tomorrow we'll take up SB 57, if I have that right, Aaron, and then the regulatory actions under agenda item 10.
Yes, ma'am.
And then we'll start with the other items on our agenda for tomorrow. So thank you all for hanging in there this evening. Thanks particularly to all of the medical board staff, including all of the folks who are behind the scenes and not necessarily visible on our screen too, who are doing the hard work to make sure this meeting is running well. So thank you, and we'll see you all tomorrow at 9 a.m.
Thank you.
And have a good evening, everyone.
Thank you.